Loudly and clearly into the microphone.
Yes, sir.
Good morning.
Good morning.
Can you please introduce yourself to the jury?
Hi, I'm Investigator Brittany Abel with the Tallahassee Police Department.
All right, and how long have you worked with the Tallahassee Police Department?
Approximately 13 years.
And what, what position are you in?
Currently, I'm an investigator with the Criminal Intelligence Unit.
How long have you been an investigator with the Criminal Intelligence Unit?
Approximately a year.
A year, okay. Were you the lead detective on this case or investigator on this case?
Yes, I was.
And what are some of your duties as the lead investigator on a case, just generally?
Patrol responds to a case and they complete their report, then I would be assigned it if it meets our criteria in the Violent Crimes Unit.
Okay. And then in this case, just walk us through how did you get onto this case?
I was assigned the case.
Okay. And what did you do upon being assigned the case?
The first thing the most important thing was to obtain the surveillance video, was my first task.
Okay. Let me just ask you this really quickly before we get into what you did. What happens in an investigation when a witness cannot identify the suspect and there's not an arrest made on the scene?
That's what, if there's further follow-up to be completed, that's when I would be assigned the case to obtain surveillance video, talk to witnesses, so on.
Got it. So is that why you were assigned to this
Yes,
case?
ma'am. Yes,
Okay.
ma'am.
Got it. All right. So surveillance video. So do you go to Circle K to get the surveillance?
Yes, I do.
Okay. Upon getting there, did you verify the time on the surveillance?
I did on the current system they had, and I recognized that it was 36 minutes off at the time.
Okay. And how were you able to recognize that the time was off?
Because it's just common for investigators to check that because it happens often that systems are off within stores. So we check what the current time is versus the system time. So that's when I noticed, I think it was 36 minutes fast.
Okay. So if we see a time on the surveillance that says like 1 a.m.,
right,
based on your investigation, what time would it have actually been?
It was approximately like 12:30 a.m.
All right. Do you know what time the 911 call was made in this case?
Yes, it was at 12:34 a.m. on October 4th, 2019.
Okay. And what time, or do you know what time the first officer arrived on scene in this case?
Officer Bartholomew arrived at 12:48 a.m.
Say it one more time.
Officer Bartholomew arrived at 12:48
So about
a.m.
10 minutes later, roughly?
Objection. Counsel testifying. Please ask the questions to the witness, Ms. James.
Is that about 10 minutes later, roughly?
14 minutes to be
14.
exact.
Got it. All right. The body camera, I want to talk about that and the time at the top of that. Is the time at the top of the body camera an accurate time?
Yes, it's accurate.
What time zone or?
It's UTC time or Zulu time. And that's usually 4 to 5 hours off based on daylight savings time.
Okay. So that time would that time not be accurate based on the time zone?
It's accurate as a universal time, but as far as what time it was in Tallahassee, yes, it was, I believe, 4 hours or fast.
Okay. So based on your investigation, I just want to make this clear. Based on your investigation, what time frame are we dealing with in this case?
12:30 a.m.
Okay. What time did the call end on this case?
I believe the Officer Bartholomew cleared the scene about 1:20 a.m. based on dispatch.
Okay, so you just testified, you believe it started.
Counsel's testifying. James, please rephrase, Ms. James.
Did you just testify?
Objection. Counsel's testifying. The rule, she can finish her question.
Did you just testify about what time it started? What time the call came in?
Yes.
Okay, and what time was that?
12:34 a.m.
Okay, and what time did the call end?
1:20 a.m.
Okay, so that would that be our time frame for
Yes,
the
ma'am.
call?
Yes, ma'am.
All righty, I want to move into your investigation now. So you told us already that you got the surveillance footage, then what do you do?
I obviously try to identify the suspect in the video.
And how do you go about that?
I took photos from the surveillance video and released them to our police department social media pages.
Okay, and through investigative means, were you able to identify who the suspect was?
Yes, ma'am.
And who did you identify that person as?
The defendant?
Would that be Chase Morris?
Yes, ma'am.
Do you see Chase Morris sitting in the courtroom today?
I do, over here in the black suit, gray tie.
Let the record reflect that the witness has identified the defendant.
The record shall reflect.
All right, so what else, if anything, did you do to investigate this case?
I did follow-up interviews with the victim, witnesses, took photographs, reviewed body cam.
Did you conduct a photo lineup with the victim?
Yes, I did.
And please refer to Mr. Thompson.
Yes, I showed Mr. Thompson a photo lineup.
Okay, and who is the victim in this case?
Tola Thompson.
Okay, all right, so when did you show Mr. Thompson that photo lineup?
October 25th, 2019.
And when did this incident happen?
October 4th.
In your interview with Mr. Thompson, was he able to make an identification?
He was not.
Did he make any comments to you about the photo lineup or the identification?
I did not administer the photo lineup, but I was told that he was unable to make a identification.
When you were interviewing Mr. Thompson, can you tell us what was his demeanor when you were interviewing him?
He's a just very calm and collected individual.
Did Mr. Thompson bring anything to the interview with you?
Yes, he brought his medical paperwork.
Did Mr. Thompson give you, I don't know, any problems when you were trying to interview him?
No, ma'am.
Did it appear to you that Mr. Thompson had any memory issues?
No, ma'am.
Throughout your investigation, did you learn anything or have anything pointing to Mr. Thompson being under the influence of anything at all?
No, ma'am.
And through your investigation, did you ultimately learn that it was Chase Morris that had struck Tola Thompson?
Yes, I did.
Overruled.
And was Chase Morris ultimately arrested for this case?
Yes, ma'am.
And on what day was that?
November 1st, 2019.
May I approach the witness, Judge?
You may.
Investigator Morris, if you could look at that disc for me. Do you recognize that disc?
I do.
And what do you recognize that as?
It's my follow-up interview with Mr. Thompson.
And is that the interview you just told us a little bit about?
Yes, ma'am.
And how do you know that that's what's on that disc?
It's a disc I reviewed and initialed.
When you reviewed that disc, did it appear to be edited or altered in any way?
No, ma'am. It was our full interview.
Okay. Did it appear to be an accurate depiction of what you sort of just told us about and what you remember?
Yes, ma'am.
Okay. At this time, state would enter into evidence. State 9, right?
Any objection as to states 9? States 9 will be admitted.
Permission to publish?
You may.
May I approach the witness, sir?
You may. Members of the jury, please give your attention to your screens as Ms. James is going to publish the next video.
Oh, cannot see. There we go. There we go. Is everybody able to see it, Judge?
Yes.
Okay. And they'll be starting in just a second, Judge. It just, they weren't in the room yet, so that's why it's black on the screen.
It's got an automatic light in it.
Yeah, it does. I'm just gonna see if I can help us out a little here. There we go.
Judge, no objection to the state helping us out here.
Very good.
If you don't mind, you can see here. I got a whole team already. Let me grab my case and my notepad. Okay. You need anything more? Once again, thanks for coming out. I have a couple questions. Going over the report, the officer briefly just said that, let's see that one, exchanged words with them beforehand. Can we go into a little more detail, like how was he acting, what was he saying? Can you tell me a little more about it? Because it's very just like broad. And
I'm gonna turn it down just a little bit, Judge, if that's okay. It's just really
Yeah,
loud.
your audio is a little hot.
Was, yeah. Let's see. I went to the gas station. I was on my way home. I was a family homecoming weekend. I said, well, let me get some gas before homecoming gets going and their town is really crowded. So let me stop here, get some gas. So I stopped to get some gas. I was at the pump. These folks came out of the gas, out of the store, very loud, making noise. And then this guy, when he got in the car, and the guy came over to me.
Like, why?
And so, and then we started, he's like, we started exchanging words, and he was got in my face, and I was like, look, not tonight, not tonight. I just wanted to see that. I was like, just trying to de-escalate it.
What was he saying? Like, can you tell me anything? Like, did you know he wanted to fight when he came over? Or just help me understand that part a little bit.
Right. They came, like I said, they came out making noise, very loud noise. They were very loud, and I said, "Can y'all just turn it down?" And then
Is that while he's at the store, or is he almost to you at that point?
I don't know where he was at it because I was at the gas pump.
Okay.
I'm at the second gas pump, of the gas pump from the street.
Yeah.
And so he, like I said, I guess his reaction to me saying, "Bring it down, can you all be quiet?" Led to him coming directly to me around the pump and out of the store to the pump.
Okay. Was anything said at the pumps?
Yes.
As far as,
Yes, it's like, you got something to say, you got, and I'm like, really? I'm like
you said,
not just go away from, please go away from here, just not tonight, just go away from here with it. And then he just kept on, and I thought he was actually turning to leave, then he turned around like he was going to leave, then he turned, then he swung on me.
Okay.
And then he hit me in the lip, and then he ran and jumped on the truck.
Okay.
Right.
Is this still swollen at all?
Not at all.
Can you tell me about your wrist? What ended up happening with that?
I got hit in the lip. I can only tell you that my best guess is that, in terms of backing up, going back and trying to break a fall, that I used my left hand to try to break my fall. My glasses came off. My head went back, my glasses came off, and I went back a little bit.
Okay. And when he hit you in the face, was it an open hand, closed fist?
I'm assuming it was close fist.
So enough to make you fall backward, obviously. Okay. And then, as far as I understand, you've had surgery. What did the doctor say was going
No,
on?
I went home. The police came and asked me for one of the EMT. I did not at the time. I was just it started swelling, and I was just thinking it was gonna swell. It was just a sprain, and it was swelling up.
Okay.
So I went home. I put some ice on it. I went to bed. I woke up the next morning. I looked at my wrist. It was down a little bit, but it was still painting, and it was still looking a little different. So about 8 o'clock in the morning, I said, start thinking I better let me go see what's going on with my wrist. So I went to patients first to have a look at my wrist. They took some x-rays on it, and they said your wrist is fractured or it's broken. We can't put a cast on it here, so we can make a referral. And we can make a referral for me next week. And so I said, okay. And so I called the place that they were going to make a referral to, and I got in the morning to see them that morning. And so they made some more x-rays, and the doctor looked at it, he said, well, we can just can't put a cast on that. It's pretty broken pretty bad, and you're gonna have to have surgery. So I had surgery on Tuesday.
Okay. And what doctors did you see?
Williams, I don't know the first doctor's name at TLC, but Williams, Steve, Dr. Wilson. And that's just aftercare kind of thing, but.
Okay. Do you mind if I make a copy of this?
Sure.
All right. I'll do that while you're looking at the lineup. And this is who actually performed the surgery. He's got one of those names that both names are. And is this the
Yeah, that's what they said.
distal radius fracture?
Yeah.
Do you have any further paperwork with them?
I do, but I don't have it with me in Tallahassee. I have the medical bills from Blue Cross Blue Shield. I have the medical bills from Tallahassee Alex TLC Surgery Center.
Okay. Anything you think that someone could email me or
I can scan it.
fax it?
I can scan it and email it to you.
Okay.
I can get that to you on Monday.
Okay.
Okay. And I also, I just went through my debit card, just I could print it. I just wrote down all of our out-of-pocket payments.
Yeah, like I said, make sure you keep track of all of them. And then as far as you're aware, no more, I know you have a follow-up today, but no more surgeries that you're should be done. And you've never seen this person before, you don't know this individual?
Never, ever.
Okay. And do you believe you'd be able to pick him out of the lineup?
I think I have an idea a general idea what he looks like. I know his height is about my height. He was a little about my size. So.
Well, we'll at least give it a try.
Yeah.
You'd like to, correct? Okay. All right, another investigator who has nothing to do with the case, is going to come in and show you the lineup, just to say that he doesn't know who the suspect is either. So, he's going to show you the lineup. Do you have any questions for me now? And while you're doing that, I'll make a copy of this and get it back to you.
All right.
Okay. And he'll explain the whole process.
Okay.
Okay.
Thank you.
I'll be back with you shortly.
Hello, sir.
Hello, how are you?
I'm great. Looks like I'm better than you are, right?
Today.
Today. All right. Hey, my name's Dan.
Hi, Dan.
It's nice to meet you. You're Tola Thompson.
Yes, sir.
I've got it right here. I work with investigator here at the police department. We work in the same unit, but I haven't been involved in your case at all. I don't know any of the details, specific details about it at all. And because of that, I'm an independent administrator of these photographs. I can show them to you without any bias or any hints to give them to you as to who this person is or isn't, what they did or they didn't do. I don't know any of those types of things. So this form has some instructions for me to read to you. I have a copy of those instructions for you. This is yours to keep and to take with you today. Okay? Your name is Tola Thompson, T-O-L-A Thompson. This is TPD case number 19-151751. Today is October 25th. It is 9:47 a.m. Okay. So I'll read these to you. You start right there. Okay. You will be asked to view a series of photographs of individuals. The person of interest might or might not be in this photo array. I do not know the person of interest's identity. Do not feel compelled to make an identification. It is as important to exclude innocent persons as it is to identify perpetrator. The department will continue to investigate the incident with or without an identification. Individuals presented in the series may not appear exactly as they did on the date of the incident because features such as head or facial hair are subject to change. The photographs will be shown to you one at a time in these folders. There are some blank photos in the series. This is part of the normal process. Take as much time as you need to examine each photo. If you make an identification, I will continue to show you the remaining photos in the series. If you do identify someone, I will have you designate the photo of the person you have identified. Since this is an ongoing investigation, you should not discuss the photographic lineup, procedures, or results with anybody else, okay? If you would. This has asked for you to initial here in that blank that you received these instructions there. On that one right there, sir. Okay. Do you understand each of these instructions and everything?
Yes.
You don't have any questions about them? Okay. And this there. That one. No. All right. Would you like to see him again? Or is there any reason why you would want to see him again? No. Okay. All right. Some follow-up questions to all of it. How many photos were in the photo array? Do you remember? I didn't ask you to pay attention at that time, so okay, I'll just tell you. There's 6 photos and the 2 blanks in there. Right. Now, then ask us to choose from the following options regarding the photo array, and I'm going to check the one that says I'm unable to select any photograph as being the person who, and then ask to fill in the blank. You want to provide any description to me about what happened or why you were here or anything like that? No. Okay. We can leave it like there then. Okay. go ahead. Sign right there and print your name where it says. That's your name. And you are swearing that all that information is true and accurate, because I checked, I indicated that there were 6 photos and they were ready to run it, but identify anybody, and that you initially you understood those instructions. So, Mr. Thompson, I hope that you feel better, and everything goes okay. I hope that you get well, all right, and whatever that is there. And I'm gonna go, that should be, I'm gonna go and return all this to Investigator Abel, and then she'll be back in here in just a minute to talk to you. Okay? Thank you, sir.
I understand you were unable to identify him.
They have all over much like haircuts and everything.
I know,
Just-
like I said,
It's tough. So I do understand the importance of not picking the wrong person.
Here is my email on the back of my card here for when you find that paperwork or, okay. And, obviously anything you feel comfortable sending me so I can put in the case file as far, and obviously, that obviously may change the charge.
It's okay.
Okay. You have 2 pens in it?
Yes.
Okay. So yes, I would, be interested in that paperwork.
Okay.
And then, do you have any questions for me?
How's the investigation going? How do you feel about it? You talked to the clerks and the witness. I talked to them, so.
Yes, I've spoke to, the clerks, and obviously, I've been over at Circle K a lot. Hopefully that video.
I used to, but I have not been since. I'm just not scared to go, but I just have not been back.
So, no, like I said, I'm gonna continue to work this. I feel good about it, obviously. There's a big difference between a case with no pictures of a suspect and pictures of a suspect. So, I will definitely make contact. I do feel good about it.
Okay. All right. Thank you.
I'm gonna walk back downstairs.
If there's no objection from the defense, I believe it's just, yeah.
You can stop the video.
And that's all the questions I have for her right now, Judge. Thank you.
Cross-exam.
How are
How are
you?
you doing, sir?
Good. Help us with some time.
Okay. I'll try
So and if you could, for the jurors, we've had almost a year or longer kind of separation from courts and cases and things like that. Body worn cameras came online. I think Officer Bartholomew said they were tested in 2018. coming into 2019, and then at some point in 2019, everyone had cameras.
Sounds correct.
Fair. I'm
Yeah,
not holding you to
fair.
the specifics. You
Okay.
didn't do the purchase orders. So let's talk about time. And I want to make sure we get this clear because I went up to Officer Bartholomew yesterday and was asking him about the time on the body worn camera.
Okay.
It had an appearance of being much later than the surveillance footage. And so hopefully you can clear that up for us. How about that?
Okay.
So you had a base time, and I'm going to use base time as to whatever you're relying on to measure the other times. In other words, the Circle K surveillance time, the body-worn camera time, the catalog times. And so I want the jurors to understand the variations in those and how, what you used as a base and how you can rely on them.
Okay.
If you could explain that.
Obviously, the most correct would be our dispatch time, which was when the 911 call was came in, and then the incident was created by our dispatch. And
That's okay.
so that happened between 12:34 and 12:38.
And I'm actually very curious about this. If you explain to members of the jury, how do we know that's a reliable time? What is the mechanism to?
The 911 call takers immediately enter things in the system as they're on the phone with like whoever's called
So
in.
is there a clock in their computer system that
Yes.
logs the time?
Yes,
And what is the base, what is that time based on?
based on Eastern time, Tallahassee time.
No, but I mean, is there like, and I've got a whole list here,
Mhm.
simple Google. So I don't understand it completely, but I want to make sure the jury does. So the base time, you're using a set time, which would be what the dispatch time was, and that's what you're using as a base.
That's what I started with to get the surveillance video.
Okay. And what was the variation between the base time and the surveillance video? Roughly. I'm not holding you to a split second, sir. In minutes.
It was within a couple minutes of the incident occurring that the first 911 call came in.
Okay. So you compare that to the CAD logs,
Mhm.
and you're using that, that's also called a dispatch log, right?
Yes,
Okay, all right. And so that's the variation with the surveillance and the base or dispatch time, right?
right. When I got the surveillance video, saw that it was 36 minutes fast. It came back to about 12:32 a.m., which is pretty consistent with the 911 call coming in a couple minutes later.
And so let's now compare that and go to a greater distance in time.
Okay.
The body worn camera time.
Right.
So what was and if you know, and I'm not holding you to sit here and calculate it, what was the time from the base time, the dispatch time, and the body worn camera time?
It's going to be the universal time, which is, I believe at the time was 4 hours fast.
Okay. And there's actually, there are a few apps where you can do conversions
I would
and things
object to
like that.
counsel testifying.
And please rephrase.
So the base time is in comparison to the surveillance was 36 minutes, is that right?
Investigator Abel, please give an
Yeah.
audible answer.
Sorry, I thought he wasn't done. Yes, sir.
So tell the members of the jury how the body worn camera tracks time.
Once again, it's the universal global time is the easiest way to describe it. So if you removed 4 hours off of Officer Bartholomew's body worn camera, it would be roughly about 12:48 a.m., I would imagine, when he arrived on scene. His camera would have started.
And that cross checks with the base time, the dispatch.
Yes,
And then the time difference between the dispatch time and the surveillance time, you calculate that. So you have all the times laid out.
right. They're all matching up at this point.
Okay. And so there, do you know that is this particular Zulu time, is this based on the 0 meridian Greenwich, England mean time, Greenwich Mean Time, GMT?
I believe it's Greenwich Mean. Yes,
Okay, and the reason
but I'm
asking-
not an expert in it. But it's
Right.
it's the universal. Yeah.
I will absolutely admit, nor am I.
Okay.
In this case, though, I'm going to just go through these and see, because evidently there's some variation to a degree. So Greenwich Mean Time, International Time, is that the same thing?
Judge, I would object to relevance at this point. I think it's been made clear.
Overruled, but we need to get to the point, Mr. Pumphrey.
Okay. And so in your report, did you ever calculate, because you captured the 36 minutes roughly. Did you capture the difference between the Zulu time and the base time?
No, I mean, documented it anywhere? I mean, no, I don't need to, because I just know the body worn camera's time is that way.
And that's because you're trained.
Yes.
Okay, all right. No further questions, Judge.
Any redirect?
No, sir. Okay, sir.
Will Investigator Abel be recalled at any point?
Not by the state.
Mr. Pumphrey? She will not be recalled at any point.
I don't proceed.
Investigator Abel, you can step down. Have a good day.
Thank you, sir.
State may call its next witness.
Judge, at this time, the state would rest.
All right. Members of the jury, now that we have hit the noon hour and the state has rested its case, I will give you your lunch break. There is a cafe within the courthouse and also 2 delis downtown if you wish to remain close. Of course, you also can obtain your vehicle as well if you would like to go somewhere else. You will have until 1:30 to enjoy your lunch. And at that point, please report back to the courtroom. The bailiff will collect you and the trial will resume. Enjoy your lunch. Everyone can be seated. Is the defense making any motions at the resting of the state's case?
I am, Judge. You have just a moment. Judge, may Mr. Morris be seated?
You may.
And Judge, may I be seated on?
You may.
Judge, I'm just going to do this orally.
Okay.
So Judge, at this time, on behalf of Mr. Morris, respectfully move the court for a judgment of acquittal. In this particular case, pursuant to Rule 3.380 of Florida Rules of Criminal Procedure and Section 776.032, 766.012. And Judge, in this particular case, we haven't raised those last 2 issues. Judge, I would just like to ask the court to consider at this instance, a motion for judgment of acquittal as to these charges. And then I've got a couple other motions that I'll address separately from this. Your Honor knows the standard. It's been around forever, Lynch v. State. So in light most favorable to the non-moving party, that's my motion.
Right, state response.
Judge, I believe the felony battery, great bodily harm statute, or the jury instruction, all the elements have been met by the state. The state put on evidence that Mr. Morris actually and intentionally touched or struck Tola Thompson against his will. ID is not an issue, and so when you look at the testimony that's been presented, I believe that element has been met. The second one, Chase Morris and caused Tola Thompson great bodily harm, permanent disability or permanent disfigurement, and then obviously the instruction that it does not include mere bruises. Mr. Thompson has a permanent scar on his hand. He testified on his wrist. I'm sorry. He testified that he can no longer do things like a push-up, and he could do that before. The injury that was caused by Mr. Morris, he testified that he had to have surgery. He's got 2 pins in his wrist. The medical records are in evidence. So at this time, Judge, viewing the evidence in the light most favorable to the state, I do believe the state has met its burden.
And I will deny the motion for judgment of acquittal, but it certainly can be re-raised at any point after the defense's case or at the conclusion of any rebuttal case if the state is going to present it. You have other motions, Mr. Pumphrey?
Judge, I have 2, and these are, first, based on discussions last night, I'm going to make a motion for mistrial on cumulative error, just just tagging back all the objections and everything else. And being specific with that motion, when I say tagging everything, all the sustained objections throughout the case, from this point backwards until we started. And that's all I have on that one.
Right, any response from the state?
No, sir.
All right, as to the form of the questions by the prosecutor and the objections being sustained on those grounds, do not believe any potential error would rise to a level where the defendant cannot obtain a fair trial or has not obtained a fair trial thus far, so the motion for mistrial is denied.
Judge, I'm going to make a due process motion, and this is more COVID related, and I'm putting that on the record. I've been a trial lawyer now for, a year or 2 years. It'll be or almost a quarter of a century. I've never had to try a case with a mask. I've tried cases in churches in McCullough County, and all over the state. I've done hearings and things. And as a trial attorney, nonverbal communication is a cue that is a very big issue for us as trial lawyers, both the state and the defense, but specifically the defendant is the one in jeopardy. And this is my first post-COVID trial wearing a mask. And although it's uncomfortable, everything else, there are pros and cons to it. The pros are the health issues, although I'm fully vaccinated and plan to stay that way if there are any booster shots. I think everybody else should do the same. And I understand the health concerns. I understand the Supreme Court's rulings. And so, but in looking at the jurors, it's hard to discern what their facial expressions are when certain issues come up, whether they be evidentiary, whether they be testimony, whether they be cross-examination. And as a trial lawyer, part of our art is looking at the jurors and seeing their reaction to certain things. Judge, I understand why the courts require masks. I can appreciate that. I still have a duty, though, to preserve any issues on behalf of my client. He is the one in jeopardy. He is the one that, depending on the jury's verdict, could determine whether or not he goes to jail, prison, or otherwise, or whether he walks out of here free. And so because in my experience, and I can't cite to anything specific, but if anyone reviews this, but roughly, probably 37% of communication is nonverbal. And so I take a lot of feedback, nonverbal, from jurors and their cues, their nonverbal cues, whether it be, a smirk or anything else, but I can't see that behind the mask. And I raise this issue. It's somewhat of a novel issue to raise. I don't have anything to support it or back it up. I hope I never have an opportunity to go through another pandemic, and hope we never go through another. But my concern is not focused on myself. It's not focused on the jurors, or the court is focused on the defense of my client. And so I openly admit that is a deficit, although I am surprised at how fluent we're able to work even under these circumstances. So I think the court system here has done the best they can, and I'll candidly say that. But on behalf of Mr. Morris, I would make a motion for mistrial on that issue, and then I will also make a motion to dismiss on that issue on due process.
Right. As it pertains to that issue, in making the ruling, the court will judicially notice all prior administrative orders of the Florida Supreme Court as it pertains to COVID-19. In accordance with that, the Florida Supreme Court has ordered all inferior trial courts to take certain COVID mitigation measures, including having proceedings involving distancing and facial masks. To that end, the motion is denied, as it would implicate any confrontation clause grounds or the right to a fair trial. Essentially, all measures pertaining to distancing, masks, and otherwise witnesses or jurors having face masks deal with COVID mitigation measures. Whether that implicates the federal right in any way, again, I will find it does not, but ultimately those issues can be reviewed if necessary. The motion for mistrial on that ground is denied. Also, the motion to dismiss are denied on those grounds.
Judge,
Anything else?
Judge, at this time, I just renew all prior motions, objections, and everything else. And Judge, I'd like the court to inquire of my client as to his decision on whether to testify or not. The court, I quite candidly have put this on the record several times. The court granted me great leeway in issuing an order to allow me to go sit down with my client. As I disclosed to the court with his permission, he has a number of processing issues, which I identified the first time I met him. And then it was backed up by family and other people, but just observations. I don't know if the court's noticed, but he is very actively participating. In fact, we had the one issue and he was fervently scribbling exactly what I was saying.
Right, so,
And if you notice, Judge, he's asking questions and he's passing notes and he's interacting with Ms. Keppel. And so I feel he has at this point processed everything to this point. I haven't seen any problems with deficits. I've even asked him, do you understand what's going on here? I had a long talk with him off the record yesterday before he was taken back to the jail. He was having anxiety. He fidgets almost as much as I do. And so I can relate to that part of it, but the anxiety part and the processing was the key issue that I wanted to make sure he is understanding the process and what's going on in real time. And if there are any questions, I've followed up with him and he can confirm that when the court inquires. I would like to inquire of him briefly after the court inquires on his.
that's fine. Mr. Morris, please stand and raise your right hand so you can be sworn. Do you swear or affirm the testimony you're about to give will be the truth? You can lower your hand. Mr. Morris, do you understand in a jury trial where you are the defendant, you have the constitutional right to testify? Have you gone over what the right to testify as a witness in your own case means with your attorney? Do you need any additional time to discuss this constitutional right or the decision that you need to make today? Have you made a decision as to whether you wish to testify in this trial on your own behalf? And what is that decision? And are you firm on this decision? Do you understand by testifying you are subject to cross-examination like any other witness? There are certain dangers that are involved with you giving up your right to remain silent. Do you need to discuss those with your attorney any further?
No, sir.
Just what I mean by danger, obviously, is not mortal danger, but essentially how you present yourself and what comes out could affect the outcome. That's what I mean. Do you have any questions about that, or do you wish to speak with your attorney any further? All right, so you are firm on this decision. All right, the reason I'm asking you these questions and whether you're firm is essentially there is no do-over on this decision. It's a once in a lifetime, now in the moment. Do you require any more time, or do you want me to go over any part of this with you again? Right, Mr. Pumphrey, you wish to inquire as well.
Judge, may he be seated?
You may.
Mr. Morris, we've gone through this trial. The state has been a zealous advocate for the state, but at this point, we had discussed what the court just went over with you previously, both at the jail and over the last year. Maybe we touched base and everything during COVID, but before that, you had actually come to my office. We had discussed options, we discussed what the court asked you about, and I had given you my opinion or my professional advice as to but I clearly advised you that it is your decision. It's considered a client objective. In other words, I can't influence you. I can tell you what I think is best. I can tell you what the pros and cons are. As I've told you, your processing issue is, of concern. That's why I came out to the jail and we discussed what your testimony would be and what you're going to present. And that as long as you're truthful and listen to the questions, and if you have any questions or any processing issues or, major anxiety or anything, you let the court and the bailiffs know, and they'll address it. Did we go over all that? Are you pleased with what I've done to this point? And I've had the honor of having Ms. Keppel here present. Has she also been assistance in you in processing things? And if you had any questions about any paperwork or anything, she provides it to you. And she's taken a lot of notes. I know she's shared those with you as well. And that's all regarding the strategy and the processing to make sure you're on point for whatever we're doing. Yes. And in real time.
Yes.
Okay. So I discussed with you, or the court discussed with you, your decision to testify. We have discussed it at great length, and I've shared with you my concerns. I've shared with you what I think are the states over here, and they're hoping you're going to step on a landmine or do something else, and because of your processing issues, that could be problematic on cross-examination.
Yes, sir.
And do you feel that I've thoroughly prepared you for taking the stand and focused you on the truth of what happened that night so you can tell your story?
Yes, sir.
Okay. Now, we heard a couple of jail calls, right? Okay. And not meant to embarrass you or anything, but as I explained to you, probably the first time you came in, you have a right to remain silent.
Right.
And I've advised you not to talk on the phone.
Yes.
Okay. I've advised you not to talk to the police.
Yes.
Okay. And so you fully understood and knowing those rights, just like you do here today, you made a conscious decision to waive those rights at periods of time, some unfortunate with personal discussions, but the court's ruling saved you from the rest of that. But at the same time, you understand that the state can question you about that as well, since that just came out last night. Okay, and you've heard that tape.
Yes, sir.
Okay, and I've shared my opinion about the tape. I haven't did that, have I? Okay, but even though I was not happy with it, I've advised you that we will push forward as long as you tell the truth.
Yes, sir.
That's all you need to focus on. And you agree with the strategy because we came out in an opening statement. It's somewhat unusual. It also gives up what our strategy and our theory is. But based upon that, you gave me permission to share what I did with the jury in opening statement. And as we went through the case and through the different things, for example, on the jail phone call stipulation, you wanted the whole call played as a strategic decision. And you've seen how the courts handled everything, and I've explained that to you as we go through. Having all that in mind and understanding that you still feel it's in your best interest, I've made the recommendation that you testify, but I haven't forced you, coerced you, or threatened you in any way. And you understand that you've made a decision up front to come out and tell the jury, and you agreed to stipulate the ID, which is an essential element, but that was strategic.
Yes.
Because our theory in this case is focused on the fact that you were justified in reacting to the threat that you perceived.
Yes, sir.
Okay. And so with all that in mind, do you wish to present a defense case?
Yes, sir.
You understand that even as we sit here now, we could sit here and say, defense rests and be done with this. And you didn't have to take a stand, but the judge is not going to read the stand your ground instruction.
That wouldn't make any sense to do that.
Yes, sir. He said that wouldn't make any sense. If you could repeat it for this poor young lady.
That would make any
Her
sense.
she's like a duck in the water and her fingers are going 90 to nothing. And she's got to hear everything. So and you understand there's a witness in the case, the state listed as a witness, and that is the mother of your child.
Yes, sir.
That's your girlfriend.
Yes,
And we heard a discussion with her previously.
Yes, sir.
Okay. You understand that discussion on the jail call is going to come up if you take the stand or if we put her on the stand.
Yes, sir.
Okay. And you still feel that our strategy and our decisions to this point are solid and you feel comfortable moving forward?
Yes, sir.
All right. Very good. And with some exceptions, I retained Detective Copeland and Officer Bartholomew, which may potentially be additional witnesses for us. And have I investigated everything and communicated everything and strategically made decisions like hiring a private investigator to reach out to people and not doing depositions strategically and getting somebody to talk to people because we had everything on video? Okay, good. Just wanted to make sure we're ready to move forward, Judge.
Very good. Before we take our break, I just wanted to review the state's exhibits that are in evidence. So that way we have no issue with that later. States 1, the Circle K footage was admitted. States 2, victims of the alleged victim, Mr. Thompson, 2A through 2E, admitted. States 3, admitted. States 5, I believe the first jail call states 6, the second jail call, and states 8, the video that was taken, body camera video of Officer Bartholomew. The only thing that I do not show is admitted is states 4. Did the state move to admit states 4? Did the state move to admit states 4 during its case?
Yes, sir, I did 3 and 4. 3 is the patient's first record, and then 4 is the Tallahassee outpatient surgery.
All right. I believe when 3 was admitted, I didn't think they were being joined together, but as the defense objecting to states 4, its mission. All right. And states 4 is deemed admitted during the case based on what the prior stipulation was. Are there any other pieces of evidence in the state's case in chief that we need to address?
Yes, sir, I just wanted to say, there's 2 discs with the same jail call on it. Yesterday, I left state 5 here, and then I went and made a new copy that hopefully it would work. The copy that we paid for is the copy that I have here.
All right.
This other copy is the one that I have.
And Judge, just to tag on to that, the protocol is that before anything is played, any tapes or any video or anything, jurors would have to come back in, and we do it just the way we've done it so far during the trial. And I wanted Mr. Morris to understand that too, because this is Mr. Morris's first time ever seeing a trial, and thankfully the first time being subject of a trial. And so I'm going through these things on the record so it's clear that he understands, each and every stage that we're going through as best we can, and make sure that he's processing it and making a conscious, knowing decision.
Very good. If the defense needs to use any of the admitted items, they are there on the clerk's stand.
I just wanted to say one thing, Judge, and I have already said this in the beginning, but I just want to make sure that specifically that Mr. Morris is clear on this since he is going to testify. I know Mr. Pumphrey is, but the issue of him being delayed or not understanding things, I know Mr. Pumphrey just at length went over with him that he is going to be cross-examined. I want to make sure that is not to be mentioned, that he is delayed or has trouble understanding anything. I understand he's doing that to cover the record, but it's not appropriate for there to be any mention of any type of deficit in his ability to understand. So I just want to make sure that's clear, especially during cross. So.
All right. As it go, well, I guess 2 things that I want to say to that. Ms. James, 1, please make sure your rate of speech does not get so fast where it's going to create some sort of visible issue to where either he's having trouble understanding or cannot filter through what's just been said. But as to that point, Mr. Pumphrey, I do believe she is correct. This does not go to his incompetency to proceed. Otherwise, trying to bring up any sort of condition, I believe, is unnecessary since he's capable of following along.
If the court makes that ruling, I'm going to follow that ruling. I do want to put on the record, though, I did at length in preparing him for trial, this was a hurdle to overcome. And my advice to him was that we need to let the jurors know so they realize if you're on my questions, right? And we went in depth about cross-examination. And it's, not something that you want everybody to know your business. But when I first talked to him and in going through the representation, I've explained to him, listen, you need to pause and listen to what I'm telling you. And so I'm just carrying that forward. I respect the court's ruling. If the court has made that ruling, I would proffer, though, that I would bring out on direct examination the fact that this is his first trial. He's never given testimony before. And this is a new process for him. Anything that's where he's showing he's scared to death. I don't know if the court noticed, but I had to sit with him over here on the side. He was tearing up, and it was just anxiety. And for us, we do this every day. And so he's very stressed. And for what reasons, I don't need to get into, but I think that's part of the process of explaining. If you have somebody who is blind, if you have someone who is, and it may not be obvious, any deficit or any issue that would the jury may misperceive, I would like to clarify that. But if the court makes that ruling, I will follow that ruling. And,
That is the ruling, and so it's clear why. This is less about the jury having an awareness of his condition than it becoming anything related to his ability to comprehend or understand or follow the law, to properly conform his behavior, or any things of those nature that go to guilt or innocence as far as him in some way, it being something that he's incompetent to proceed, which no one has made an issue of. The defense has not moved. So he is competent to proceed. The trial has proceeded. If he needs additional time, both examiners need to give him the space, reduce their rate of speech, wait for the response. But again, we're not going to make this an issue in front of the jury in some way that either he cannot understand what's taking place, cannot properly conform his behavior or actions, or in some way should not be tried due to this condition.
Judge, to clarify on the record, I will tell the court as the officer of the court, I've not seen any issues that even raised the head of competency. When I was a young private attorney, I had a fellow I represented for over a year. Talked to him, he was nice and pleasant, and thought everything was fine. I'm very sensitive to this. And then we were talking about plea negotiations. He said they told me to take the plea. I go, who's been talking to you? I'm thinking it's people in the jail or something else. He goes, well, they tell him that. He was hearing voices in his head. And then I researched it and called his family, and he had been struck by a car and had a severe head injury. And he heard voices his whole life. And no one had ever documented that. And he had a record. And so I then immediately had him evaluated. So if I even think that Mr. Morris is not competent, and I would ask the court to make a finding. The court has seen the interaction, seen his reactions to you, and how he's interacted with us. And so the record's clear. I think the court is also finding that he's competent. I haven't asked for that inquiry, but just so the record's perfectly clear, because in years to come, somebody may look back at this and not remember everything.
Based on the record that is before the court, the defendant is competent to proceed, and ultimately the basis of the ruling is I do not want the finder of fact to confuse any processing delay with competency, right?
Judge, there's one thing I need to address that the defense just brought up.
Go ahead.
The fact that they want to ask him, is this your first trial and have you ever testified? It's irrelevant. It's bolstering. It doesn't matter if he has or not. Now, if he looks nervous, I'm not objecting to, them saying, are you nervous today? That's fine. But any type of is this your first trial? Have you ever, I don't know why that matters. So, and they just said they were going to ask that. So I just wanted to mention that.
Judge, when I was a prosecutor, I was a law enforcement officer. I remember the first time I testified, a prosecutor asking me, have you ever testified before? Because I was nervous. I'd never done that before. And I just followed that process because I just believe it's being transparent to the jury is part of the process. I'm not trying to get into, he has no prior record.
I'll make a finding that any line of questioning that deals with essentially dealing with why your client may be nervous is proper. Beyond that, if the state needs to object, we'll deal with a contemporaneous objection and a ruling at the time.
Yes, sir.
Okay.
Very good.
Enjoy your lunch. Please report back at 1:20, and hopefully everyone reports on time. We'll get rolling from there.
Yes, sir. Thank you, Judge.
Sorry? 1:20.
You want to start working the time?
Better? Yes.
I'm gonna walk it like you. I just don't want to give you walking in while you're getting shot up. So give me just a minute. I'll call you out. No.
Okay.
Just a minute, hold on.
Thank you, guys. We're back here at 120. I can leave this stuff here.
Yeah,
he's coming back here, he's doing it right.
Okay. Actually, guys, I think I'm gonna leave all this here.
Okay, I'm locking the door so you can.
Nobody's gonna play.
I'm walking it about 15 till.
What's that? Yep. Thank you so much. Put you up there, Bob, if there's nobody in here. Okay.
You have magic keys, so you can do whatever you need to do, right?
Oh, yes, I'm good. I let myself up.
In
Yeah.
and out.
No, I'm not. That's good.
Those copies that the form, and go in here.
I'm going to walk. Do you want to go?
Oh, you have to like 15 minutes.
Yeah. I know. No, I gotta find it. Thank you. Oh, how are you doing, Mike? Good, good. Extra is a good word. It's all extra. Extra.
How's it going here?
It's extra. All righty. I wonder why I have to start somewhere. And thank you for picking the audio. You did a good job.
Well, how's it going? Are they, how long is the trial?
A lot longer.
A lot longer. Today and tomorrow?
Oh, no. I think that it's the defendant's going to testify.
Cool, cool. Thanks.
I'm leaving this here.
the call that's in evidence, do you remember what date that call was made?
I do not.
Can I approach the witness? You hold it out. I don't think you can mess up with this. I guess I've already handed it to you now, but does that refresh your memory as to when that call was made?
Yes,
Okay, and when was the jail call that is in evidence? When was it made?
May 14th, 2021.
May I approach the witness?
An incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To refuse charges, press 2. If you would like to permanently block your number for receiving calls from this facility, press 6. For balance and safety for using Securus. You may start the conversation now.
I think go to trial. No, I get it, person. If they want to do it, kind of jail, that's a good person.
Yeah, I think there is two jobs. I was just trying to figure out on my other laptop, how to fix the audio issue.
Both ends of the conversation I'm playing.
Yes, sir, that's correct. So you can't hear everything. This has happened to me before, and there's something that our IT person could do to fix it, but obviously he's gone at this point. So, I mean, I can start with this tomorrow. I agree, the conversation is not playing how it needs to be played, so.
Instead of, you are going to need to be called again tomorrow, while the state works with IT issue this evening. Members of the jury, this is going to be our break point for tonight. Please report the courtroom to F tomorrow morning at 8:30. And from there, the plan is to get underway as quickly as possible. Enjoy your evening. You remain under the instruction you received earlier today that you will not talk about the case with each other or look up any matters pertaining to the case. Good night.
Hungry for new backlinks for your website? Use Backlink Analytics by SEMrush. Compare your profile with rivals. Discover their authority score. Track their lost and new links. And find the tastiest sources to get mentioned on. SEMrush, turning data into ideas.
If you wear glasses or contacts, you must see this. A Japanese Nobel Prize-winning scientist in stem cell research, Shinya Yamanaka, has discovered a natural way to reclaim the 20/20 vision you were born with in record time. Did you know, vision problems have absolutely nothing to do with your eyes? A shocking link between stem cells and your eyes was discovered by researchers at Harvard University Stem Cell Research, along with researchers at Vanderbilt University, the University of Utah, and the National Health Services, NHS, in the UK. These studies show that your eyes will deteriorate with each passing year, even if you wear glasses or lenses. And that's because they don't do a single thing to actually improve the way your eyes work as you age. This Nobel Prize-winning scientist helped in discovering the real reason why you are losing your vision, and a revolutionary way to reverse your vision problems as you sleep, no matter what your age or current condition. And it works like crazy. This secret habit is so amazing. It sent the entire eye care industry back to the drawing board. And it's currently losing them millions of dollars. 13,000 people are already doing it and gave up their glasses in less than a month. It's so powerful because it targets the single root cause of vision loss. So if you're suffering from vision impairment, stop everything you're doing and click the link below to watch a short free special video that explains exactly how to reverse vision problems quickly. And no, this has nothing to do with meds, surgery, or expensive treatments. And it works for all types of vision problems: cataracts, diabetic retinopathy, macular degeneration, glaucoma, blurred vision, you name it. Andy Perth was a new grandpa and was excited to see his granddaughter at the hospital for the very first time. Except when he got there, his vision was so poor, he couldn't even see his granddaughter's face. Heartbroken and angry, he desperately searched for a solution, and that's when he came across Dr. Yamanka's research discoveries, and a simple ocean creature that was the key to unlocking his vision problem once and for all. After heavily researching a possible solution, he put together a remedy based on this prize-winning research, and he couldn't believe his results. After just 1 week, his dark blurry spots started to vanish, and by week 7 he could see clearly again for the first time in years. Jan had glaucoma that was so bad, she was on the verge of going completely blind. She was at the end of her rope and was intrigued and skeptical by this new discovery. She tried the remedy, and to her surprise, her transformation was almost instant. Her vision started to clear within the first few days, to the point that she can now see objects that are both close up and far away clearly. So click the link below and watch the short eye-opening video before it's gone. Click below before it's too late.
The Certa Perfect Sleeper is made with a unique Hex Cloud foam designed to cradle your body and help.
The call that's in evidence, do you remember what date that call was made?
I do not.
Can I approach the witness? Does that refresh your memory as to when that call was made?
Yes,
Okay, and when was the jail call that is in evidence? When was it made?
May 14th, 2021.
May I first witness?
An incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To refuse charges, press 2. If you would like to permanently block your number for receiving calls from this facility, press 6. For balance and safety producing, Securus. You may start the conversation now.
I think go to trial. No, I get it, person. If they want to do it kind of jail, that's a good person.
Yeah, I think there is two jobs. I was just trying to figure out on my other laptop, how to fix the audio issue.
Both ends of the conversation I'm playing.
Yes, sir, that's correct. So you can't hear everything. This has happened to me before, and there's something that our IT person can do to fix it, but obviously he's gone at this point. So, I mean, I could start with this tomorrow. I agree, the conversation is not playing how it needs to be played, so.
You are going to need to be called again tomorrow. While the state works with IT issue this evening. Members of the jury, this is going to be our break point for tonight. Please report the courtroom 2F tomorrow morning at 8:30. And from there, the plan is to get underway as quickly as possible. Enjoy your evening. You remain under the instruction you received earlier today that you will not talk about the case with each other or look up any matters pertaining to the case. Have a good night.
Did you know that the average adult has 5 to 20 pounds of toxic poop in their body?
Hey, are you still there?
So, you don't super.
No, yeah, I need a super, I already have a new.
Oh, okay, well, I don't need to bother to call it.
You need a bottom and a top for the brood box.
Gotcha.
And then I don't need a super for the brood box because I had already ordered a spare super, so I have 2 of those already. But I do need frames to go in the brood box.
Oh, okay. So we don't need a box, no, we need crap.
No, we need a box. I need a box to put the second colony in to live in.
Okay. So, do we need the base?
Yes.
Okay.
The bottom, the floor,
So we need the bottom and the top. Right.
but baby, it's not a nuke. The nuke is the small, tiny box that they use to start a colony. I have a nuke. I don't want a nuke.
Okay. Okay. All right. So what do you call the base?
A brood box. And the bottom, the floor that's got the little ramp where the girls go into, down at the bottom of the box.
Okay.
And then the top, I think they call it a telescoping top. It's got the metal around it, but if they only have wooden tops, that's fine.
So far, that's all.
That's okay.
I'll ask her again.
Yeah, no, it's okay.
The separator, you said you got one.
I need an excluder. I'll need a second,
But you do need
a second excluder.
yellow and gray plastic.
Yeah, yellow's fine. It's fine. Yellow's fine. Plastic's fine. Doesn't matter. Whichever's the cheapest.
Okay. And, they have flat tops, one of the laboratory top with the lids on it. Flat tops, some of them have holes in it for sugar.
Yeah, I need the flat top without the hole in it.
Okay. And then, there's, kind of bundle head, so I guess we'll have some extra.
Yeah, I need extras anyway, because when I pull one,
That's right.
yeah, when I pull one, I can put a new one in there. I don't have to worry about it. We're doing space there.
Okay. And then they have plastic, so
Plastic boxes.
no plastic,
Frames. Yeah, it's okay. They can be plastic. I mean, what are you talking about? The centerpiece is plastic? Yeah, that's the way the other ones are too. Mine are. Yeah, those are okay. That's okay. Yeah. Yeah, that's okay. You just want to, okay, cool. Alrighty.
Anything else you think?
No, not, I've got Corona strips and I got all sorts of other stuff. I just need someplace to put them. But not a nuke. I need a brood box. Yeah, a brood box. And how much are their supers?
Well, it's the same assembly required product,
Yeah.
yeah, fruits. So,
That's okay, go ahead and get another super then and get the frames to go with that too. That way I'll have a spare one. Yeah, but, yeah, that's okay. I mean, it's better to have them and not use them than not have them and need them, so. And if we're doing local business with Monticello, so I'm happy with that. It's worth the investment. If I can keep the girls around long enough to make some money on the honey, it'll be awesome. Okay, alrighty. All right, thank you. It's probably gonna be a late night too, just FYI. Okay, I'll see you in a minute. All right, bye. I'm so frustrated when I'm not here. I walked out. Oh, I knew, I came, I came in here, you have to cover that. What do you say for that? Oh, okay. I mean, no, because the clerk was here, or the, Madam Stenographer was here. She had some stuff she had to do. I went out, I starched my lunch, and I just came back in here so I could make a phone call and just get some peace of quiet before. And I saw it sitting up there, but I was like, I knew the front door was locked, so I wasn't worried about it. And on the way back up, and I thought, oh my God, well, that's stuff too. I wanted to ask you, okay, I know it was illusion mind. Sorry, I have been in a trial like this. The only time I have is oddly enough when I got to family law trial. It's like they. Seems to be so many words about the stuff and that just only 5 hours. Yeah, come on, it's still, it's front locked, we're good.
Hey, this jury,
This must be a very dangerous man.
we started with his morning, he proposed.
Well, they like you so much that.
The jury in there, right?
No, but they come down that hall. Yeah.
Where are they at?
They're in the room over. Like right now, or now at
Yeah,
night.
where's the jury?
At lunch.
You're at lunch now.
Okay, where's the jury?
It's a conference room between the actual jury room and a hearing room. You know, if I had to answer that question, I could retire.
It's just tricky here. It's a hallway.
Yeah, that's why.
I'm like shoving them in the corner.
That's why I was so happy about getting much of at one point. Stop that. Because all of a sudden I saw three guys bringing him down the hallway. Everybody's hovering there, waiting. I'll get you in here in a minute. This. It was very awkward.
Right.
Yeah, we have to do it yourself. So that's right. Which is which? State's there. You need a card once you're left the staff.
You say this is right here?
Yeah, he sits right there. Well, the wheelchair goes back. That's for, his,
Right.
yeah. Did you use the restroom when you went upstairs? Okay, you should be good to go for a little while.
Oh, yeah. There's up in there too. I'm one of the. That was a lot of. Yeah.
Differently situated than upstairs.
Well, I walked out there and go, something like that. So all that main hallway, there's only a bathroom down to the left, correct? There's not one to the right.
Unless you have the key card, you can't use the one to the right. But if you
So there is a
get-
bathroom back.
Now you're out.
By where the elevator is, there's no light, and then from the, they go out that way, takes out of the hallway, the closed area.
The back by the jury room.
Hey, you doing? Body guard.
Brother Fred out of trouble.
Definitely.
When I say deviant mind, shouldn't hang out, you know. That's trouble, Fred. Yeah, man. Remember you had that earring in your ear?
I did. I do remember that.
Who was the guy?
Tattoo.
Who was the guy? Man, he had so much stuff on tape. I get a case like, oh. He get guys sit talking all kinds of stuff. Skinny guy, had long hair. Jimmy.
He was my work husband.
Wow. That guy. I see stuff and I see it there. Wow. But yeah, we worked some good cases. We did that huge MDMA case. Remember? That kid's got a wife and kids now. Walked out that night. Did the right thing. What's up? Were you back up here?
Yeah, I'm done, man.
I'm glad seeing you. Well, this is kind of tail end of the.
This is hospice.
Yes, for law enforcement.
Yeah.
Hey, man. Master's not looking too bad. I worked all last night. I told him, I said, 57 ain't like it when it's 37.
Yeah.
Getting old ain't for the weak of heart. I'm just glad to be here. A few times I didn't think I'd be here.
I'm sure. Well,
Hello. Good. Hey, how you doing? Why are you in here?
I know.
Oh,
Okay.
I thought you were with Judge Marsh. Fun. I know, I haven't seen you in like, like 2 years. 2 years old. I know. I left my mouth. I'll call Maggie or somebody.
Yeah.
Is Victoria here?
Yeah.
You have her cell number?
Yeah. She might be at lunch though. I'm Gina.
I'll call Maggie. You're gonna have Gina?
Yeah.
They could just like either bring it or meet me. I'll meet them down the hall. But yeah, I was like, well, I haven't seen a lot of people. It's been like, you know.
Can you bring me my mouse?
Can I bring you your mouse?
Yeah, at my computer desk.
Oh, that's so you have my
2F as in Frank.
2 is number 2, F is in Frank.
Yes, ma'am.
On my way.
Okay, thank you, Dina. Go back again. I asked her to do it.
I'll try to meet her like down the hallway, so she's gonna walk the whole
I
way.
asked her before she.
Talking's good for you,
Do that.
right? Well, how have you been? I know you did like a lot of work on, it's always like you guys put up a fence on your property.
No, not on my property, like one of my neighbors.
Ah, one more. Yeah. Come on. Yeah, absolutely. Where are we going?
Crazy, you know, right? Yeah. In total, about 300 feet. Yeah, can you enjoy on? You know, the movie scene the other day, on TV.
Yeah.
Hey, stand
Right.
like a photo stick, steroid.
Mhm. Sure. Well, technically, we can catch up with them. I think they actually just recently. Or no, that was the threat. They added the threat.
Straight up anytime you want. That means at the bottom of the guidelines, 26 months, judge can send you anything that.
Oh, thank you. You're welcome. Are you like, to meet up there? Yeah, my grandfather used to, him and his two brothers used to fell trees, and like my grandfather would like climb all the way to the top and then like ride it down. I'm like, how did you survive? Oh. My mom says that is proof that why women live longer than men.
All right. Please be seated.
Any matters to address before we get started?
Just briefly, Judge.
Go ahead.
Judge, we're on the record and let the record reflect that counsel is present. Ms. Bingham, I should have made that. Ms. Bingham and Ms. James, it's the state's case in chief. We're reconvening after lunch. And let the record reflect that Mr. Morris is present, as well as Ms. Keppel, to assist. And Judge, my first witness would be Sierra Roylance, if I'm saying that right. And Judge, Mr. Morris's mom is seated back in the back, and she's kind of helped locate her. She was outside smoking. She went to take a restroom break. Before I talked to her, though there's been new evidence that's come out in this court. And so the rule of sequestration is questionable whether it applies or not. I would like to discuss that with her so she knows that, hey, your phone call from last night, was disclosed in discovery. So whatever you said, you said. And Mueller, I haven't really talked to her about the case since probably first time I prepped it. Briefly spoke when yesterday, and I've seen her in the hallway, but I need about 5 minutes just to make sure everything's good with her and put her on. I don't anticipate anything's changed from what she told me before. So.
State, any response?
That's fine, Judge.
Okay.
Judge, as to Officer Bartholomew, I released him from my subpoena. I chatted with him, resolved whatever questions I had. I told him though that he's still under state subpoena as well. I thought Ms. James had released him, but just to be sure he wasn't a rebuttal witness or anything. And then I've got Sergeant Copeland, Sergeant Dan Copeland. And I've just retained him because I can't foretell what, the next two witnesses will or won't be. And so depending on how that goes, I may release him and that may be then part.
Very good.
So just so we have a room.
Sure. I'm not saying that Bartholomew is not going to be a rebuttal witness. I just was fine with you saying, I just want to make sure that that's clear.
I just want to make sure I wouldn't let him release from
Right.
the subpoena. He's supposed to be
Right.
here.
Okay.
All right, has Ms. Roy Lance returned from the bathroom?
Judge, I'm working on my x-ray vision, but I'll walk outside now that I know I can tell her that. That's
Okay.
That's about all.
And the jurors are there? Okay. All right, we'll bring him in as soon as he's finished. This couple, what time were you all expecting to need to do the case management with Judge Allman?
Generally very quick, so I'm not staying back if you need to call me when.
All right. Hopefully by that point, if we're at the charge conference, it won't produce any great delay, but we'll see where we're at.
Or should I just say?
That would be great. May I bring the witness in?
You may?
Don, did you want to put on the record that you did, or on the record that you did ask me? Did you want to put on the record that you did ask me?
Yes, yes, yes.
Okay.
Hold on, Mr. Bailey, could you, or Mom, could you just take her outside the second, let me address one thing with the judge, and then literally be 5 minutes, or 2 minutes. Judge, I want to make sure I protect the rule of sequestration. I talked to Ms. Rowlands. We're going to put her on just a second. Judge, I did want to put on the record that my client, I always, talk to clients about, hey, you still please straight up. You can, if you want me, I'll ask the prosecutor. I talked to Ms. James. Ms. James isn't making any offers. And I talked to my client. Just want to put on the record that he's been offered all previous plea deals and everything else. It's not going to slow us down or anything else. Just want to make sure I'm making my record. He's ready to go. He said he's ready to testify. Ms. Roylance is here, so got a good start.
All right. Let's bring in the jurors.
Are we gonna wait to bring the witness in until the jury is in, or
I'm sorry?
are we gonna wait to bring the witness in until the jury is in, or?
She can be in the courtroom. That's not going to be a problem.
You rested on the record, right? Yes, you did. Never mind.
State has already rested. Ms. Roylance, just take a seat in the gallery for right now. Just take a seat in the gallery. Yep.
Wait for the jury to see.
All right, jury entering the courtroom.
Everyone can be seated. With the state having rested its case prior to the lunch break, the defense is now going to begin its case. Mr. Pumphrey, are you ready to call your first witness?
I am, Your Honor. I call Sierra Boylan.
You can come up to the witness box, ma'am. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? You can take your seat. Please speak loudly and clearly into the microphone.
Okay.
You can scoot that chair up a little bit and pull that mic close to you, but not right on top of it.
Okay, leaving my mask on the whole time?
Yes,
Okay.
ma'am. May it please court.
Okay.
Could you please introduce yourself to the members of the jury and tell them your name?
Yeah, I'm Sierra Roylance, Chase's girlfriend, mother of his child.
And how do you spell your first name
It's
and your last name?
Cierrarolance.
Ms. Roylance, back in October of 2019, October 4th to be exact, were you living with Chase Moore?
Yes.
And when you were living with him at that time, later in the evening, did you guys decide to go anywhere?
Yes, yeah, we went to the Circle K right down the street from our house. I had the pregnant munchies.
Okay. And what did you guys go there to get?
Ice cream, ice
Okay.
cream.
And do you recall the events of that particular evening?
Yes,
Okay.
very clearly.
So take us from the house to the Circle K.
Okay, the Circle K is only like a couple blocks down the road from our house, so that's where we decided to go. It was just a night like any other, just decided to go and get myself some ice cream. Publix was closed, so we couldn't go there. And we got to the store, went in, I got my snack. Chase went in with me.
And I'm sorry if I stopped you.
No, that's okay.
The mask and the hearing from where I'm at. So did you say Chase went with you?
Yeah, we went together.
Okay. Who was driving?
I was.
Okay. What were you driving?
His white truck, the white F-250.
And once you, where did you go from the house? You went to?
Just straight to the store.
Okay. And did you stop anywhere in between?
No.
Okay. And your mask is kind of falling down on
Oh.
you.
Yeah, it's a little big for my face. Let's see.
So, what time do you think roughly you got to the Circle K, if you know?
I know it was past midnight. So anywhere between, I think, midnight and like 2 a.m., somewhere in between there.
And you live with Chase Morris.
Mm-hmm.
That's the young man seated over here to my left.
Yeah.
All right. And tell the members of the jury of what you observed of him that night driving to the Circle K.
Oh, on the way there?
Yes, ma'am.
I mean, it's a very, very short ride. So there wasn't really much to observe. Just, like I said, just a night like any other. It was late, so I didn't want to go to the store by myself. That's why I made him go with me.
When you got to the store, what did the two of you do?
We both went in. I went and found whatever I wanted to get. And there were some people in the store. There was, I guess, the lady who works there. She like hires this man. I think he's like, I don't know if he's homeless or whatever, but she hires this guy to like clean up trash outside of the store and take the trash to the dumpster. So him and I guess a couple other people that kind of hang out around the store at night, they were there, and Chase started talking to them, like he always does.
He always does. Explain to the members of the jury what you mean.
Oh, he's just very, very talkative person. He's very, very outgoing, and I'm a little more introverted than he is. So I'm kind of an in and out person, and he likes to talk. So I had finished up my transaction, and I went back out to the truck, and he was still in the store talking to the people there.
Were you trying to get him to come to the truck? Or?
Yeah, I was being a little impatient. Being 7 months pregnant, you don't really have a lot of patience for a lot of things at that point, and I wanted my ice cream and I wanted to go. So I had already made it back out to the truck, and he was still in there talking to the people he'd made friends with, because he can make friends with anybody anywhere. So yeah, he was still in there.
When you guys were first coming into the store, on the truck when you first pulled up, was there anybody out there that Chase interacted with at all that you recall?
I don't think so. No, I'm pretty sure we went straight into the store.
Okay. And then when you left and he was in the store, do you recall how many people were there?
Yeah, I'm pretty sure there was the store clerk, the woman who works there, and then I believe 3 other individuals in the store.
And did you go directly to the truck?
Did I go directly to the truck after leaving? Yeah, I went straight to the truck.
Did you get in the truck?
I did.
What side?
The driver's side.
And windows up, windows down?
They were up when I got in the truck, but when I got in, I rolled the windows down. I'm not sure if I rolled them down specifically to holler at him or if I just rolled them down, but I did, the windows were down, and while I was in the truck, and Chase was still in the store, I was hollering out the window for him to hurry up because my ice cream was melting. And
Now, there's a video surveillance of the store that night.
yeah,
Have you been shown that video?
no, I haven't been shown any of those videos.
Okay. And notice you were listed as a state witness as well as our witness.
Mhm.
Has
I would
my,
object to relevance.
And
as to, has anyone at my office shown you any videos or anything?
The only video I've been shown is of my testimony from when we were interviewed by the police, and that was shown to me only by your office. And I guess somebody from the state yesterday, minutes before all this started, asked me if I would like to see the video or if I had already seen it. And I told them that, I had already received a copy from your office prior to that, but that was the first time anybody had spoken to me about anything.
And that was with whom did you do that interview? Do you remember the officer?
Well, the officer that interviewed me for my testimony back then, I'm not sure of his name, but I would think I would recognize him.
Okay, have you seen him out in the hallway? the last 2 days?
I think so. I thought I saw the lady and the man that came, because it was a woman and a man that came and interviewed us.
And we say interviewed you, that was at your home.
Yes.
Okay. And when you were at your home, and this is shortly after the incident or some period?
Yeah, it wasn't, I think it was like a week later. It definitely wasn't the day after or the day after that. I'm pretty sure it was like a week, at least a week later.
Okay. So I want to follow in sequence. I want to take you back to sitting in the truck.
Okay.
When you roll the windows down, do you remember what you did?
Yeah, I hollered out the window for Chase to hurry up because I was getting impatient.
Okay. Did you turn on any music or anything?
No music. I was just sitting in the truck.
And before Chase comes out of the Circle K, did you drive off anywhere?
No.
Even there?
No, I was just sitting waiting.
Okay. And were there other people at the gas pumps?
Not that I recall. I didn't see it. Like, when I got there, I know there was nobody there. And maybe there could have been somebody pulled up in the time that I was sitting in there and all of this other stuff happened. But
And you say other stuff. What are you talking
the man. Oh, I guess this is my time to explain that.
about?
No.
I'm going to ask questions.
Okay.
You just answer them.
Okay.
Have you ever testified like this in front of people you never met?
No.
You a little nervous?
Yeah, a little bit, but not so much because, there's nothing to be nervous about when you're telling the truth.
So let me ask you this. When you're sitting in the truck, did anything happen before Chase came out of the store?
Yes, when I yelled out the window for Chase to hurry up, there was a man at the gas pump to the front, to the right, to the front right of me, pumping his gas. And immediately after I yelled for Chase to hurry up, I don't want to cuss. Do I just?
The jury's.
I don't want to be
the court will
disrespectful
direct
to
you
the
on that.
court or anything.
Ms. Roylak, you need to say what you remember you heard. And
Okay. Well, this man told me to shut the fuck up and just screamed it at me. And I was really, really caught off guard. I've never been accosted like that or talked to like that in my life, especially by a stranger in the middle of the night at a gas station. But he told me to shut the fuck up. And I was very caught off guard. And I was like, I believe I said, "Who do you think you're talking to?" And I believe I also told him that he needed to shut the F up, which was not probably the smartest thing to do. But, it really upset me and caught me off guard.
Did you get out of the truck?
No, not at that point. I didn't.
Okay. And so where is Mr. Morris at this point?
He was still in the store.
Okay. And so what's going on with this guy?
After he told me to shut the F up and I replied, "Who do you think you're talking to?" that was when he continued to scream at me, called me a stupid bitch, and told me that if I didn't shut the fuck up, that he was going to make me shut the fuck up.
Now, when you heard that, do you remember where Chase was?
Right when that happened, right as he was yelling that is when Chase came out the door. And
do you remember how Chase was reacting or what he did?
yeah, he heard him tell me, he'd heard him call me a stupid bitch and
Overruled, she's testifying from a recollection. Go ahead, ma'am.
yeah, that's when he ran out, when he heard that man, that reply of him screaming at me, and
Did Chase put himself between, now you're still seated up in the truck?
Yes,
The guy's
yes.
not coming over to you?
No, he didn't come towards the truck at me.
Okay, so where was the first place that Chase went?
Chase, he went in between the truck and where the man was standing. He didn't go like straight up to him. He put himself between me and the vehicle and the guy.
Is Chase very protective of you?
Chase is extremely protective of me and our family. And like I said, I was 7 months pregnant at the time. I've never been in a situation like that. And it was very, very, very terrifying.
Okay. So you're seated in the truck and you see Chase. Was he walking out of the store towards this guy?
It wasn't a walk. It wasn't a run. It was a quick, brisk walk because he could tell that I was in distress and he heard, this random man at, 1 o'clock in the morning screaming at his pregnant girlfriend.
Now, did you know this fellow?
No,
Now this particular Circle K you're familiar with because you guys.
I go there every day. I know the lady who works there. I go to that store every single day.
Okay. And so are you familiar with the people that frequent it? And there's some homeless people?
Yeah, there's a lot of homeless people in that area. It's not a safe place to go, especially as a young woman at night.
Okay, so at approximately, at this time, do you know who this person is?
No, I mean, I knew I could see him. I knew, but no, as far as knowing him personally, no, I had no idea who this individual was.
So do you know whether or not he has any weapons or what his intent?
That was my concern, is when somebody threatens you and tells you that they're going to make you be quiet, I mean, you have no idea what that means.
So
he could have had a gun. He could have done, there's, who knows what he could have done. Like, and that I was terrified. It's 1 o'clock in the morning. I'm 7 months pregnant. I have family members who have been through.
You can't talk about.
Okay, that's fine. I understand.
Let's just focus on that night.
I understand.
So on this particular night though, did you ever get out of the truck?
I did. Yes, I did. When I saw, when Chase walked over to the man, he asked him what was going on. And that's when I saw the man move towards Chase. And I tried to jump out of the truck because I was scared.
So
I was scared that something was going to happen to him. So I jumped out.
So now I want to slow this down a little bit. And I want to point out the fact you've not seen the surveillance footage of that store on that night.
I haven't seen any surveillance footage at all.
So, did you ever see Chase actually punch the guy?
No, I didn't. When I saw the.
But you know he did?
Yes.
Okay. And so we're not trying
We're
to
not,
mince
yeah.
words or anything else.
No.
And so when you went to get out of the truck, and you I want to slow that down a little bit. At the point you decided to get out of the truck, why did you get out of the truck at that point?
Because I saw the man move towards Chase like he was going to do something, and I felt like I needed to get out. And I mean, probably wasn't smart either, but it's just instinct.
Did you feel like you may have created that and Chase was now.
I don't feel like I created anything. There's no reason for a man ever to threaten a pregnant woman. That was, yeah.
Right.
It doesn't matter what happens, what is said. There's never any reason to threaten a pregnant woman at a gas station at 1 a.m.
Well, I don't think you have to be pregnant.
I would
but you
object to
go-
counsel testifying.
Sustained.
You need a minute, you let us know, we'll get some water.
I'm sorry.
Don't have to apologize.
It's just,
So I want to make sure we're clear with the jury, the sequence of events.
mhm.
You didn't see the other guy throw a punch or have a knife or anything. You just saw him move.
I just saw him aggressively move towards Chase.
Okay. And did the guy still seem upset?
He was livid. I don't understand from the get-go why this man was so angry.
So how was Chase though? Chase was in
a great mood. He was fine up until he, came out and heard and saw what was going on between me and the individual.
And so when you got out of the car, who did you go to?
I went to Chase.
And where did you see him once you got out of the truck?
Honestly, I don't know. I really didn't look at him. I was scared and I just wanted to get him out of there because I didn't know. He had already threatened me. I didn't know what could have happened.
So let me ask you this, why not just take that big truck and pull around the corner to TPD?
Because I was scared he was going to follow us. I didn't even go home.
Where did you go that night?
We went to a friend's house who didn't live too far away. We drove around. I drove around because I thought I saw a car following us. So, which obviously I didn't, but we drove around for maybe like 10 minutes or so and then went to a friend's house.
But at that night, did you know whether or not this person had gotten back in their car?
No, I didn't, but that was my fear.
And so, how far exactly do you live from that Circle K?
2 blocks.
Take us the route from the Circle K to your house.
Our home is here, and then imagine 2 city blocks, 1, 2, and then this is Monroe Street, and then that's the Circle K. So very, very close. That's why I was scared to go home if he was following us. I didn't want him to know where we lived.
At this point in time, you have no kids? You're pregnant?
No, I was just pregnant, yeah.
And how long did you stay with this friend? And who stayed with him?
I'm sorry?
Did Chase go back to the house?
No, we were together. And we stayed over there for, I believe, just like an hour or 2.
So, and I'm gonna ask you this, why didn't you call 911 when you're on the road? You're in a big truck.
I don't know, to be honest. I probably should have, but I was really shaken up. I was really scared.
And what about when you got to the house? Did you think to call 911?
No, I didn't.
Were you still worried about Chase and what it went down?
I was worried.
Did you?
That probably would have been the smart thing to do. But people don't always make the best decisions when they've been through something like that.
So let me ask you this about, and I don't know the specific date.
Mhm.
Did a female and male officer come knock on your house?
Yeah.
And did you guys let them in?
Yes, we did.
And once you let them in, did you talk to them?
Yes, we did.
Okay. And did you offer to go outside with the male officer?
I did. I offer to go outside with him and speak to him privately.
Okay. And you had a discussion with him, didn't you?
Yes, sir.
And that was Detective or Sergeant now, Dan Copeland?
Mm-hmm.
Is that a yes?
Yes, yes.
This poor young lady in front of you has to take down words, and if you do a uh-huh or
I'm
they-
sorry.
that's okay. She doesn't get enough appreciation, same as the rest of the staff. So you, why would you speak to him? I mean, did he identify himself as an officer?
Yes, he did. And I spoke to him because I felt that it was important that he understood what happened, that this wasn't just some malicious attack against somebody for no reason. That
Give Mr. Rowan some tissues. You may.
Thank you.
Yeah. Ms. James, if you can give Ms. Roylance a moment before you start your cross.
Can you get that video ready?
Can you open your computer?
Ms. Roylance, are you good to go?
Yes, sir. Okay.
On there. Oh, okay.
Ms. Roylance, you're Trace's girlfriend, right?
Yes, ma'am.
The mother of his child,
Yes.
financially dependent on him,
Yes.
wouldn't do anything to get him in trouble, right?
No.
Do everything you need to do to protect him, right?
Yeah, within reason.
Including lie, right?
Are you accusing me of lying?
I am.
Okay. Well, no, absolutely not.
Okay. And you would lie for him because what affects him affects you.
No, I would not lie for him, which I've already
Isn't
stated.
Isn't it true that what affects him affects you?
Yeah, absolutely.
Okay. You stated you recall this incident very clearly. Remember that? That's a question. Do you remember that?
Yes.
All right, but you don't know if you got there between midnight or 2 a.m. Is that correct?
Between those times, yeah. I would say maybe closer to between 1 and 2.
Okay.
But yeah, somewhere in that time frame.
Okay. And you were driving his car, is that right?
Mm-hmm.
He loves that car, doesn't he?
It's his vehicle.
He loves that truck though, doesn't he? Isn't that his baby? That's his truck?
No, I wouldn't say he loves an inanimate object.
Do you love your car? I mean, like,
I don't
know what
have
you
a
mean,
car.
inanimate.
You're being kind of rude.
And as are you, so please just answer
No,
my question,
I'm not.
okay?
Ms. Roylance, please answer the questions. We're not having them back and forth. Ms. James asked.
Okay, so what was your question?
Ms. Roylance, do not speak over me.
I'm sorry, I didn't hear you.
Take your time and answer the question. Ms. James, once you ask the question, nothing extra, please proceed.
My question is, isn't it true that he likes his truck, loves his truck,
Yeah.
whatever? I mean,
Yeah.
you talked about when y'all go inside the store and he's talking with the homeless people outside. Remember that? And you said he was just making friends with them because he's so outgoing. Remember that? But he wasn't just talking to him though, right? He was sort of hassling one of the guys, wasn't he?
No, actually, he offered to buy one of them a lottery ticket.
Oh, I'm talking about before that. Didn't he get mad at one of them when they were outside, or annoyed? Maybe mad's not the word, but annoyed?
I don't believe so.
Okay, so that never happened. That's your testimony?
I'm not saying that never happened. I said I don't believe so.
Okay. Why did he offer to buy the homeless guy a lotto ticket?
Because he's a nice person.
It's not because the homeless guy was begging?
No, he wasn't begging. Actually, the man he thought was homeless, I don't think he was homeless at all. He actually pulled out a stack of money because the lady who runs the gas station pays him to take out the trash and do jobs for them at the store. And so he pulled out a stack of money, and Chase thought that was hilarious. And that's when they started, talking and bantering or whatever, him and the other other people in there.
So you offered to buy somebody a lottery ticket, even though.
And the
he
guy
had
was like,
money?
I don't need that. I've got money.
Let me finish my question and then you answer, okay? Just so that the jury can hear me and then hear you.
All right.
So it's your testimony that you don't remember him being annoyed or anything that the homeless guy was begging?
No,
For money?
I don't remember that. I don't remember anyone begging for anything.
All right, let's talk about outside the store. Can you put the,
I can't get it to open. I don't know how you opened it.
it's your testimony that you've never ever once watched the surveillance footage?
No, I've never seen any surveillance footage from that store, ever.
Okay, great. And we're about to see it. You gotta.
Are you wanting the lights to be dimmed, Ms. James?
Yes, sir. It's just gonna take a second for the application to open and then I will be able to. And I'm fine. I'm just gonna ask some more questions, Judge, but I'm fine with the lights being off, so that I can refer to the video. Ms. Roylance, there should be a laser pointer there next to you. When you need it, just put it on the side, and there's a little button on the top, and that's how you use the laser if you need that.
I'm sorry, what am I doing with
May I
it?
approach the witness?
I don't know.
One moment, I think.
I turned it on, but the light's blinking. It might be dead. No, good? Okay. Just, all right. Top one? Okay.
Hold on, Ms. Roylance.
It's. Here it is. Okay. Was not working. Don't face that.
Go ahead.
Thank you, Jack. When y'all were inside the store, isn't it true that you had to get in between Chase and the guy who I believe you're referring to as the homeless guy?
Was it true I had to get between them?
Yes.
I don't believe so. I don't think I had there. Yeah, no, I don't believe so.
Okay. Right, and just for the record, I'm gonna fast forward to the portion to when Ms. Roylance and the defendant arrive. Let me go back for a second. Oh, hold on, get this suffering. That guy right there, is that the homeless guy that was outside the store?
I mean, it's kind of hard to tell. The video's pretty blurry.
So you don't recognize him at all?
I mean, is there any way you can like move it, like hit play so I can? I think that's the guy that does the trash.
That's the homeless guy, right?
Well, like I said, there was multiple people in there.
And that's one of them, right?
Yeah, that was one of them.
You see that white truck back there, like through the doors? That just pulled up? Is
Mm-hmm.
that y'all's truck or your Chase's
I mean,
truck?
I can't tell from that angle.
You can't tell if that's the truck?
Yeah, it's kind of hard to see through the doors, the top of the doors, but I see Chase walking and me walking, so yeah, that would be our truck.
Where did you just see Chase walk to? Right there. Watch closely.
Yeah, I see to the right on the screen, but what would have been the left of the store?
To the homeless guys, right?
If that's where the homeless guys are standing, then yes.
Is that you?
Yes, that is me.
What are you doing right there?
Probably telling Chase to come on
Why?
because he likes to talk to people and I wanted to go get my ice cream and go home.
And it's your memory that you don't remember him hassling them at all, right?
What did you say?
It's your memory, from your memory, you don't remember him hassling them at all. Is that what you're saying?
No, he didn't hassle anybody.
Okay. What's he putting his hands out like that for? What's he annoyed about? Were you taking too long to get your ice cream or something?
I mean, who can say he was annoyed?
Okay, well, tell us then. What's going on? That body language, what's he doing that for?
I don't understand what you want me to tell
Answer the
you.
question. If you do not have an answer, say I do not know.
I do not know.
Okay.
Please move on.
You remember what he's pointing out the door at and talking for?
No, I do not.
Okay. You would agree he's pretty animated right there though, right?
Yeah, looks like he's saying something.
Does that look like the homeless guy that we saw a little bit earlier?
Yeah.
Okay. So Chase is talking to him here, shaking his hand,
Yeah,
right?
I saw him shake his hand.
Okay. So right there, we kind of see your mouth moving. What are you saying to him?
I'm telling him to come on. I'm telling him to hurry up because I can't tell you how many times we've been stuck in a gas station and or a store or, at a restaurant and he'll just have a conversation with anybody. He's very, very talkative and outgoing and I'm not so much as he is.
Would you agree that you look pretty annoyed right there?
Yeah, I was probably a little bit annoyed.
So you putting your hands on your head, throwing your head back. You see that?
Yeah, I see that. I'm watching the video.
What are you doing right there?
I'm telling him to come on because I'm ready to go.
Are you holding them back from doing something?
No, I'm trying to push him out the door because I'm ready to go.
Okay. I'm rewinding it just a little bit. I'm gonna watch that again. All right, so it's your testimony right there that you're not holding him back from moving forward?
No, I just stated that I was pushing him out the door so we could go.
Okay. All right, and so then he tells you to leave?
No, he didn't tell me to leave. I got tired of trying to get him to come on. So I was like, whatever, talk to your friends, talk to the guy.
Okay.
So eventually you just gotta give up sometimes, you know?
All right, so this whole time he's in the store, you're out in the car, is that right?
Mhm.
Okay. All right, so on direct, you had said that, you know, this being at a Circle K that late at night, it's not safe, right? Like it feels to you that it's not safe.
Yeah. There's a lot of homeless people in that area, like we said, and, you know, being a pregnant woman, it's not a safe place to go by yourself in the middle of the night.
Okay, but you went and sat out in the car by yourself, right?
Mm-hmm.
For a few minutes at least, right?
Yeah.
You did that because you felt safe in your car?
No, I didn't do that because I felt safe in my car. I was just waiting on him.
Do you feel safe in your car?
A car doesn't.
Ms. Rollins, do you feel safe sitting in your car? That's all I'm asking you. When you sit in your car and it's just you in your car, do you feel safe?
I don't.
The witness is trying to answer.
Rollins, please answer the question. If you do not know, say I don't know.
I don't know. It just depends on the situation, I guess.
Okay. But that night, you had no problem sitting in your car in what you say is an unsafe situation, right?
Right. I went inside of my car, yeah.
All right, and this car, is it a newer car or
It's a new car.
a newer
yeah.
car?
It's
Okay,
a
so
new
does it have
truck.
like power windows,
Mm-hmm.
power locks?
Mm-hmm.
Okay. And it's a 4-door, right?
Yes.
Right, and the windows were rolled up when you got into the car, right?
Mm-hmm.
And the doors, do they lock? You know, some cars, they lock automatically. Did it, like when you
No,
shut it, does it lock?
They don't lock automatically, no.
Did you lock the doors?
I mean, I don't remember.
You don't remember if you locked it?
Probably not.
Would you have locked the doors if you felt unsafe?
Yeah, if I felt unsafe, I would have locked the doors, yeah.
Okay, but you never locked the doors that night, right?
No, I didn't unlock the door. No, I didn't lock the door.
All right, when you're hollering out for him to hurry up,
Mm-hmm.
what are you saying?
I believe I just told him to hurry up. And I was ready to go.
Did you yell it?
Yeah, I yelled it.
Was it loud?
It was loud, yeah.
How many times did you yell it? Like a lot of times, like
No,
hurry up? Okay.
no, I just yelled once.
So just one time you yelled hurry up.
And, yeah. I believe I said specifically, hurry up, I'm ready to go, like, let's get out of here.
Okay, so you said more than hurry up.
Yeah, yeah.
Okay. When you yelled it out, did you like open the door a crack to yell it out, or you rolled the window?
I had the windows down.
Did you just have the driver's side window down? Like so
Yes.
that you could yell?
Mm-hmm.
Okay. Did you roll it down all the way or just a little?
It was down all the way.
Okay. All right, so only the driver's side window is down, right? That's what you just told us.
I believe so. I believe so.
Okay.
I don't see why I would have rolled down any of the other windows. But sometimes I do. Sometimes I roll down the front too, because the buttons are next to each other.
Okay.
So the other one could have been open too. I just don't recall.
All right, and you also said that you don't remember seeing anybody like around at the gas pumps. Do you remember that?
Yeah, yeah.
I want to talk about the man that you're saying. You never saw him though, actually, right?
Yeah, I absolutely saw him.
When did you see him?
When he was standing at the gas pump screaming at me.
But you just said that you didn't
very
see,
clearly.
You just said you didn't see anybody though.
No, and other than him.
Okay, so
I mean like the other person who was apparently there, the woman, I didn't see her.
Okay, so you saw him, but you didn't
Yes.
see her.
Yes.
Okay. Does that seem kind of convenient to you?
No, it doesn't seem convenient. It seems like when the man who was screaming at me and cussing at me and threatening me, that's the person I saw. That's the person I paid attention to.
But he didn't start yelling at you right away, right?
Yes, he did. As soon as I yelled out the window for Chase to hurry up, he screamed, "Shut the fuck up" at me.
Okay.
The
But what
first
I'm
thing he
asking though,
said.
Ms. Roylance, is when you first got in the car, you didn't like immediately roll the window down.
No, I sat there for a few minutes. I gave him a few minutes to talk.
Right, but that's what I'm saying. He didn't yell at you right away, right?
No, he yelled at me after I yelled. He told me to shut the fuck up because I yelled.
Okay. But you had been sitting there for a few minutes already.
Yeah.
Nobody said anything to you, right?
No,
You weren't paying attention to him or to anybody, right?
no, not until he screamed at me for the
I
first
understand
time.
that he screamed at you. We're gonna get to that.
Okay.
All right. When he yelled, your testimony is that you could see him. Is that right?
Yes.
Okay. Was he looking at you?
Yes.
He was looking at you.
Yes.
Through the gas pump?
What do you mean through the gas pump?
You said he was pumping gas.
Yeah.
So how was he looking at you if there's a big gas pump right there?
Okay, so here is the whole machine where the gas comes out of.
Mhm.
Here's the man standing, holding the gas pump. You can see, it's very clear because he's not hidden.
Would you agree with me though that the little gas can thing, that you put your gas in, that's at the back of your car, right?
Yeah.
Okay, so if he's standing at the back of his car at a gas pump that's across from you, how would you have seen him through the gas pump?
How would I not? I don't know how to answer that question. Like, I saw him. He was standing there. I could very clearly see the man standing, pumping his gas.
Okay. Are you sure you didn't just hear him yet?
I'm positive.
Okay. So it's your testimony. You saw him
I
and
am
you heard him.
yeah.
Let me finish, okay?
Okay.
You heard him and you saw him, right?
Yes.
Okay. All right, so then you said that when he yelled for y'all to shut, or for you to shut up, or y'all to shut up, that you immediately responded and yelled back at him, right?
Yeah, I did.
Why would you do that if you didn't feel safe?
Just instinct,
Would you agree that might make the situation worse if it's what you're saying it is?
I do agree. I think that was probably not a wise decision on my part to reply to yell back at a man who was already very aggressive and angry for no reason.
How do you know he was aggressive?
Because of the tone of his voice, because of the things he said.
Ms. Roylance.
Please stop. Let Ms. James finish her question. You can respond.
How do you know that he was aggressive if all that he said was shut up?
He said, "Shut the fuck up," first of all. And it was very aggressive. The tone of his voice, the way he screamed it at me, that is aggressive. If somebody were to scream, "Shut the fuck up" at you, that would be aggressive. You would think that was aggressive.
Have you ever told anybody to shut up or shut the fuck up?
Sure.
Okay. You would agree that there's times where you say that to someone, but you're like joking, right?
Yeah, this was not a joke.
I'm not asking that. I'm saying you would agree that there's times when you say that to someone and you're saying it in like a joking tone.
Sure.
Okay.
If it's somebody you know, but that man didn't know me. There was no joking. It wasn't a funny ha ha. It was very clear that this was not a joke or anything like that. Very clear.
All right, so then you yell back at him, right?
Mm-hmm.
And he doesn't come towards you or anything, right?
No, not at that point. He didn't come towards me.
He never came towards you at all.
No, not towards me.
Okay. He didn't go towards anybody until
Yes, he did.
Let me finish. He didn't go towards anybody until he was approached, right?
Yeah, I guess, but
okay.
All Chase did was ask him what was going on. So I'm not allowed to say anything unless you ask a question.
Please stop. No question has been asked. Wait for the question.
Well, no, that was my question. I can't say anything.
You're not here to answer questions. You're not here to ask questions, ma'am.
All right, so you're characterizing this man for us as being aggressive, although he never did anything like to you. He never came towards you. He never stepped away from the gas pump. He never made a movement towards you. He never did anything to you aside from, according to you, say, shut the fuck up.
No, he also threatened me and called me a stupid bitch.
That's a threat?
No, he threatened me. He told me that if I didn't shut up, he was going to make me.
That's what you're telling us though, right?
Yes, that is my testimony.
And you're the only one who heard him say that, right?
Yes, I guess so.
Okay. So if other witnesses at the scene never heard that, then what?
Then they never heard it.
Okay.
But they weren't the ones being accosted. They weren't the ones being in the altercation.
When you yelled, were you loud about it?
When I yelled what?
When you yelled back at him, were you loud?
Yeah, I was loud.
So if other people were around, they would have heard you, right?
I mean, I'm assuming so, but I can't say that for sure. I'm not other people.
If you're telling us that you felt so threatened, right? You started crying. You felt so terrified and so scared and so threatened.
I was.
Did you call 911?
No, I didn't.
Okay. Did you call Chase?
Chase was with me.
No, he wasn't.
What do you?
He was inside the store. I'm talking
He
about.
heard, no, I understand. I'm sorry. No, he heard us. He heard the man yelling at me. He heard either me or the man yelling, one of us.
Okay, but not
which caused him.
Not initially though. The initial, what you're saying was shut the fuck up. You testified that Chase hadn't heard that. He heard you and then him, right?
I'm confused.
Your testimony.
Judge, over to Judge, compound question.
Please clarify, Ms. James.
Your testimony, sorry, Judge. Your testimony was that Chase heard the threat, right? And that's what made him come out the store.
Yes.
Okay. I'm talking about before that. The initial, what you're saying was shut the fuck up.
Mm-hmm.
Okay, that's what I'm talking about.
Yeah.
When you heard that, you testified that you felt threatened. So you yelled back at him.
I didn't necessarily feel threatened until I was actually threatened. It was scary to have somebody yell that at me out of nowhere. I reacted and, yelled back, which I shouldn't have done. I just shouldn't have done that, but I reacted just like anybody else would have.
And the whole time you're in the truck, right?
Yes.
In the safety of your vehicle, right?
What you consider as safety.
Do you not feel safe in a car?
It's not about me feeling safe in a car. If somebody can shoot me through the front windshield, so he could have come up with a tire iron and broken my window.
But he didn't do any of those things.
No, but he didn't, but he could have, and he threatened me. I had no idea what he was going to do.
Okay, Ms. Royland, he never even moved outside of the gas pump.
But he did. He moved towards Chase.
He moved outside of the view of the gas pump. That's what you're saying? That he made enough movement.
I don't know what I don't know what the gas pump moved out in front of the gas pump means.
Well, you were watching.
Yes.
Right? Okay.
But you.
If you were watching Miss Roylands.
Okay.
Okay. If you saw him.
Yes.
And you were watching him.
Yes.
Then you should be able to tell us whether he made enough movement. You're saying he moved, that he did make movement.
He made a movement towards Chase, and that's when I jumped out of the truck.
But never towards you, right? He never threatened you in terms of physically moving towards you or doing something to you, right? He never did that.
No, not physically towards me.
Okay.
Not while I was in the truck.
And he didn't when you were out of the truck, right?
Right.
Okay. You testified that you saw the man move aggressively towards Chase, right?
Yeah.
Remember that? Okay. What did he do?
Like I said, I was watching them. Chase walked up. He asked what was going on. I don't know what was said between them.
I'm just asking what did the man do?
I'm talking.
Okay, and my question was, what did he do? What was
Okay,
movement?
the man moved aggressively towards Chase,
What does-
okay?
What does that
He
mean?
he stepped towards him. I mean, can I stand up and show
Sure.
you? Okay,
Please stand in front of the jury so they can see clearly.
okay. The man is standing here at his gas.
Stand in
pump.
front.
Stand in front of the jury so they can see clearly.
Over here.
In front of the black screen mesh right there. Yep. Please back up, Ms. James. That's fine.
He was standing at the gas pump. Chase walked over, and I don't know what was said between them, but that is when he moved towards him like this. And as soon as I saw him move towards Chase, is when I jumped out of the vehicle. So I didn't see anything after that.
You can sit down, thank you. All right, so like you just showed us, you said he took a step toward them, right?
Yes,
Is this one step?
Just-
2 steps?
I believe it was 2 steps.
2 steps towards them,
I believe so.
okay. Would you agree that we'd be able to see that if that happened?
I don't know.
Okay. What did he do with the gas pump that he was holding and pumping gas with?
He let go of it.
He dropped the gas pump on the ground
No, the gas pump was in his car.
and he was pumping gas with it, right?
Yeah,
And you're saying he just let go of the gas and took 2 steps towards Chase?
yes.
But if we don't see that on the video, then what? Then maybe he didn't do that?
I don't understand.
If we don't see on the video him ever make any movement outside of that, would
Do
you agree
you-
that a
do
gas
you-
pump is not that,
Hold on.
would you agree that a gas pump is not that large? or that-
No, I won't. I don't agree to that. A gas pump is pretty big.
Okay. But you could still see him though.
Yeah,
Okay.
because of where my vehicle was positioned, I could see everything perfectly. I wasn't behind the gas pump. The gas pump is like this. My truck was here, so I can see either side of the gas pump perfect.
All right, you said, that you didn't drive to TPD because you were scared that he was going to follow you. Do you remember that?
Yes, I do.
Okay. You were scared of that even though he never, not one single time, did any movement come towards you. He never did anything to you.
Not to me, but to the person I was with, to the father of my child.
I know he's the father of your child.
He had
We know.
already threatened me. He had already aggressively moved towards my boyfriend, which scared me so much that I felt like I had to put myself in harm's way to get out of the car and put myself between them or save him.
Okay, so Ms. Royland, it scared you so much that Mr. Thompson moved towards Chase, but it didn't scare you that Chase came rushing at him?
Chase didn't come rushing at him. Chase came rushing out of the door to check on me and see what was going on. He didn't rush at that man.
He came to check on you.
Yes.
Okay, he never stops once at your car, does he? He doesn't come to the car to check on you.
What, I was in the vehicle. The man that was accosting me was outside of the vehicle. He put himself between me and the man.
No. I'm saying you just said that Chase did not rush from the front of the store to where Mr. Thompson was.
No, I didn't. I said, he did not rush to Mr. Thompson. He rushed to the scene. He rushed to where this was going on. He didn't rush to Mr. Thompson. He rushed out there to see what was going on.
But not once does he stop at the car that you're sitting in to check on you though, right?
Why? No.
Okay.
Why would he do that?
Because you're sitting in the car, right?
Objection argumentative.
You're just,
Were you sitting in the car?
you know, I was sitting in the car. Why do I have to answer that
Objection.
again?
Okay. The friend, who was that? The friend's house you went to, who was the friend?
His name was John.
John what?
John Moore. John Moore.
What's
Sorry.
his address?
I don't know.
Where does he live?
Off of 5th Avenue.
What's his phone number?
I don't know.
How do you know him?
He is a friend.
A longtime friend or what?
No, not a longtime friend of mine,
Of
of
Mr.
Chase's.
Morris's? Okay.
Yeah, so a mutual friend of both of ours, though.
So instead of going to the police station, you go to his house.
Yes,
Okay.
after we drove around for a little while,
What were y'all doing when you were driving around?
making sure that that man wasn't following us.
Were you talking about what story you were gonna say in court? Or if he got in trouble?
No, I wasn't. At that point, I was so shooken up and terrified, all I could do was cry. I was scared that he was following us, so I drove around in circles through that back neighborhood for 20, 30 minutes.
Instead of just going to TPD? Which was right next to it.
Yeah.
Okay.
Like I said, people don't always make the smartest decisions when they've been through something traumatic.
The 20 to 30 minutes that you're driving around in that neighborhood, you never called 911 in that 20 to 30 minutes, right?
No, I never called 911.
But you'd agree, had you, they would have been able to come help you, right? Since you were so scared?
It would have been a good idea. Yeah. But like I said, traumatic incidences, they cloud judgment sometimes,
Okay, so it's traumatic that someone told you to shut up?
No, it's traumatic that I was 7 months pregnant at a gas station at 1 a.m. and a random man who I do not know threatened me. And in turn threatened my unborn child.
Would you agree that
When someone tells you that they are going to make you, I wasn't finished.
I'm done with my question.
Well, I'm not finished.
Okay.
When somebody tells you that they are going to make you,
Please stop.
I'm done with that question, Judge. I'm
Judge,
moving on.
I would ask that the witness be allowed to answer and finish her answer to the question.
Mr. Roylance, you can finish.
I don't even know what I was saying anymore, so I guess it doesn't really matter. It doesn't really matter anything.
Would you agree that had you called 911, they would have been able to come to where you were, come find you?
That's how 911 works, yeah.
Okay. And they would have been able to help you, right?
Objection, asked and answered.
Overruled.
They would have been able to help you since you were so scared, right? Had you called them?
Yeah.
Okay.
But they would have been able to help me.
Okay. But also had you called them, you would have had to explain a story of what happened, right?
And it would have been the exact same story you're hearing right now.
But 20 minutes after this happened was not enough time for y'all to concoct this.
That you're accusing me.
I'm not done.
You're not done accusing me of lying?
Roylance, please wait for the question.
20 minutes was not enough time
Unbelievable.
for y'all to get your story straight, was it?
What?
You don't need to look at him. You can look
I
at
didn't look at him. I'm looking at you because this is insane. You are sitting here accusing me of lying over and over and over again. And I'm sick of it. It is not fair.
Okay, I'm not asking a question.
Judge, could we have a little bit?
We're going to take a brief recess. Members of the jury, the bailiff is going to leave you out. We'll resume with the testimony of Ms. Roylance in 5 minutes. Please be seated.
Judge, I want to remind the court, there's another judge on a death case. I don't know if you can communicate with Judge Allman. And Ms. Keppel is coordinating that.
This is the point where you need to take your.
Not
Not
yet,
yet.
Judge, I'm letting the court know. I don't know if you guys have IM between each other.
No.
In Pinellas County, 20-something years, we talk to each other during.
If anything, that would probably be a distraction.
Judge, I'm going to object to this entire line of cross-examination. I've sat here and I've been quiet. I've listened to this cross-examination. This witness is getting badgered at this point. Judge, this young lady's upset. She's been honest about her mistakes and about how she could have made different decisions. And I got to hand it to Ms. James. She is a good prosecutor and a good cross-examiner, but at some point, Judge, the emotional response she's eliciting from this witness is severely upset. She's distraught. Her face is red. She's crying. She's sobbing. And the state is reacting to her with disrespect for the witness stand. And I have no problem with control of cross-examination. I have no problem with controlling the witness. I have a problem with flippant, childish responses to try to elicit a response from the witness. I don't think that's fair. I think it violates my client's due process. More importantly, I think it violates the citizen of the United States due process rights and respect. What happened to professional decorum? So,
Ms. James, how much further do you have to the cross-examination?
I'm not sure, Judge. I need to go through the surveillance of the outdoors with her, which is only a few minutes, but I need to go through that with her. And then we have the jail call as well. But after that, I don't believe I have that much more, depending on what she says.
If you believe the witness is being non-responsive, please ask for me to direct her to answer, but do not engage with her. Do not send any flippant responses her way.
Yes, sir.
Mr. Pumphrey, do you need a bathroom break? Mr. Morris, do you need a bathroom break?
I could use one. Am I allowed to do
You can
that?
sit down, Ms. Roylance, please. Use the bathroom as well.
Judge, can you advise her not to talk to anybody or
Correct. Ms. Roylance, do not speak to anyone until your testimony is concluded.
You didn't touch this yet.
Judge, is it okay if the young lady in the back is Mr. Morris's mom? Is it okay if she goes with her?
As long as they're not talking about the case in any way.
Okay, fine.
Yeah. And then I just had this for closing. Oh, yeah. So, and at any point in his interview, in the body cam, in the witness, you know?
Right.
So you need a break? Yep, go ahead. Go ahead.
Judge, would you like me to give you a high sign or something?
Yes.
How would you like me to do that?
We're in the middle of the examination. Now give the signal and then we'll take the break as needed. Are you the scheduler who keeps everyone where they need to be?
Always. Everyone.
Hopefully 2 days of trial is not keeping you away from your emails and phone calls.
Keeping me away from my normal job. I've got 2 attorneys on standby that are letting me know when.
Okay.
There's 1 or 2 cases left until Almond's gonna call them.
Okay.
Like I said, I think Don can probably something not calling just real quick. I think it's just a phone call, I believe. I don't think they're actually gonna stay on the meeting.
Oh, what? Mr. Tolman, but it's a private thing. They're not in person. It's one of their friends is in Miami.
What did she remember?
You don't?
No,
Yours is about
Good, that's
starting
all.
with
I'm gonna, chaos is right. Can you cover me?
No, that's. It's given it to me. Just.
Yes,
Oh, it's to me. It's to me.
they're just up there.
That's why I said, you just take mine.
Good time for the call.
Just can we be excused briefly?
Before we bring the jury back, you go ahead and do the call.
Just, we're gonna step out the hallway.
That's fine. You can go out there. Ms. Royal, you can come back and take the witness stand. You can just sit here.
I don't even know if you need to. What do I find out?
Your Honor, I'd like to apologize for speaking over you earlier.
You're fine. Done, people bring your testimony, they get emotional. You need to take a moment. Okay.
Bless you.
defense, I think, asked her, it was when, on direct, when they were talking about, the police showing up at the house, and she agreed to talk to them. And I just want to make sure I heard her say that, or the defense say that Chase agreed to speak with them also. I think the question was asked, was he there, and did he agree to speak with them, and I'm pretty sure she said, yeah.
I would have asked about my client on the ghost.
My court reporter can read back the testimony.
That's why I'm making sure, because I don't want it.
As this could go to the right to remain silent, I state tread carefully.
I am, Judge, want to make sure you know what I heard. It was on direct examination, it was, yes, please, before we don't have to tell me right now, but just before he testifies. I just want to know if the defense asked her whether he agreed to talk to law enforcement when we got to the house. Yes. No, I can continue with her, I just. On the next break? Yeah, I just at some point want to know.
I can tell you, it's no surprise he's gonna take us in and ask him.
You want me to get off the record and look for it, or?
I don't want you to do that. He's gonna take a stand, you can ask him.
We can keep going, I'm ready, Judge.
Let's get this thing going.
Let's bring the jury in. Jury in, go for it. Everyone be seated. James, you can continue with your examination.
Thank you, Judge. Ms. Roylance, you didn't see Mr. Thompson with a gun, correct?
No.
You didn't, I'm sorry,
No.
and you didn't see him with a knife?
No.
You didn't see him with any weapon?
No.
You didn't see him ball his fist up?
No.
You didn't see him raise a fist?
No.
Your testimony is the only thing you saw him do is take like a step or 2 steps forward, right?
Yes.
On direct, the defense brought up that the police came over to the house. They came to you, right? You didn't go to them?
No.
And your testimony today, you want to make sure that you seal the deal, right?
What?
You remember saying that?
No, I don't remember saying that.
Judge, if she could orient the witness to the time and date of the statement.
Ms. James, please do that.
Ms. Roylance, do you remember speaking on the phone with Mr. Morris last night at 8:30 p.m.?
Yeah.
Okay, you remember telling him you're going to kill it today?
Yeah.
You're going to kill it today, right?
Yeah.
You remember telling him you're going to seal the deal with your testimony, right?
I don't remember that as exact words, but yeah, that was me encouraging him that we were gonna get him home today. Absolutely. Because I feel that my testimony should carry some weight.
Judge, is there another question?
James, is your examination concluded?
No, sir, I guess I need to refresh your memory as to what she said. She said she doesn't remember saying she was going to seal the deal with the testimony today.
Okay, sure, I don't understand what the relevance is.
Hold on, Ms. Rollins. Are you attempting to refresh your recollection with the audio recording?
Yes, sir.
Judge, she's agreed that if she said it, she said it. There's no.
I'm not sure there's anything to refresh at this point unless you're using it for another purpose.
So now she's agreeing that she said it, because before she didn't remember.
I don't remember if every single exact word that was said on that phone call. I was encouraging him that we were going to hopefully win today and get him home. That's what I was doing.
I don't have any further questions for her.
complaint during the trial?
Judge, I may call her in rebuttal, so.
So she's already been released.
Right, Mr. Roylance, the state might recall you as part of the rebuttal. Please step outside until the testimony is closed. You may proceed.
Mr. Morris, can you please introduce yourself to these people you've been staring at for the last 2 days?
I'm Chase Morris from Tallahassee, Florida.
Mr. Morris, you've been sitting here throughout all of this and heard everything, so you know what we're talking about, right?
Yes, sir. It's fun.
And on the night of October 4th, 2019, what caused you to sprint out of the Circle K over in front of the truck?
What I heard coming out of the store was a guy yelling at my pregnant girlfriend. I mean, her sitting in the truck or not, she was, being yelled at and threatened as in that, if she didn't shut up, that he was going to make her. And at that point, me hearing that, I beelined to him. And
Let me slow you down there. So was there any particular individual that night that caused you to accelerate to that area of the parking or the gas pumps?
Any particular individual, he did.
Who is he?
I'm not sure of his name, Thomas.
Mr. Tola Thompson?
Yeah, Thompson, yes, sir.
And that's the gentleman who testified here in court?
Yes, sir, that's the man that was here first, yes, sir.
That's the fellow that had the wrist?
Yes, that's the fellow that I struck, yes,
So
sir.
at this point, when you're sprinting out, do you know this guy?
No, sir, not at all.
And was your sense to cause you to start getting over in that area that quickly? What were you reacting to? Was it just your nature, just to physically exert yourself for no reason?
No, sir, not at all. I reacted to something that I heard that was very violent, very aggressive, that I felt, I felt threatened by. I felt that I needed to put myself in between.
And so, now, was your girlfriend was seated in the truck?
Yes, sir, yes, sir.
Why was she in danger then?
I'm not sure I understand.
All right, but you haven't done this a whole lot, have you?
So now we're
I've
just
never done
relevant.
this before. And sometimes it takes me a second to understand what you're saying.
Okay, that's fine. So, now this truck, that's your truck, isn't it? It's the one that everybody's been talking about?
Yeah, that's our truck. It's my truck, but we I let her use it when she needs it, and, I can't afford to get her own vehicle yet.
All right, what kind of work do you do?
Sir,
What kind of work do you do for a living?
I don't know.
That's your relevance.
Overall. Let me ask that again.
Yes, sir.
What type of, so the jury can hear, what type of work do you do?
I own a roofing company. I started when I was 22.
Objection relevance?
And they're going good for about 9, 10 years, something like that now. And it's ups and downs, but it's been getting good. Got a lot of work from
About objection
Hurricane Michael and
answering.
Sally.
Relevant?
It's all in Trouble City.
Already allowed the testimony. Once he's finished speaking, the next question will occur.
And I got an office off of 331 that I just got it's right on the main highway. It's storefront, so it's proud of it.
Now let me ask you a question. Do you have employees that work for you?
Object to relevance?
Yes, sir, I do.
Staying at this point, stop speaking, Mr. Morris, once the objection is sustained.
Yes, sir, yes, sir.
Judge, I've got a point I'm gonna make that I'll tie into this that relates to Mr. Morris. And this
So we get to the point.
do you employ people of color?
Yes, sir, we employ African American and Hispanics and Caucasians.
Okay.
And most of them are Hispanic.
And do you personally identify as white?
Yes, sir.
And African American people you identify as black?
Yes, sir.
Okay. And so, have you, in the 10 years that color, or employees of color, have you been sued for discrimination?
I've never had a complaint. I've never had a complaint against my license.
Oh, Mr. Morris, if you see my hand go up like that, just freeze.
Okay, yes, sir.
Okay. And there's a little bit of delay and there's a buffer between you and the judge. When the judge speaks, you have an objection, you gotta stop.
Yes, sir. I'm sorry. Just nervous and just stuff.
So, Mr. Morris, when you were over there, there's a section, and you've seen the video, where you can't see. That's no camera angle that.
That's correct. Yes, sir.
And you see you pacing a little bit and come back over.
Yes.
Why were you doing that? What was going on?
I was contemplating what his next move was gonna be. His demeanor was so aggressive, I didn't know what, I mean, I know it doesn't show much in that tape, but what it was to me, it was,
Mr. Morris, you didn't know this person? And so, what's going on in your mind after what you've heard from the minute that started you to kind of sprint over?
I'm sorry, can you repeat that?
Morris, you need some tissue?
I'm okay, I got some of it, thank you, Judge.
Mr. Morris, it's been stressful for you.
Very stressful. I mean, it's just,
Just give it a moment, Mr. Pumphrey, and resume your examination.
ready.
Good. Mr. Morris, as you're sprinting out there, what's running through your mind about this person? You don't know him, do you?
There's no telling, I mean, there's no telling what
would happen to you?
I mean, I know it was gonna happen, I didn't know it was gonna happen to me, but I wouldn't let it happen to her.
What if he pulled out a gun?
That's what I'm saying, I would
object to speculation.
I would have approached him anyways.
Probably. Mr. Morris, I don't think he's here.
Mr. Morris, once an objection is made, please stop speaking, wait for the ruling.
I'm sorry, I didn't hear it.
Your attorney will ask you the next question. Go ahead.
When you were in that blind spot, and you've seen the video, what was going through your mind? What was going through your mind and what happened? Explain to the members of the jury, not me. Tell them.
What was going through my mind was, I mean, what could happen? What is he about to do?
Were you upset?
Yeah.
Were you upset?
Yeah.
Were you
I'm
scared?
I don't get scared. I get scared, but like it turns into defense.
Well, I want to talk about this night.
Yes, sir.
Behind that gas.
Yes, I was, I mean, definitely by the way he was talking, I mean, there's no telling, it's FAMU homecoming, man, and there's no telling, FAMU homecoming.
Okay. And how long have you lived in Tallahassee?
My whole life, I was born and raised here.
So, did you punch Mr. Tola?
Yes, sir. I punched him in his mouth.
Okay. Did you punch him square in his mouth?
Yeah, right.
Why? He said.
Because I felt like I needed to, man. What do you mean?
Well, did he do anything to cause you to do that, or did you just randomly hit him?
Yeah, I just picked some guy out of a crowd and hit him.
Okay, well, this isn't a time to be.
I'm sorry. Yes, sir. I'm sorry.
There's serious stuff here.
Yes, sir.
Oh. Get out of yourself.
I'm sorry.
So when you ran across the parking lot, I noticed that you didn't hit the man when you ran over.
No, sir. I went up to went over to the snare where it was going down and to ask to see what was going on, what to further, I guess, my investigation in my head.
You don't do many investigations, do you?
That's it.
All right. Well, were you trying to hit him, or did you react to something?
I reacted to his body language and his aggressiveness, in my opinion. Him, the way he was talking was, I don't know how, I mean, just aggressive, and like his body language, it definitely, he he kind of moved to me. I don't think he really like took 2 steps like Sierra said. It was more like his, like maybe a step and like kind of like, it was enough to make me think I needed to strike first. I mean, and that's
So
what I did.
You believed you were about to be injured or?
I believe it was about to, something was about to happen.
Okay.
I mean,
Did you pick up a pipe?
pipe? No, sir.
Did you pick up a baseball bat?
Oh, no, sir.
So you used non-lethal force?
Yes. I mean, I wasn't trying to hurt the man. If I was trying to hurt the man, I would have, or if it would have been a malicious attack, I would have jumped on him or something. I mean,
Well,
I really.
members of the jury heard you and your daddy talking on the phone.
Yeah.
And the,
I didn't, go ahead.
be patient. So, did you go after him and get on top of him?
No, sir.
Did you hit him more than once?
No, sir.
The minute he went backwards, did you go over and try to jump on him?
No, sir. I stepped back. I mean, I hit him and he went down. The threat was eliminated.
You stepped back,
Yes, sir.
even though you popped him in the mouth. Where in the mouth?
Yes, sir. I
Did-
stepped back,
Were you
right?
still scared?
Yes. I mean,
Okay, so now tell me, the jury, not
I'm
me.
sorry. Yes, I was still scared. There's no telling
Tell-
what, after you get hit, what you would do.
Jason, you gotta slow down. All right.
I'm
Take a deep
sorry.
breath. All right. We need to slow this down for the jurors.
I'm fine. It's just a lot. Trying to defend myself.
Were you still scared when you went to get into your truck?
For sure.
Okay. And
I
what
mean,
were
by
you
that-
thinking?
I mean, at that point, he has enough time to, I mean, he didn't get knocked out or anything, so he was getting back up. So there's enough time for him to grab anything if he had something, you know,
So
to,
what-
to be able to, you know.
So you didn't advance on him, he advanced on you.
He got up, I turned around and got in my truck.
Let me back up. just a
Okay.
minute. At the point in time where you reacted and threw the punch,
Yes, sir.
okay, were you advancing on him or was he advancing on you?
In my
threw the
opinion, he
punch?
advanced to me. Well, I mean, I'm walking up to him, so I'm talking. I'm right here in around him, you know, because I hear the way what he had said, so I'm over there. And then his progression made me progress. I mean, it could have been my progression that made him progress. I don't know. Just by me being over there, you know, like me being up there, it could have made him.
Now,
You know, I don't know.
if you're wanting to hurt somebody, you gotta hurt them, don't you?
Well, yeah.
Okay.
I can
Were
definitely
you
hurt
trying to
somebody.
hurt the guy or did you just react?
No, sir.
And
I mean, did you see his face? I mean, I didn't. His wrist. That's, you know.
well, looking back on it now, though, you can see how things were miscommunicated or misunderstood possibly.
For sure.
And does it make you feel good about what you did or anything? Or
Hell
you feel
no.
bad for Mr. Tola Thompson?
For sure. I definitely feel bad, but I mean, then again, I did what I felt necessary at that time. I mean, I was with my mother of my child, you know.
Is this
She's
your first-
pregnant. I miss my little
Is
boy.
this your first child?
Okay, I don't object to relevant.
I was saying, Mr. Pumphrey, as it relates to the testimony about the child,
This
it
is
needs to
so
remain
much.
focused and directed. Take your time, Mr. Morris, to correct yourself.
I'm ready. Hold on.
He indicated he's ready, Mr. Pumphrey.
So he's blowing his nose.
I'm ready.
Now, as you sit before this jury, are you proud of what you did?
No, sir. I mean, I'm sitting in a courtroom like a convict.
Did you,
And I'm not.
after the punch, after the punch, when y'all got back in the car, how was Sierra acting? How were you feeling?
I mean, I was being quiet because she was hysterical.
And where did you guys go from there?
My buddy John Moore, I played football with him at Child's.
Slow that down.
I'm sorry, John Moore. He lives Fifth Avenue.
John, John, Moore,
John Moore.
Moore.
Yes, yes.
Do you know how to spell his last name?
Moore. That's how you spell it.
And where did y'all go?
We went to Child's house. Oh, where did we get? We went to his house.
His house.
Yes.
Tell the members of the jury where.
I'm sorry, I feel comfortable
apologize.
talking to you. We went to his house off of Fifth Avenue
All right, and why did you go there?
because we were trying to avoid being followed if we were going to be followed. I mean, she was driving and I was just,
Was it I'm gonna ask
I
you,
kind of do what she says sometimes.
I want to ask you two questions. Was it due of the fear of getting in trouble or the fear of the unknown of somebody following?
It's probably the fear of unknown. Or probably no, it is the fear of unknown. Yeah.
And there was,
What's behind you. You don't know what. I mean, it's Tallahassee, like I said, family homecoming. You don't know who's there. I mean, it's family homecoming.
so, Mr. Morris, as you've seen all this play out and everything else, you can understand why Mr. Toller would be upset.
I'm sorry, say that one more time.
You would understand why Mr. Toller would be upset.
Yes, sir. For sure. I mean, I wouldn't wish that he'd have to have surgery on his hand. He didn't. I mean, at that point in time, I mean, don't deserve to have that kind of damage done, right? I mean,
but let me ask you this. But at the time, you saw the man get up,
right,
and you were pulling out,
right, and I'd already had struck him, so I didn't know what he's capable of or what he would do.
And so that's what kept y'all from going to the house around the
For
corner.
sure. I mean, I live literally like I could drive a golf ball there or chip, maybe 9-iron a golf ball there.
Okay, well, I don't compute that. I'm not going to ask the jury for that. And that gets into too depth of business and everything else. But
yes, sir.
is there?
I'm sorry.
And Sierra, you talked to her on the phone. You're still boyfriend and girlfriend.
Yeah, I love her very much. She's the mother of my child. I'd do anything for her and him.
May I have just a moment, John?
Okay.
No further questions, tender the witness.
Cross exam.
No, I can put it in.
James, please take your time in between questions.
Yes, sir.
You may proceed when you're ready.
Thank you. Mr. Morris, is this funny to you?
Is what happened to Mr. Thompson funny?
Well,
No,
all
ma'am,
of it.
No, none of this is funny.
Why do you keep laughing? It's like
I
a
guess
nervous laughter, or do you think it's
It's-
funny?
No, it's definitely a nervous, like at the end of a cry laugh, I guess. I don't think I'm laughing, actually. I didn't know I was.
Well, you remember the defense having to tell you this is a serious thing, right?
I don't recall what he had asked me or what I had responded, how I responded. I'm sorry.
But you do understand that
This is
Mr.
not a
Thompson
laugh.
was seriously injured by you. You understand that, right?
Yes, ma'am. Of course, I understand that. Not here to dispute
What
that.
is, you keep bringing up that it was FAMU homecoming. What's so scary to you about FAMU homecoming?
I mean, I'm from Tallahassee, and so I know family homecoming is probably the highest arrest in, every year, probably during that time. There's a lot of bad stuff goes on in family homecoming.
And why is that?
Um,
Because of the type of people?
no, I don't know. Statistically, I don't know.
Okay, so to you, FAMU homecoming is just scary. It doesn't have anything to do with the fact that it's a lot of Black people?
No, ma'am.
I'm not joking.
I understand that, but I see where you're going with that. Yes, ma'am.
Okay. Well, you keep bringing it up like it's scary. So I'm just trying to understand is FSU homecoming scary to you?
Not as bad, no, ma'am. I think a lot of people would agree
I
with me
didn't
on
ask
that.
a question.
I was finishing my statement. Yes, ma'am.
Had you had anything to drink that night?
No, ma'am.
Okay. Why was Sierra driving your car, not you?
She always drives. She drives, I drive. It's kind of we share the car.
Mm.
She likes to drive because she doesn't really get to drive a lot because I'm always working. So she loves to drive it. I don't blame her.
You said you were nervous. You remember that?
Yes, ma'am, I do.
Are you nervous because you've sat here this whole time?
I'm nervous because I have a bunch of
Hold on,
people
I'm not
looking
done
at
yet.
me.
Hold on 1 second. Okay, just
Yes,
give me a
ma'am.
minute. Are you nervous because you've been sitting here this whole time, right?
I've been sitting there the whole time, yes, ma'am.
Okay, hearing what everybody has to say, right?
Yes, ma'am.
Are you nervous because you and Sierra are the only two people telling the story?
No, ma'am.
Okay. Are you nervous because the evidence doesn't match what you're saying?
That's not accurate, and I feel like I'm nervous because I have a bunch of people staring at me. And this is something I've never done before, you know.
Are you nervous because you did something really bad and now you had to basically come up with an excuse for why you did it?
No, ma'am, I'm not coming up with an excuse. I'm nervous probably because it depends on whether I'm free or not. And my boy needs me.
All right, I'll ask my question.
Yes, yes, ma'am.
All right, I want to go to the video. Let's talk about that.
Says no records found.
Just wait, Mr. Morris.
Okay, yes, sir.
Remember when we were watching the inside of the store footage when Miss Roylance was testifying?
Yes, ma'am.
And it was clear that you kind of like to run your mouth a little bit, don't you?
Sometimes, yes, ma'am.
Yeah.
As in, like, what do you mean by run my mouth? Because you kind of say it like it's derogatory, like I've run my mouth as in talking trash to somebody or something. Is that what you're saying, ma'am?
You already answered. That's okay. Thank you.
Okay.
Right, and for the record, I'm just going to fast forward to the relevant part.
Judge, is there a reason we're using this? Is it refreshing recollection?
This is my cross, so this is my cross-examination,
Hold
Judge.
on one moment. Mr. Pumphrey, please stop speaking. Members of the jury, we're going to excuse you for a few moments and bring you back. Please be seated. Pumphrey, the video is in evidence. What exactly is the objection?
Judge, and I agree it's in evidence. I just don't know why the prosecutor is just stopping and playing with the video. She's on cross-examination. If she's got an impeachment issue, if that's why she did that, I'd just like to know the purpose of why she's presenting any evidence.
James?
Because it's my cross, and the entire direct talked about what he did outside, and I have questions specifically about certain points in the video, just like I did with Ms. Roylance and Mr. Thompson and Ms. Wiggins. It wasn't an issue with any other witness, but now it's an issue with him.
So the direct testimony does not match what's on the video.
Correct, and I have questions about that.
On that basis, then, Mr. Pumphrey, there's a reason to use the video. Is
That's
there
all I
anything
need.
else?
All I needed, Judge, but I will put on the record that just because it's your cross, we all still apply the rules of evidence. So those kind of comments are unnecessary, they're unprofessional, they're not needed, and my fuse is getting short.
We don't need the back and forth. Please bring the jurors back.
Okay, thank you.
Judge, may I ask my questions from the council table, just so I can use the video?
If that's going to be easier to get through the video.
Yes, sir, I think it will be.
Jury entering the courtroom.
Yes, ma'am.
Everyone can be seated. You can continue with your examination, Ms. James.
Thank you, Judge. I'm just fast forwarding to get to the portion. Mr. Morris, you see yourself on the video, right?
Yes,
Okay.
ma'am. That is after I heard that man yelling.
Okay. And you see the car, right?
Yes, ma'am.
Why
I
don't
see
you
this
just,
car.
why don't you just get in the car and leave?
Because I don't know, my brain didn't think that way.
So your brain told you to go and confront somebody when you could have just gotten in the car and left?
I mean, to a degree, that's what my brain thought. I mean, I hear someone yelling very violently towards the mother of my child that's pregnant. I'm gonna pursue. I'm not the kind of guy to run.
Okay, but the mother of your child who's pregnant is sitting in the car that you're about to run past, right?
I got that. Yes, ma'am. I'm putting myself in between him and her.
In
I mean,
between
I
him and-
understand what you might have done, but that's not what I did.
I didn't say that. I
Okay,
didn't say
well,
that.
it sounds like that.
Mr.
In
Morris,
between-
yeah, hold on.
Yes, sir.
While you
Sorry.
respond to the question that you're being asked, you don't need to direct any comments to Ms. James. Please wait for the next question.
Yes, sir. Sorry.
Go ahead.
You're saying that you put yourself in between Miss Roylance and Mr. Thompson, but would you agree that Miss Roylance is in the safety of your truck, right?
Depending on what, I don't know. I don't know.
Okay, so you thought in that moment, it's better to go confront this person than just get in the car and leave?
At that time, yes, ma'am.
Does that make any sense to you?
It did at that time, and truthfully, that's the kind of person I am. I feel like I don't think I would.
The type of person that needs to go confront somebody?
No, that would defend his woman and his kid.
Defend what though? She's in the car.
The way he was talking made me feel that way.
But he didn't make any movements towards her, right?
At this point in time, I'm running towards something that I've heard.
And you didn't even know that he was back there, did you?
No, yeah, I could see him.
Did you know Miss Wiggins was back there? Or did you just know you heard shouting?
I didn't see her car. My truck's too big.
Okay. Okay, you see yourself, right?
Yes, yes, ma'am.
Okay, so I'm gonna rewind it just a little bit. So you can see what you just did. 1 second. All right, watch closely for me, okay?
Okay.
All right, see how you step right there?
Yeah, that's me picking up someone in my peripherals to make sure that's not the threat. Even though, coming out of the situation, looking to make sure nothing's behind me. checking my peripherals as I'm pursuing a situation.
So
It's
when
kind of
you,
like natural.
so when you stop and turn,
Mhm.
why don't you just turn and get back in the car? At this
Like
point,
like I said, I was, I'm not sure. My brain didn't think that way that night. I
okay?
didn't
And at
think-
this
I don't think
point,
I would ever think that way. I don't know. I don't know.
I know, and at this point, he's not doing anything to you, right? Because you're way over there.
No, he's very aggressive at this point. There's no audio. I mean, he's definitely yelling. I mean, he's been like aggressive the whole, like when I come out here and the way he was talking, I mean, at this point in time, I don't remember if he was talking right then where I was standing. I mean, this is a very fast thing. I mean, there's probably
We can
6 or
slow it down
7
a little.
words.
I can slow it down some. And I'll do that when I keep
I'm
playing
saying
it.
when when something like this
Okay.
happens, it's very fast.
I
It's
see.
not like, hey, let me think. Should I get in my car? Should I do this? Should I do that? You don't have time to think like that. It's reaction. It's based on what your instincts as a human are.
All because he's yelling?
Yes, ma'am. The way he was yelling it, yes.
So I just want to make sure I'm clear. All he's doing is yelling. He's not making a move towards you at this point, right?
He is threatening with his words very, very heavily.
And you agree you could have just gotten back in that truck.
My body could have definitely turned around and gotten that truck. Yes.
Okay. And you agree, Miss Roylance, she's nowhere near you, right?
She's about 10 feet from me.
She's in the car, right?
That's 10 feet from me.
In the car?
Yes,
Okay, but yet you're supposedly protecting her?
for sure.
Okay.
Like I said, if he'd have had a gun, what if he'd have pulled that out of his pocket? Because I had already pursued it that far.
But he didn't have a gun though, did he?
But I'm saying, what if?
Were you thinking about that when you ran up to him?
For sure.
Then why did you run up to him?
Because that's who I am. I don't run from stuff like that. I'm sorry.
Would you agree that he was behind a gas pump before you even got over there?
He was kind of to the side of the gas pump. Like, see how there's an angle on 1 to 5?
Yeah.
He's standing outside of the gas pump. You just can't tell from that angle.
Towards the back of his car, like where the gas
To
pump
the
is,
front of the
right?
car.
The
To the front
furthest
of the
part
car. To the front of the car.
Okay, pumping his gas.
No, I don't think he was pumping at that time. I'm not sure.
So if Ms.
I don't
Roylance,
know.
you don't know, okay. All right. But at this point, he's done nothing to you aside from words, is what you're saying.
At this point where I'm standing right there, yes, I don't think he has made his approach towards me yet. I think as I get closer, that's when his step comes, or his body language, his aggression.
Would you-
I think.
Would you agree that you
Mhm.
confronted him? Right?
Depending on what you would say confronted, because he yelled saying, shut the fuck up as a confrontation. So I think he confronted us as us first. for
Mr.
sure.
Morris, did he physically confront you, yes or no?
Yes.
When?
When I was in front of him, close enough to punch.
Right, but when you confronted him is what I'm saying. You confronted him
Like I said,
first.
it could have been me progressing the situation because of what he said to make him make a step towards me. My body, what I processed and saw was him coming at me, but it could have been from me pursuing what he had said to her, if that makes any sense to you.
No, it doesn't.
Judge,
So,
that's argumentative.
Overruled. Your client has already been instructed once only to answer the question. He keeps providing extra.
so Mr. Morris, this right here, you don't call that confronting him? Running from the front of the store to him, that's confronting him, right? You confronted him.
He confronted her first.
No, he did not.
Yes, he did by his tone of voice, his aggression. Yes, ma'am. Yes, ma'am.
But physically, he never. went
Did I
towards her at
physically
all.
do anything to him right there? No, ma'am, I did not. I'm merely running up to a situation.
A situation that you created, right?
How did I create it when he's the one that said something first? Why are you?
Morris, answer the question. You're not asking any questions of the prosecutor.
Yes, sir. Sorry, sir. Restate
situation
that, or
that-
re-ask me that, please.
Yes, sir. A situation that you created
No, ma'am, I
when
did not
you
create.
went up to him.
I did not create that situation whatsoever.
Let me ask you this. What would have happened had you just gotten in that car and left?
Chances are I wouldn't be sitting right here talking to you.
And how do you know that?
What do you mean? How do I know
What
that?
makes you think that? He never pulled a gun or a weapon or anything on you, right?
He did not. No, ma'am, he did not.
He
There's no
never even raised a fist
I didn't
at
give him
you.
that chance, ma'am. Do you understand that? That's how someone like me responds to a situation. You don't give someone a chance for it to be bad on you. I don't.
Right, you
That is
respond
that
very
is a natural instinct, ma'am.
You respond very aggressively. Would you agree with that?
Because I'm trying to explain to you that you don't seem to understand.
That's
I'm
a
not trying to be
question.
aggressive, and I don't appreciate you turning me around like that.
Had you gotten in that car?
Objection asked and answered.
Sustained.
All right. So right here, you would agree with me, you turned around and now you're going back towards him, right?
That is correct. Yes, ma'am.
Okay. Right here. You walk away from him again, don't you?
I'm standing, checking my surroundings. Yes, ma'am. I'm
Still-
doing a circle. It's kind of like, I don't know how, I'm not walking away. I'm checking what's surrounding me. Like I said, that's like 101 as in a situation. You always are looking around.
So in all the times that you had to check your surroundings, you couldn't just go get back in the truck and leave?
Yes, ma'am, I could have. And I wish I
And you
would have.
chose not to,
I
right?
wish I would have. I wish I would have. I really do.
Mr. But instead, you made a choice
That's correct.
for
I made
the
a
second
choice.
time
I
to
made a
turn
choice.
back towards him, but this time you put your hands on him, right?
I'm sorry, re-ask me that.
So this is the second time now that you've turned around and walked away from
Okay.
him, right?
I didn't turn around and walk away. I kind of did a pivot to look. It's kind of not really walking away.
Okay, I'm gonna
still
rewind it.
engaged.
I'm gonna rewind it. All right. So here you are running towards him. You
Yes,
stop, you turn around, right? You saw that?
Yes, ma'am.
Okay, that was the first time. Now you're confronting him, right?
Yes, ma'am.
Okay. Now you
Checking
just
around me.
you turned around and stepped away from him again, right?
A step is not walking away. Like I said, that is me turning around and checking my surroundings.
Okay. But would you agree
That's pretty obvious.
would you agree though that when you took a step away from him,
Mhm.
you had your back to him, right?
No, I had my shoulder to him.
Okay, and he didn't do anything to you then when you had your back to him, right?
Not that I could see.
He
I mean,
could've-
I didn't see. I was looking, took my eyes off of him, which
And would
isn't
you
smart.
would you agree that if he wanted to do something to you, he could have when you turned around? He could have caught you off guard.
That would have probably been his ideal time to strike.
And he didn't, did he?
He did when as I turned back around, his approach, maybe he was too slow. I mean, he was inebriated. Was he not? He had a band that said he was at
At a cigar bar. You remember
cigar
hearing
bar.
that?
Yeah, I know a
Okay.
cigar bar, and he did say he drank too.
He said he had one drink. Remember that?
How many times have you heard that, ma'am?
Mr. Morris, you're not asking questions. Please answer. And when you're ready, we'll move on.
I'm ready. Yes, ma'am. Sorry.
All right, so you approach him. You turn back towards him. Would you agree with that at that point?
Yes, ma'am.
Okay. Would you agree that I think earlier you testified that y'all were standing closer towards the front of his car. Do you remember that like a few questions ago?
That was where he was standing. That's not where we were standing. I happened to be in between the two cars doing my turn to the right. When I looked when I looked back, he was probably right there by his, right behind his passenger door as to where I'm looking like I am now.
Well, he was.
So
Who
he has
is-
moved since I'd said, when I had said what you just said, I said, as in where he was standing, that he's obviously changed positions in this particular frame.
But we're looking at the front of his car though, right?
I know, but when you asked me where I saw him standing was not this point in the clip. It was 7 seconds before that. 10 seconds, or I'm not sure how much time.
Okay, so if it's your testimony that at some point he was at the front of his car and then he moves towards the back, we would have seen that, right?
This is, do you see where the gas pumps are sitting and where this angle is? I mean, and like geometry, I mean, like you're losing visual right there. I mean, there's a good probably 4 feet from the end of that gas pump, maybe 2 foot that he could be standing in, that you would think that he's still behind the gas pump.
You would agree that we never see him moving at all in this frame, right? He never comes out.
You don't see him much at all in this clip at all. All you see is me, and
Right.
I think that's why you're just
Right, that's what I'm saying.
Mhm.
You never see him come out from outside of that gas pump, right?
Mhm.
Okay. So any movement that you're saying he makes, it's in that little gas pump area.
Well, that gas pump is probably 3.5 foot wide. From this angle, you probably got about 5 feet. So he's got about 5 feet and moving.
All right, I want to talk about when you
Either which
punch
way.
him.
I just don't understand.
I didn't ask a question.
Okay.
Please wait, Mr. Morris.
Yes, sir.
All right,
Use your face
Okay,
covering.
sir.
when you punch him, you back up, don't you?
That's correct.
And you stand there for a
That's
little
correct.
bit, right?
That is correct.
Right? Why would you do that if he was such a threat?
Kind of been shocked a little bit still. I mean, I don't really know. I mean, how long of a second is that? Am I standing there? Can you tell me? Because
Sure, let's rewind it. Give me 1 second. All right.
that's me walking over, back it up. That's like 8 seconds.
You're still standing there. Hold on. All right. So,
Still looking. I don't know.
so I guess my question to you is, if he is such a threat, hold on.
Yeah.
If she is such a threat, why are you still standing there waiting for him to get up?
Like I said, I don't know. I mean, I know the right things to do in a scenario that happens very, very
Can you
fast
answer
like
my
that.
question, though?
How do you know which?
Mr. Morris, please respond to the actual question.
Okay, I'm sorry.
I'll ask it again, okay?
Okay,
If he is such a threat to you and
Correct.
to Sierra and to your unborn child, Miss Roylance, I'm sorry, and your unborn child, why?
did I not jump in the truck?
No. Hold on. Why, after you punch him, do you back up and you stand there? You wait for him to get up. Why are you doing that if he's such a threat to you?
I guess I'm still analyzing. I don't know. I mean, I have processing issues, so a lot of times
Okay.
I move differently.
Mr. Morris, it's because you wanted to fight. That's why you did that.
That's
right?
If I wanted to fight, I would have jumped on him.
Well, you hit him, right?
I would have jumped on him and fought him. I didn't want to fight. How can you say that? Just by me
I'm done
standing
with
there?
my
I
question.
don't understand.
Thank you for your answer.
Yes, ma'am.
All right. Watch this part real close for me, okay?
Okay.
All right. You see how is that Sierra or Miss Roylance, I'm sorry, getting out of the truck?
That is my beautiful woman. That is Sierra.
And you remember her testifying that she was real scared of him too, right?
Yes.
And you'd agree she's walking over to where you and him are,
She feels
right?
pretty protected when she's around me.
Oh, no, I'm asking. You would agree that even though she's so scared, she's now gotten out of the truck and walked over to where the supposed threat is.
To get me out of the situation, she backs me up like I back her up. Yes,
Okay.
ma'am.
Even though she's so scared, right?
I mean, in that time, I'm the father of her child. Wouldn't you back him up if he's
Don't
on
ask me a
Mr. Morris,
question. I asked the question.
We're not asking questions. Please
I-
respond.
Yes, sir. Sorry.
All right, watch this part real close for me when you get a chance. Let me know when you're ready.
I may.
Okay. You see her standing in front of you?
Yes, sir.
Okay. Would you agree? Look at her hand. You see her hand pointed up like that?
Mm-hmm.
Would you agree with me that she's telling you to get back in the car?
Yes.
Okay. Would you agree with me that she has to tell you that because you want to fight Mr. Thompson? You're waiting for him, right?
No, ma'am. That is not correct. That's not why I would be standing there. Like I said, if I wanted to have fought him, I would have hit him and then got on top of him. You don't just, like, who hits somebody and lets them stand back up.
Well, you did hit him.
No, I'm
right?
saying who hits them and then lets them stand back
Mr.
up and they're
Morris,
trying
you're
to
not
fight.
asking questions. Please
I'm sorry.
respond.
I don't even realize I'm doing that. I'm sorry.
At the same point where Miss Roylance is pointing at you to
Mhm.
get in the car, do you see Mr. Thompson?
I do.
Okay. Watch this clip for me, okay?
Yes, yes, ma'am.
At any point, do you see him run after you?
He is not running after me, no, ma'am.
Okay. At any point, do you even see him try to defend himself at all against you?
He probably, I guess that
You didn't
hurt.
see him do that though, right? That's my question, is you
Judge,
didn't see that.
Can the witness be allowed to
Yes.
answer the
Ms.
question?
James.
And Judge, at
please
this point, I'm
wait.
going to object.
Hold on. Ms. James, please wait for the answer and make your objection, Mr. Pumphrey.
I'm going to object to badgering the witness and argumentative.
Sustained as the argumentative. Please move on, Ms. James.
Can I ask the last question that he was answering? Okay.
Go ahead.
You didn't see him come after you at all after you had punched him, right?
No, I don't believe so, no, ma'am.
Okay.
See that, him standing right there, I mean, there's no telling what he's about to do. Like, he's by his trunk.
Do you remember him testifying?
Do I remember him testifying?
Do you remember him testifying today?
It was
Or
yesterday.
yesterday, I'm sorry.
Yes, I remember him.
Do you remember him testifying that he was trying to take a picture of your tag?
Oh, see, I mean,
You don't remember that?
No, I remember that. I remember that
Okay.
fully. He said he couldn't actually get a clear picture of it
Right, because
So
you
he
were
didn't have
taken out
my
of the
tag.
parking lot so fast.
so fast. I mean, watch the next car go by. It goes about the same
Morris,
speed as
you're
mine.
only answering the question.
Would you agree that you and Miss Roylance pulled out of that parking lot pretty fast?
Pulled out of it anytime, pretty normal. You're pulling onto a 45-mile-an-hour highway. You know, you kind of have to get out of there quick. Like I said, watch the next car that goes by after mine. See if it's not going the same speed.
Would you agree that Mr. Thompson never once, not a single time, touched you?
He did not touch me, no, ma'am.
Would you
I did
agree
not
that
give him a chance
you never gave him a chance, right?
not to touch me. His body was coming at me aggressively, like his first. I mean, I already explained myself.
I hear you saying that, but you could have walked away, right?
Yes, ma'am, I could have.
Asked and answered.
Sustained.
Don't you think I wish I
Wait,
would
I
have
didn't
walked
ask
away?
a question. I
Morris,
did not
you're
ask a
not
question.
Asking questions.
I'm sorry.
When you refer to Mr. Thompson, what do you refer to him as?
Mr. Thompson?
Okay, have you ever referred to him by his race?
No, ma'am. Or, as black man, yes, as a black man.
Not a black man. What have you referred to him as? I
A
get what
black
you're saying
man.
with black man, but
A-
what exactly
Judge,
did you
this is
say?
argumentative. The witness
Members
needs
of the
time.
jury, hold on.
A
Mr.
black man, just
Pumphrey.
as he
Hold
would call
on,
me a
Mr.
white
Morris,
man.
stop talking. Members of the jury, we're going to take a brief break again for 5 minutes, perhaps longer. Bailiffs, please take the members of the jury out.
Y'all are moving all the way.
Please be seated.
Can I throw these tissues away? Or can I throw these tissues away?
You can. Just hand them to the bailiff. Mr. Pumphrey, your client has already testified to employing black people. I'm not sure why, but for whatever reason, that door was already entered into for some reason. What is your objection?
I can't hear you.
Said your client has already testified to employing black people. I'm not sure why, but for whatever reason, that path was already started down upon. What is your objection?
The objection at this minute
Yes.
is being argumentative and not allowing the witness to answer the question and just this is the witness that we haven't been allowed to go. We can't get into the fact that he has severe dyslexia, he has auditory and visual processing issues, and rapid fire questions as he starts an answer is not working. I'm surprised he's doing as well as he is. I'm surprised he's holding up to this. James
Ms.
is
James,
after him, but she's going after him in a very angry tone, an aggressive manner. And, you know, he's trying to process everything. So all I was doing is asking to allow him to answer.
Ms. James, it pertains to the pacing, I believe. We've already established this out of the presence of the jury. And that's
I'm doing my
why-
best, Judge.
I know, but that's why I advised you before you got started. It cannot be your normal cadence. As far as the issue of whether this is argumentative, again, Mr. Pumphrey, your client has testified to employing black people, which I guess is trying to indicate some sort of positive relationship. I'm not going to let this get out of hand, but Ms. James, if this starts to go beyond what he has referred to the alleged victim as, all I'm going to say is tread carefully.
Yes, sir, I will, but I guess I do want to say, Judge, and I think you already noticed it, on direct examination, without me saying anything, right? We already discussed this N-word situation and the fact that he refers to him as that black man. Why in the world defense would get up on direct examination and start talking about how he employs black people, which to me, and I'm sure to this jury and to others in this courtroom, indicates that he doesn't have a problem with black people. And I am allowed, that door is open. Now, I'm not going to say the N-word, but I am going to ask him about it.
Limited questioning at most needs to occur on this issue. Beyond that, the objection as to argumentative is overruled for now. If this gets too far afield, I am going to shut it down, Ms. James. So we're clear.
Yes, sir. I guess, would you like to know what my questions are so that I can know?
I don't need to know them.
Okay.
Humphrey, you can object as need be. Go ahead,
Judge,
sir.
I just, while we've got the jury out, I want to clarify a couple of things. The state is correct. I did go into the fact that he employs people of color.
Yes, you
I
did.
did also go into the fact that he identifies as white, he identifies African Americans as black. And so that door is wide open. I didn't just open it, I kicked it open. Okay? And so if she wants to get in that tape, she can bring it. In fact, if she wants to bring it, if she wants to play the portion she's seeking, that's fine. But I'm worried about this young man. He's holding up better than I would have expected. I didn't know how to do it. And in working with him and stuff, it's amazing he's hanging with it, but she can't rapid fire him like that. He can't respond and process it, and he's trying. And she gets mad at his answers, and he's still answering them and trying to process them and answer them truthfully. And so I
We've
do want
already
to go
discussed
into.
the pacing. So we've already discussed the pacing. Ms. James has acknowledged she needs to slow down.
Yes, sir, you have. The judge, I do want to go into though, on cross-examination, the state went into his brain and his brain thinking. And the state opened that door. And I would respectfully request that I be allowed to walk through it and at least advise this jury, because he was getting pounded so much. He said, he's trying to explain what's going on in his mind at that time on that video. He's having to process the video, auditory, visual. He's having to process what she's saying, auditory, visual. He's having to listen, and the court is well aware of this, because I'm sitting here just amazed. He keeps asking questions. He's not being disrespectful. He's being very respectful, but he has processing issues. And so he has anxiety. He has a lot of things, and that's what, is the jury is seeing, but the jury doesn't know that. I'd like to be allowed some leeway to just let them know he has these problems. And the state's one right out the brain.
No.
What's going on in your brain?
Can I respond to that, Judge?
Briefly, go ahead.
And we can have the court reporter read it back. He straight up said, despite this court's order, which is why I brought this up while he was in here, he straight up said, I have processing issues. And I immediately was like, okay, so we're just no, we don't need to go through that anymore. He's already said it, but we don't need to, keep on going through it. I never once said, does your brain work? That doesn't make any sense. I never implied that he couldn't understand. In fact, I think he's doing quite a good job understanding my questions and responding. which is why I'm going the way that I am, because I think he's doing just fine with me. But no, I think it's wholly inappropriate to do what he's already done, but I don't think we need to harp on that anymore. It's inappropriate.
During the direct testimony, Mr. Pumphrey, I do remember your client making mention of processing. Beyond that, we're not going to get any further into it. The ruling remains the same. Any sort of disability that would otherwise confuse the jury concerning his competence or ability to otherwise conform his behavior to what is lawful, we're not going down that road.
Yes, sir. I understand. And Judge, I want to make it clear on the record, and I know the court sees this. He's not, and I can't explain it. I don't know it. But he keeps asking questions, and if there's a gap area, he gets nervous and he starts to ask things. And then he'll be very respectful and apologize to the court. He's apologized to Miss James. He's apologized to everybody in here, I think. He just, and that's part of it. And I'm abided by the court's ruling. I'm not questioning that. I'm just making the record clear because he's done an amazing job. I really did not think he would hold up at all.
Mr. Morris, do you need any water? Do you need additional time?
I have
to take a
some,
break?
thank you so much.
Judge, so I don't cause a mistrial, I do plan on asking him if he's ever used a racial slur in reference to this victim. Based on the defense doing what they did, I do plan on asking that. If he says no, he says no. But I think if he says no, that's grounds for, impeachment, and there is an officer that will testify to that. They can cross her, obviously, on the fact that it wasn't, mentioned in her report, but they opened that door by trying to bring out his relationship with Black people. And I mean, it just is what it is.
I advise you to tread carefully.
I will,
If you end
Judge.
up in a mistrial, ultimately, that's what will happen.
I will, Judge.
Judge, there is some language that comes to mind, though, goading. And we need to be very careful here on this one.
All right, let's bring in the jury.
Oh, and just one other thing. I'm not questioning the cross-examination theory, but the law is that you can stand your ground and not a conflict avoidance theory, which the state is presenting to this jury in a cross-examination.
Understood. Well, in final argument, it's one thing to ask, could you have left? As far as a proper instruction on the law, it will be what's in the instructions.
Yes, sir.
It's a lot to be catching.
You can sit down, Mr. Morris, for right now.
Oh, yes, sir.
Jury entering the courtroom.
Everyone can be seated. James, you can continue with your examination.
Thank you, Judge. Mr. Morris, what do you refer to Mr. Thompson as?
Mr. Thompson,
Have you ever referred to him using his race?
as a Black man, yes, I did.
Okay, what have you called him in terms of as a Black man?
A Black man,
Objection asked and answered. I think we're treading on thin ice.
a Black man.
That Black man, have you called him that before?
I don't know.
Have you referred to him as that Black man several times?
I haven't really had many conversations with the guy.
I don't mean with him, I just mean in general.
Oh,
Have you ever referred to him as that Black man?
Asked and answered.
Sustained.
Have you ever used a racial slur when you're talking about Mr. Thompson?
Objection. Well, Judge, this is the issue.
We just talked about
the
this.
Board addressed. And it goes
Rule for
directly out.
now.
I'm not sure. I mean, like,
It's just a yes or a no. Have you or have you
I
not?
don't know.
You don't know?
I don't know.
Okay. I don't have any further questions.
Cross-exam.
Come on with John.
Okay. Or redirect, excuse me.
Mr. Morris?
Yes, sir.
And
Yes,
were
sir.
you in that gap at the Circle K that we just watched the video time and again?
Yes, sir.
Did you have a lawful right to be there as a citizen?
Oh, for sure.
And is that here in the state of Florida?
Yes, sir.
And in the state of Florida, you understand you have no duty to retreat in those circumstances.
Yes, sir. I don't think I would.
You understand too that what the state's crossing you on is called a conflict
Judge, he's
avoidance
not a legal
theory.
expert. That's inappropriate.
Okay, yes, sir.
And
You understand your ground law.
Judge, he's not, this is not appropriate for him.
sustained, is there any basis your client has to respond to these questions, Mr. Pumphrey?
Judge, I'll move on. We need to finish up. Now, as far as the questions the state was asking, okay, at the time that you're pivoting and watching your surroundings, or however you described it,
Yes, sir.
when you turned around, was Mr. Tola Thompson advancing himself on you?
Yes, sir.
Okay. And at that point, at some point, did you feel like you needed to pop him in the mouth?
That's
to
what
back him off?
his aggression or his pursuing is what I felt. That's exactly that's how I felt, was how his body moved. I mean,
You described
I'm sorry.
you said that when the state was pressing you, there's about 5 feet that can't be seen clearly on the video.
Yes, sir. If not, maybe more, maybe 6 feet.
And the state was questioning you about things that, you could have gotten in the truck. He equally could have pulled a gun, right?
Exactly.
You said 10 feet from your girlfriend. That it doesn't take but a split second to close that gap, does it?
Maybe a second.
And were you concerned for your own safety? Doesn't mean you're not scared, but were you concerned for your own safety when you were putting yourself between him and your girlfriend?
Of course, that's a thought that goes through your head, but you try to block that out.
As we watched all this video, have you at any instance done anything other than walk, except for that one time?
Sorry, say that again.
In all the video, the whole time you were at the store, were you walking the whole time until you heard the threat?
Yes.
Okay. And were you, even though you ran over there, and you were walking around checking your surroundings, you didn't know if he had somebody with him, you weren't paying attention to this person before you ran out there?
No, sir.
And there are people milling around, there's homeless people.
There's a lot of people in that area. You got Lake Ella right there. And right behind the Circle K is there's a pathway for TPD, but there's also like a little valley where a lot of homeless people chill out, I think.
Let me just mark it out. All right. Judge, I'm just checking to make sure I'm on through everything. I appreciate the court's patience.
My brain hurts.
Attorney's
No
almost
question.
done, Mr. Morris. Just wait.
Question was asked. Moment to confer, y'all.
Okay.
No further questions.
Morris, you can step down. Does the defense have any other witnesses?
Yes, Judge. We have
Call your next
Detective
witness.
Copeland, or Sergeant Copeland? Investigator Copeland, I'm sorry. You want me to go get him, Judge?
Yes.
Do I have it in you? I think I do have it. You don't need it on a desk, though. Are you wanting it, or do you want me to play with it? Okay, okay, okay. You're welcome. That's fine.
Sergeant Copeland, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You can take your seat.
Thank you, Your Honor.
Please speak loudly and clearly. Mr. Pumphrey, when you're ready, you can begin your examination.
I would just order, it's gotta be on this to give to the clerk. I do have an objection to it. No, maybe let's take it out and talk about it, because I do have an objection to it.
Judge, the state has a request.
You need to have a sidebar.
We could just walk over here, Judge, we don't need to take them all.
Move into the hallway. Members of the jury, we will resume in a moment. Please remain seated.
Back in session.
Pumphrey, you can proceed when you're ready.
Can you mark it page and defense one?
It's defense 2, because you already have an exhibit one. It's defense
It's
2.
defense is 2.
All right. Will you please state your name and introduce yourself to the members of the jury?
Good afternoon. My name is Daniel Copeland, Copelin. I go by Dan. I am employed by the city of Tallahassee at the police department. I'm currently assigned as a sergeant in the patrol division.
And Detective Copeland, did you have an occasion to assist Detective Brittany Abel in 2019 wearing a body-worn camera and interview one Sierra Royland?
Yes, sir. I became involved on October the 25th, 2019 at the request of Investigator Abel, and I accompanied her to meet with Miss Roylance, and I spoke to her that day. And it was captured on my body-worn camera.
Yes, sir. And as part of, you've been experienced in law enforcement for years, is that right?
For a year?
For years.
Oh, yes, sir. Sorry, I didn't hear you with the
I
math.
wish I could say year, but it's years.
Yes, sir.
A lot of years.
It has been.
So as a interview training or technique, you want to separate people and see if they want to talk to you. You're not forcing them. You're just asking them if they want to talk.
Yes, sir. It's a good practice to ask people to provide their account where they're not going to be influenced by someone else.
And you also, right, you want to separate them from the person, and you also want to capture it because this was closer in time, almost a year and X number of months ago. And by using the body-worn camera, when someone gives a statement, you can capture it.
That is correct.
And did you do that in this particular case, in this investigation regarding one Sierra Royland?
Yes, sir, I did.
Your Honor, may I approach the witness?
You may.
Showing you what's going to be marked as defense exhibit 2. And I don't know if you've seen that or not.
I have, sir.
Okay. You recognize it?
I do recognize it. It is a disc that I have initialed that is a copy of the body-worn camera video from the day in question.
All right. Is it a fair and accurate representation of your interview with Sierra Royland, capturing her statement?
That is correct, sir.
And at the end, do you affirm with her that she'll swear to what she just said?
I do.
All right. Your Honor, this time, permission to publish?
Is there any objection as to defense, was defense 2 coming into evidence?
No, sir.
Defense 2 is admitted at this time. Members of the jury, please pay attention to your screens. I will dim the light to assist you.
Give us the desk. Thank you.
Judge, permission to publish the 8-minute statement.
You may.
Judge, I believe it's ready to publish.
You can publish when you're ready.
know what to do is that Damian threatened me, out of no provocation, screamed and threatened me, and Chase, in my opinion, was just offended. I'm pregnant, we're at a gas station at 2 o'clock in the morning, like, this man, who I don't know, started screaming at me, cussing at me, and threatening me out of nowhere, and I was fucking terrified. Like, I literally, when we left there, I didn't even go home because I was scared. And so that's pretty much what happened. Like, I was yelling for Chase to hurry up out the storm. I mean, I'm screaming and cussing at me, told me to shut the fuck up or he's gonna make me. And I mean, I literally never, ever had anything like this. I mean, I don't know who that guy is or where he comes from, but that's not how you talk to a woman where I'm from, and that shit scared me. Like, it really did.
Okay. Obviously, you're not being sold, okay? So I don't think that you need an attorney or anything like that.
Yeah.
If you don't want to say anything else to me, because the way you kind of started this was that you didn't know what you wanted to say or whatever.
I
based
just
on whatever you did.
don't want to say anything that's gonna get him in trouble or like, it was just
Did
not.
you ever come over for the truck engine?
Well, I was in the truck, so I couldn't really see that good at that point, but I was getting out. And I mean, he could have, I'm not sure, but I know that he was terrible. That's serious. And I was always scared.
Where was chasing him in relation to the truck? Like, if you're sitting in the driver's seat, and I'm sitting here in the passenger seat, where are they in relation to the truck?
To the right of it.
All the way on this side?
Yeah.
Behind us or in front of us?
I think they were in front of us.
So you could see what was happening.
Yeah, I could see what was happening. And it looked like he moved towards me. It really did. And that's when I started to get out of the truck, because it looked like he moved towards
When
me.
it looked like you moved towards Chase, what Chase?
I don't know, I didn't see that when I got out of the truck. Yeah.
It's pretty high.
Yeah, it's pretty all you can say right there. I'm here for her, because it's always trees, all stuff down, and you gotta get the whole stuff.
It's like there's a sack coming down from those trees. Okay. All right. Well, I appreciate you talking to me. I understand you probably don't want anything more than that.
Yeah, but that's.
I'm concerned about all that, but you're not in control of it.
I know, but anything that happens in it affects me too. Anything that happens, it's just him, just right. I It was just crazy, and I've never had anybody talk to me like that in my life. I've never had some random person like that. So he didn't look, you don't look at the guy and think that he looks that threatening, but I mean, like, he was venomous, like literally like spitting when he was speaking, especially if it was like, I mean, it was angry. And I don't know if he got something else on at home, but there's no reason.
Would you want to write this one statement as what you told me, or do you just want to leave it like that? You
I
want to
would,
write it?
honestly, think I should wait to do that or something, but, I'm absolutely willing to write down everything that I said, just might not, you know.
Or follow through, and review
There's more. Turn it down, or unplug it and turn it down, so that way on the applicant.
Turn it on, hold
Yeah. Judge, I'm just asking for the rule of completeness at this point. I believe we've worked it out, so we're handling that now.
Very good. Humphrey, you can continue.
Which I think they're still working on the technical aspect.
Right.
I was never the AV guy in high school.
She doesn't say. Yeah, but I'm not. Yeah. All right, we're good, Judge. I'm gonna.
You may proceed.
Judge, I think they want to publish.
I want to just play the rest of the interview.
Sure.
Okay, let me dim the lights.
One statement as what you told me, or do you just want to leave it like that? You want to write it?
I would, honestly, think I should wait to do that or something, but, I'm absolutely willing to write down everything that I said, just might not, you know.
Or follow through, and if you would like to, you would be fine.
Yeah.
Right, so if there's anything you need to change, that's true.
I'm 100%
Detective Copeland, is that a fair and accurate representation of Sierra Roy Lance's interview? And I don't think you actually swore, but you had her affirm that she would swear to it on October 25th, 2019. Not calculating the math, it's late in the day, but it's a few days after the event, whereas as we sit here today, it's a year and a few months after the event. Yes, sir. No further questions?
Cross-exam.
Good afternoon.
Good afternoon.
When you interviewed Miss Roy Lance, was she hysterical at all?
No, ma'am.
Did she cry at all?
No, she did not.
Did she like get worked up at all emotionally?
No.
And during the time that you interviewed her, she was living and had been living with Mr. Chase Morris, correct?
Although I never asked her that question, and that was never stated to me, that was my understanding.
Okay. How long have you been an investigator?
Well, I'm no longer an investigator currently now. but I have been an investigator for approximately 8 years during my career.
Sorry, what is your title now? I don't want to call it.
I'm a sergeant
Got
in patrol division, but at the time of this incident, I was an investigator or detective assigned to the violent crimes unit. And I did approximately a 5-year term in there for the second term as an investigator. The first time I was an investigator was for almost 4 years. So about 8 years, a little bit more.
And throughout your career, just in law enforcement in general, have you ever had anybody that you're interviewing or talking to be untruthful with you?
Yes, ma'am.
And what are some indicators that you look for when you're trying to determine that?
Everyone is a little different. So whenever I first speak to someone, I try to get an understanding as to what their personal habits are, the way they speak, their tone of speech, just to kind of get to know someone.
Judge, I think we're running close to our motion.
Please approach.
Motion to bundle stack.
Thank you, Judge.
Oh, one moment.
Oh.
Allow the court reporter to
Most
proceed.
important person.
Now you can proceed.
Okay. Sergeant Copeland, when Miss Roylance was talking to you, she said she didn't want to say too much until he told her what to do, right?
Or until she spoke to him and found out what to say or what to do, yes.
And that was her same response when you asked her if she'd read a statement too, right?
That is correct.
Was that she wanted to wait to talk to Chase first?
That she
Right.
would, but she wanted to wait to speak to him.
When you asked her, this was sort of at the beginning, do you remember when you asked her, what did the guy say to you? What did he say to you?
I do.
Okay, and do you remember, she kind of hesitates a little bit and then starts her story all over again rather than directly answering. Do you remember that?
I do remember that.
All right, I don't have any further questions. Thank you.
Any redirect of Sergeant Copeland?
Sergeant Copeland, you would agree that you captured everything the jury needs to see on that video, is that correct?
In regards to my interview with Ms. Roylance? Yes, sir. Everything that, all the questions, all the conversation that I had with her were captured on my body camera.
That's all. Thank you very much. Thank you.
Yes, sir.
Sergeant Copeland, you can step down. Have a good day, sir.
Thank you, Your Honor.
Any other witnesses for the defense?
No, Judge, that's for us.
Members of the jury, with the defense now having rested its case as well, we are going to take a bit of an extended break. So everyone understands, for the scheduling for the rest of this evening, we will proceed into the jury instructions and closing arguments, and then you'll have your opportunity to deliberate. If you need to call your families or make any arrangements moving into the evening, you'll have this time during the extended break to do so. We will reconvene at 5 o'clock, and you can take your time. All right, the bailiff will lead you out.
Thank you so much. I know.
Everyone can be seated. Mr. Pumphrey, does the defense have any motions at this point in the trial?
Judge, at this time, we would request and reassert Mr. Morris's rights under Florida's stand your ground law. I don't need to cite the statutes, the court's familiar with it, and the instructions. And having said that, the burden now shifts to the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. If I'm remembering correctly, I'm not reading off my sheet, but whatever the jury instruction is, and the instructions are, the court is aware of that. And given that testimony has been provided, at this time, I'd make a second motion for judgment of acquittal with a different standard and ask that the court dismiss this case and let us all go home.
Right, as it pertains to whether statutory immunity applies, the defense or the defense case has asserted a prima facie case of statutory immunity. The state's case, however, also presents clear and convincing evidence that immunity should not apply in the court's assessment of that evidence. So the case will proceed forward and the defendant will not be discharged. However, that ruling is preserved for appeal if need be. Any other motions?
Moment, Your Honor. Judge, I need to renew my motion for judgment of acquittal.
Same ruling as to the prior judgment of acquittal as well.
Judge, I have a couple of other motions.
Go ahead.
Bear just with me a second. Judge, I have a motion in limine. Case number 2019 CF 3767. I'll make it orally. And at this time, I would move the court to limine out or preclude the state from making any improper statements in closing argument. This has been a heated trial. And I got to tell you, Ms. James she's done her job for sure. I'll be sure and let Mr. Campbell know that. But, and I thought we were going to get done on Monday, and she's a fighter. But Judge, I want to make sure that we
about
keep
my calming presence that seems to draw it out of people.
Judge,
Go ahead.
I don't know if a freight train could stop that. So calming presence or freight train, either one. And I say that out of respect and professionalism because I always enjoy having a worthy opponent, and that is the highest honor I can give a trial attorney. That having been said, I still have to do my job, and I want to make sure we have a clean trial and this jury gets this case and is able to take it back there and deliberate so that my client can have his due process rights. And so I would just move to exclude any improper statements, and the court is aware of what those are. I also have a motion in limine on burden shifting. I would ask that the state not go into any burden shifting or lessening their burden. The burden is on them. The burden is on them in two areas. Now that we qualify for the instruction, they'll have to argue to the jury that they proved to that standard, that he was not acting in self-defense. And so, those are my motions. We'll add those to the list.
Any response, Ms. James?
No, sir.
I think it's fairly clear the state cannot burden shift whatsoever. The Florida Supreme Court and all of the appellate courts are very clear on this. That is granted. As it pertains to specifically arguing the instruction, if we need to more specifically get into how the closing argument may otherwise run afoul of the understood law, Mr. Pumphrey, we'll stop closing. It's not really my preference to do so, but we'll address it and stop closing if need be. How long is each party thinking they'll need to give closings?
State?
Am I allowed to go first? I don't know.
Oh, that's a good question.
I believe we've had an attentive jury, hint, hint, but give me your estimates.
Judge, they can always give back the sandwich to the defense bar if they want.
An
But I think I'd
hour?
lose in this case.
An hour?
Ooh, okay.
Well, I'd rather ask for that than you cut me off in the middle.
Judge, in all due respect, I think the court's gonna have to cut her off whether it's 2 hours.
All right, as to an hour, 45 minutes is probably a little more appropriate. I don't know if you're even going to need that in its entirety, but
Judge, if the court wants to order us to limit to 30 minutes, I have no problem with that. Mr. Morris, you got any problem with my position on that?
45 minutes for each party. That will be your allotted time. Ms. James, you certainly can split it up. Mr. Pumphrey, I'll have the clock running. I'll give everyone a signal with one knock when you're getting close on time.
Hopefully I hear you.
All right, let's move into the charge conference. Right. Instruction 3.1, introduction to final instructions. That
Judge,
is standard language.
I'm
Go
sorry,
ahead.
one thing before we start, Judge. The defense and I have talked about this before, which basically is if the jury comes back with the lesser of misdemeanor battery, it has to be severed because he does have the prior felony battery, great bodily harm. And I have the JNSs and stuff for that. However, Judge, I need to amend the information to add that language.
Right. Mr. Pumphrey, any argument about the state amending the information at this stage?
I'm sorry, Judge, can you repeat that?
Any argument about the state amending the information at this stage as it would
Judge,
relate to the lesser included?
Judge, they didn't initially charge that. I'm going to object, but in all candor to the court, I think the case law is pretty clear that up until the jury is actually charged, the state can amend the charging document. That's my understanding of the law. But I'm making my objection because the question then becomes, prior to the amendment now, after we've closed the defense case, they wish to make an amendment to the charging document. And so I would exercise any and all objections can be lawfully made concerning when the state realized that the evidence was showing differently than what they had initially charged. If they haven't seen the evidence different than they initially charged and they're merely asking for the lesser, it's a different analysis. But again, I think the case law is pretty clear. They're the state. They deal with charging documents and true bills or no true bills. So I've made my objection.
The objection is overruled. I will permit the state to amend the charging document as it pertains to the lesser included, but only as it pertains to the potential of the lesser included. Other than that, no other amendments are going to be permitted.
Yes, sir. And then there's one more thing, Judge, which this really doesn't matter unless they come back with the lesser, but Tom Balboni, he's our fingerprint expert. I'm sorry, Tom Balboni, that's his name. He's our fingerprint expert at the state attorney's office. And he's disclosed for that purpose. And I think I put like, if the jury comes back or something like that. I disclosed his name, but did not put expert next to his name. And in order for him to say whatever he needs to say about the fingerprints, I guess technically I have to put expert next to his name. So want to put that out there.
Well, the defense essentially be wanting to do this out of the presence of the jury concerning the prior.
If that becomes an issue, Judge.
Yeah, if it becomes a thing. I just wanted to put it out there that I did disclose him, but I didn't put expert next to his name, and I think the case law shows that I have to do that in order for him to say, that he compared the fingerprints, so.
Let's move into the charge conference. 3.1, that is standard language unless someone has something to raise on it.
I'm sorry, Judge, let me just, did she send out a new copy, or is it the same?
Same copy, except mine's just going to include the stipulation instruction.
Yes, sir.
All right, any discussion as to 3.1?
No, sir.
Mr. Pumphrey?
No, Your Honor.
3.2, I believe standard language as well, just includes the defendant's name and the charge.
Objection.
No objection.
8.5, felony battery. I believe here only we need to decide what are the give as applicables, if at all.
I think the first give only applicable, the Fabi state is appropriate. Sorry, I didn't move that. I think the Fabi state one is appropriate. The state would ask for that, and then second one.
Based on the evidence, I don't believe Clark v. State would apply because there's essentially not a transferred touching or striking through another object.
Yes,
There
sir.
has not been.
Yes, sir, I agree.
Transferred.
Right. Then the Fay versus State gives applicable will be added, and that will be the end of 8.5. 3.4, when there are lesser included crimes or attempts, 8.3 battery is a category 1 lesser. I assume the Fay v. State instruction, give as applicable, would be asked for as well by the state.
Yes, sir.
Any basis for argument as to the Clark v. State, give as applicable?
No, Judge.
All right. And Mr. Pumphrey, you are asking for a separate proceeding out of the presence of the jury if the defendant is only found guilty of simple battery.
That is correct, Judge.
And I will remove that as well from the instruction.
And Judge, let the record reflect Mr. Morris is present, seated at the council table, and he's got his own notepad, and he's been interacting with Ms. Keppel and myself, and I haven't, again, I'll reiterate, I haven't seen any processing issues, any deficits.
I will find
He's
all,
done better than I would have done against Ms. James's cross-examination on this case. But
find also based on his testimony, I have no concerns as to him proceeding forward with the trial. All right, 3.6F, justifiable use of deadly force. 3.6F and 3.6G must be given based on the DCA precedent, even though there was no deadly force. Both will be given in accordance with the law. Right, it is a defense to the crime of felony battery. Let me insert that in there. All right, as a defense to the crime of felony battery, including battery if the actions of Chase Morris constituted the justifiable use of deadly force. And from there, let's move into the give as applicables. Mr. Pumphrey, which gives applicables are being sought?
Judge, I lost track there just a second. My apologies.
I did too, Judge. Where are we at in this?
3.6F, after giving the main statement, it moves into the give as applicables.
I don't have that in my copy.
No, but this is the justified use of force instruction, which the defense had requested at the beginning of trial, and I
We did,
believe
Judge, that's correct.
they are entitled to at this point, unless the state is arguing against.
No, sir, I'm not. I was just saying it wasn't in, I think we were both saying it wasn't in the
Yeah.
copies we have, but I'll pull it up so I can
Correct.
see.
Pull it up from the Florida Bar website. You can follow along.
Okay, 3.6F. Is that what we're on, Judge?
Yes.
Okay.
I'll read the lead paragraph again. It is a defense to the crime of felony battery, great bodily harm, including battery, if the actions of Chase Morris constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. From there, it begins to move into the give as applicables, which give as applicables are being requested. Mr. Pumphrey.
I apologize, Judge. We're trying to pull it up.
No problem. I guess if it's easier, Ms. James and Mr. Pumphrey, for you to read over my shoulder as I edit, maybe that might move this along.
It's fine with me, Judge.
We got it up, Judge.
Okay. As to the first, give as applicable, use of deadly force is justified if defendant reasonably believed the force was necessary to prevent imminent death or great bodily harm to himself or herself while resisting. I don't believe our evidence would go towards any of the things enumerated in that list unless there's an argument for it.
No argument, Judge.
All right, I will remove that give as applicable. Next, give as applicable, defendant not in a dwelling or residence, or if defendant was in a dwelling or residence would have no right to be there. I don't believe that would otherwise apply based on our evidence.
Judge, are you going to give justifiable non-deadly?
Yes, both are given. The prior DCA ruling was both have to be given, even if you're not talking about
Yes.
deadly force. Right. I don't believe there's any argument applicable to a dwelling or a place where the defendant had no right to be.
I'll email you.
No, Judge.
All right, the next give is applicable. If there is evidence the defendant was engaged in a criminal activity or was not in a place where he or she had a right to be, which means there was a duty to retreat. Again, on the evidence, I do not believe that applies.
Agree, Judge.
Agreed.
Right. That's fine. That's fine. Good, all right. The next give of applicables deal with the defendant in a dwelling or residence and also the extension of the castle doctrine to someone's lawfully occupation. I don't believe those apply as well. Any argument for those?
No, Judge.
No, Your Honor.
All right, there was no force in resisting a law enforcement officer. Okay, after that, we have a read in all cases. I believe this just goes to otherwise what's understood to be the appearance of danger and the cautious and prudent person. This does need to be given unless there's an argument against it.
No argument. Judge, will we get a edited draft from the courts?
Yes.
The charging document?
Also, Judge, I think I know your style on this, but we print out a copy for the jurors so they can follow along while we're talking, right?
Correct.
Okay.
Unless you would prefer not to have them
No.
have a copy.
No, I want them to have a copy so they can follow what we're talking about.
I would agree with that, Judge.
All right, the read in all cases, I will now read it out loud. In deciding whether Chase Morris was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual, however, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed the danger could be avoided only through the use of that force. Based upon appearances, Chase Morris must have actually believed the danger was real. However, the defendant had no duty to retreat if he was not otherwise engaged in criminal activity and was in a place where he had a right to be.
No objection, Judge.
All right, presumption of fear. Is the defense asking for the presumption of fear?
Yes, Judge.
Judge, I don't think there's any evidence to support it. I mean, unless I'm looking at the wrong section, presumption of fear for unlawful enforceable entry into dwelling, residence, or occupied vehicle.
Well, I was about to say, we gotta look at all the A, B, and C's here. All right, Mr. Pumphrey, any argument as to the presumption of fear?
No, Judge, the only thing I was thinking, there was a vehicle, but there was never an enforceable entry that came into evidence. So that was where my mind was going as a conveyance. So I agree with the court's assessment.
All right, presumption of fear and exceptions to presumption of fear will be removed. Okay. Unlawfully by force, entering or attempting to enter a dwelling does not apply. Mr. Pumphrey, are you asking for the vehicle instruction? But again, no one tried to enter a vehicle, just rather as defining what a vehicle is.
I agree, Judge.
And those will be removed. Aggressor. And I do not believe aggressor applies, or at least the first aggressor. Any argument from the parties?
Correct, Judge. I think that the second section would apply, though, the Gibbs v. State section. So the first aggressor, talking about the forcible felony, I do not think would apply.
All right. Are you asking for number 1 following the opening paragraph of the Gibbs v. State definition of aggression?
Yes, Your Honor.
Yes, yes.
Okay. You can notify the jurors we're taking a bit more of an extended break, but when we bring them back in, we're going to finish out from here. Yes. All right. However, the use of deadly force is not justified if you find that Chase Morris used force to initially provoke. This would be use or threatened use is what's being requested here.
Judge, my screen snapped out on me. Luckily, my trustworthy assistant is back. Just flipped out.
I think the use is more applicable, Judge. Well, initially provoke. Actually, I think that the defendant's testimony was that
Threatened, or at
he
least as
felt
he perceived
threatened.
it.
So I think it would actually be the threatened use of force against himself, because there's no allegation that Mr. Thompson ever touched the defendant. And then in number 1, I think it would be the threat of force asserted towards the defendant instead of use.
Correct. Mr. Pumphrey, were you able to pick back up?
I'm working on it, Judge, and the people.
Mr. Pumphrey, you can
Judge,
also.
there is an issue, and I want to go back and bring this to the court's attention. So I'm going to make you shut up in the context. Mr. Thompson would have to go into a vehicle to a certain force, but the imminent commission of a forcible felony, she was seated in the vehicle and the threat was made, or I'm going to shut you the F up. And so I think that the court heard the same evidence as we've all heard.
I did. Really, it would be the threat of any use of force, really not any actual use of force, but the perceived threat of it would be
Yes.
where all that goes to.
Judge, in the testimony that came out was that Mr. Thompson never approached the vehicle at any point, neither the defendant nor Miss Roylance, nor the Miss Wiggins or Mr. Thompson said that he ever got anywhere close to their vehicle.
Correct.
So I don't think that would be applicable.
Let's go back to finish up with aggressor. However, the use of deadly force is not justified if you find that Chase Morris used force to initially provoke the threatened use of force against himself, unless the threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on Tola Thompson.
No objection, Judge.
Okay. All right. Let's move on to prior threats. Go
I
ahead,
don't think
Mr.
that's
Pumphrey. All right. I don't believe we have any prior threats or specific acts known by defendant.
No, Your Honor. We also don't have reputation of victim known by defendant.
Right. Let's go down to physical abilities.
I just want to bring up something, make sure I've covered it. It's late. I know we're all tired and we're at the end, but if I remember the testimony correctly, they said that they didn't know what he could do, and he could have imminently entered the vehicle if not for Mr. Morris's actions. So if I remember correctly, Mr. Morris established that it was 10 feet, which can be covered in a very short distance. The threat was made, and she was seated in the vehicle, although she was exiting at the time that she believed or perceived that Mr. Tola Thompson was advancing on Mr. Morris.
I believe this was a perceived threat, though, not an actual spoken threat.
Judge, you heard the same thing I did.
Yeah.
And Judge, the state's position would be that was pure speculation. There was no evidence to support that.
All right. The aggressor portion will be given, and then we'll move on next to the physical abilities. And considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capabilities of Chase Morris and Tola Thompson. Next is a read in all cases. If in your consideration of the issue of self-defense, I'm going to make this an or defense of another, you have a reasonable doubt on the question of whether Chase Morris was justified in the use of deadly force, you should find him not guilty. All right. All right, Mr. Pumphrey, if you can scan the justified use of deadly force instruction I otherwise plan to make the same changes that were made to deadly force unless something else is going to be requested.
That's an additional to request at this time. These masks. What have you had trouble listening to me? No, I just agree. It goes along the same changes you made to the deadly force will apply to the non-deadly.
And Judge, I know under the non-deadly force instruction, there's a defense of property section. I don't think that that's applicable.
I agree with that. I don't remember any issue of property. It was about persons.
All right, in defense of person, I believe this one would qualify in this instance. Chase Morris was justified in using non-deadly force against Tola Thompson. And had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself or another.
Correct.
Against Tola Thompson's imminent use of unlawful force.
Correct. I don't think the imminent commission of forcible felony is relevant.
No, there's no evidence to support it.
Judge, is it perception of the defendant?
Well, after the initial paragraph of 3.6G, it goes into defense of person. And based on our evidence, Chase Morris was justified in using non-deadly force against Tola Thompson and had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself or another against Tola Thompson's imminent use of unlawful force. Beyond that, I don't believe anything else would apply.
Would agree.
Right, in defense of property, there is no property that was at issue here. Presumption of fear, any argument for the presumption of fear? Again, I don't believe we have an unlawful entry that was testified to in any way.
Correct, Judge.
Right, presumption of fear and exceptions to presumption of fear will be removed. Right, the definitions as to what would be entered between dwelling, residence, and vehicle do not apply. Again, force and resisting law enforcement does not apply. Right.
Correct.
Leading us to read in all cases. All right, and deciding whether Chase Morris was justified in the use of non-deadly force. You must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual, however, to justify the use of non-deadly force. The appearance of danger must have been so real that a reasonable, cautious, and prudent person under the same circumstances would have believed the danger could only be avoided through the use of that force.
Agreed.
Agreed.
Okay.
And again, I don't think that the first
first aggressor,
aggressor section is relevant or applicable.
right? I believe the second aggressor section will mirror what we already have above.
Correct, Judge. I would again request number 1 under the Gibbs v. State aggressor. And for Madam Court Reporter, I'm saying Gibbs, Gibbs.
However, the use of non-deadly force is not justified if you find that Chase Morris used force to initially provoke the threatened use of force against himself.
Correct.
Unless the force,
The threatened force asserted towards
that's right,
defendant.
unless the threat of force asserted the threatened force asserted towards Chase Morris was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on Tola Thompson.
Agreed.
No objection.
And again, I don't think that the prior threats, specific act of victim or reputation of victim is applicable.
Agreed.
Right, physical abilities. Considering the issue of self-defense or defense of another. You may take into account the relative physical abilities and capabilities of Chase Morris and Tola Thompson. If in your consideration of self-defense or defense of another, you have a reasonable doubt on the question of whether Chase Morris was justified in the use of non-deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Chase Morris was not justified in the use of non-deadly force, then you should find him guilty if all the elements of the charge have been proved, right? 3.7, plea of not guilty, that is the standard instruction. I don't believe anyone can really have the argument to modify this in any way, but does anyone wish to be heard on 3.7?
No, Judge.
No, Judge.
3.9, weighing the evidence. Let's get into the give as applicables. Are any of the give as applicables being sought?
I don't think that 9 or 10 apply, Judge.
Not based on what we heard in the trial, no. Any argument as to 6, 7, or 8 from the state or defense?
State would request number 8.
Inconsistent statement. Mr. Pumphrey, any objection as to number 8 being given?
Yeah.
Right, what is your
Yes.
objection? What is your
I'm sorry.
objection?
Sure.
All right, you're objecting that an inconsistent statement was given during the trial?
Well, there was. Officer Bartholomew yesterday testified that it was not a thorough investigation. Today, the state asked him, you would agree this was a thorough investigation? He said yes. So there's an inconsistent statement.
Right, the state is seeking this as to which witness?
Which witness for inconsistent statement?
Look at my, 1 second, Judge.
Judge, I don't think 9 applies.
No, 9 and 10 do not apply at all based on the testimony.
And 10, I don't believe applies.
Judge, it's Sierra Roylance. I'm just trying to find the statement that she made that was inconsistent in all of my many notes here.
The defense is already requesting it as to a separate witness, so it'll be given as
Okay.
long as there's a basis in the testimony to argue the point. We really don't have to get specifically into who or what.
Okay.
So is the defense objection withdrawn then, since they're requesting it also?
They're requesting 8, so 8 will be given. As to 6 or 7, is there any request for 6 or 7?
I don't have any statement is heard. You still having trouble hearing me?
No, you're fine. Judge, for 6, Ms. Roylance testified that the defendant was financially, I don't know, responsible for her and their son. Now, there wasn't anything that said that she had been given any money, but I certainly, the defense asked her about that, is she financially dependent on him? And then I brought it up in my cross. So I certainly think it's fair game to argue that that is a benefit to her, the financial gain that she gets from the defendant. And if she doesn't testify, like she said, whatever happens to him affects her. So I think that's kind of fair game there.
I would respectfully disagree. I didn't see any evidence or testimony concerning an offer. I think it requires there to be some proof of an offer to influence or an offer to pay money. Their living pattern was the same before the incident, after the incident. The same issues applied. I don't think there's any evidence of any offer of anything new or different since the incident that would have influenced her testimony or anybody's testimony.
Well, number 6 is written in the disjunctive. So ultimately, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? As to the disjunctive of other benefit in order to get the witness to testify, the state can argue it, whether the finder of fact agrees with it. That's going to be up to them. We'll grant number 6. Number 7 is either party requesting 7.
Judge, I would request 7 specifically to the pressure. Can you do that? Specifically to the pressure aspect of it. So I do believe that the financial pressure that's on Ms. Roylance due to what came out in the testimony that she relies, seems like pretty much solely on the defendant. And I would argue that is pressure. And I do think that she is under some amount of pressure to testify in his favor because of that.
Right. Mr. Pumphrey also did publish her recorded statement, which was consistent more or less with today's testimony. Mr. Pumphrey, any argument?
Judge, it's pressure or threat used against. I'm just not seeing the against one. We all heard the same evidence. I think they live together. She pregnant, they had a child together. He runs the business, and she depends on him. But I just don't see that one section.
Right, I'm going to deny as to 7, 6, and 8 will be the give as applicable. So altogether, there will be the 1 through 5, which are standard, and then has the witness been offered or received any money, preferred treatment, or other benefit, and then did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court. And I believe in the last portion of this, the defendant has become a witness, so that portion does need to be given. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. I'm going to insert the give if defendant testified after the fact that a witness is employed in law enforcement.
Agree, Judge. Agree. No objection. No expert witnesses, Judge.
None.
Accomplices, informants.
None of those apply in any way, unless there's an argument that someone wants to make for them.
No, sir.
No, Judge.
That testified.
Right, defendant not testifying will be removed. Defendant's statements, a statement claimed has been made by the defendant outside of court has been placed before you. The defense requesting that.
Yes, Judge.
Right, rules for deliberation, that is standard as well. Cautionary instruction 3.11, standard as well. Verdict form, take a look at the verdict form. We, the jury, find as follows. It should be on the information of felony battery, great bodily harm, check only 1. The defendant is guilty as charged of felony battery, great bodily harm. The defendant is guilty of the lesser included of battery. The defendant is not guilty as charged of felony battery, great bodily harm. So say we all, for a person.
Judge, I understand we've addressed this. I just want to make this my client inquired of me about lessers and would request no lesser. Would require no lessers. Boy, projection much better that way. But I understand too that the state has the ability to amend their charging document, and so and the court's ruling. But
well, the category 1, your client is entitled to, unless the defense is not asking for the category 1 to be given.
Judge, would you like to inquire of Mr. Morris, make sure he's?
That's fine.
So if I could just say.
Go ahead.
It's your choice, not mine. The judge is about to ask you about it. So if you become a lesser, just so that you you say you don't. What you look at your required, if you refuse.
Right. Ms. Morris, you remain under oath, sir. As it pertains to lesser included crimes, by law, you are entitled to have the jury consider, if the state has not proven the charge of felony battery, whether you should be convicted only of battery. But ultimately with that, because you have prior history involving battery, this could still be a felony, even though typically it is a misdemeanor. Do you understand what I'm saying so far? No problem. You're charged with felony battery, which is a felony crime. The subset or lower charge of felony battery is misdemeanor battery. Now, by law, the jury is, or you are entitled to request that the jury consider that if the state has not proven the highest charge, that they move on to the misdemeanor charge. You are in a unique situation, though, legally, because you have a prior battery conviction, meaning even with a withhold in this circumstance, because you have that, even if the jury finds you only committed a misdemeanor battery, the state can seek to enhance it to a felony. Now, the question that I'm asking you is, are you waiving your right to have your lesser included considered by the jury and you only proceed on the main charge? If you need to confer with your attorney, I'll allow you to do so.
Just, I think I somewhere.
And Judge, I don't know if this helps or speeds the process along, but the state would be requesting it even if the defense did not.
Right. Mr. Pumphrey, did you hear Ms. Bingham?
I thought I heard her. I was trying to multitask. But
The state is,
asked for it, she did.
the state is requesting the category 1 be given even if there's a waiver by the defense.
The judge can explain it to you, but yeah.
All right. Mr. Morris, do you understand what it is that I'm asking you?
Yes, sir.
All right. Do you wish to waive this?
What do you mean by waive it, not having it on there? Yes,
Meaning,
I'll waive it. I will waive it.
okay, the state is requesting for the lesser included to be given as a category 1. I believe as a matter of law, it has to be given. So I understand your position for the record. On the first amended information, Mr. Pumphrey, have you been able to look at it? Right.
I
Madam
gave it
Court
to,
reporter,
the judge
if you
has
can
it, it hasn't
pass
been
up
filed,
Or put up
e-filed.
to the bench so you can take a look. You may. Go ahead. Right, how does your client enter his plea to the first amended information? Not guilty plea is recorded. Right, I will have my assistant print out copies of the amended instructions. Are there any more stipulations that the parties wish to be read as a part of the final instructions?
Nothing from the state. He said anything. But the identification stipulation will be read in the jury instructions, Judge.
Which instruction is that?
The stipulation of the ID of the defendant
Yes.
in the surveillance video.
Defendant,
That's already been
Chase
read.
Morris appears on the video surveillance.
Okay, just
Yeah.
wanted to make sure.
All right, if anyone needs to use the restroom, please go ahead and do that now.
Hopefully Miss Mary has change in her desk.
Oh, I'm sure.
Okay, I'll be back. I'll try to be quick like a bunny.
Yep. And I will.
Certainly stress is sitting next to you. You got that right.
Yeah, okay.
Can I follow you? Okay. That's fine. Yeah, exactly. I did that.
Yeah, I'm just gonna walk over and get it. Do you have any children still that be attending to?
About 1-year-old. So I have a new toddler.
Okay.
All 3 girls are in college.
I'll get it. Well, I don't want to presume. You never know. Good.
We do, but it's four-legged. That was really nice thing.
You got scared? You got scared? No, you're wrong. For you. I know. I know. That's how I want to go. I haven't learned anything else.
Not yet. My assistant is gonna bring copies and then everyone can take a look. And then we'll bring the jury back in. Well, you never know your day. Okay. Breeding the dog. So Mary,
I didn't want to run over you.
Your favorite dancer? Don't be a lot. Amy here is the. Good.
That's right.
Yeah, that's the big part of the art.
You will fail. She's taking care of the better job.
For a little bit, but then we're gonna have to put it back on.
I know.
Who's bringing that door?
Copies?
Right, that's all that you.
Oh, you're trying to call me. Yeah, I didn't see that until. Thank you, ma'am.
The jury seats are over here.
Yeah, the paper's still warm.
Probably couldn't follow off my screen.
Three back there?
Yes, all five.
Can't wear my glasses.
I know.
There's any indication on the courts or not? Whether to move out.
Did you put them in the first two also?
Those first three, these two?
Those two also, yeah.
Okay, I need to go make more copies.
Okay, take this one and I'll just go off my screen.
I don't need one either.
Okay.
Miss James has
Take
one.
Ms. Bingham's and then those will All right, has everyone been able to thumb through the instructions? Anything else to bring up before we bring back in the jury?
Not from the state.
Mr. Pumphrey and Ms. Keppel, anything to bring up on the instructions?
Probably equally started on. We are going to. Yeah, we all keep covered on life.
Good for you. All right.
See, you see the delay good? Good. Did you just see the delay? You got that, we all talked to their life.
All good. Have a good night. Ms. Keppel, anything to bring up on coming through? All right, let's bring them in. 45 minutes each side for closing.
Thank you.
Jury's entering the courtroom.
Everyone may be seated. Members of the jury, we took a bit of a more extended break, but this was to reach the point of the trial where we can proceed through the final stage without further delay to you. We are now going to go through the instruction on the law. There is a copy of the jury instructions that I'm about to read out loud. Everyone can follow along with those jury instructions if you wish to do so. If you do not wish to do so, certainly you can just listen, but it will be up to you. If you open up your packet of jury instructions on the 4th page, at the heading that is 3.1, Introduction to Final Instructions. That is where we are going to get started. All right. If the jury is ready, I will proceed from here. Hold your thumb up if you're ready and good to go. Ms. Nichols, are you good to go?
Oh, I'm sorry, yes, sir.
Very good. All members have responded in the affirmative. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. When the parties agree certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the defendant, Chase Morris, appears on the video surveillance. Statement of charge. Chase Morris, the defendant in this case, has been charged with felony battery, great bodily harm. To prove the crime of felony battery, the state must prove the following two elements beyond a reasonable doubt. Number one, Chase Morris actually and intentionally touched or struck Tola Thompson against his will. And number two, Chase Morris caused Tola Thompson great bodily harm, permanent disability, or permanent disfigurement. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of felony battery with great bodily harm is battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Chase Morris actually and intentionally touched or struck Tola Thompson against his will. Two, Chase Morris intentionally caused bodily harm to Tola Thompson. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. Justifiable use of deadly force. It is a defense to the crime of felony battery with great bodily harm, including battery, if the actions of Chase Morris constituted the justifiable use of deadly force. Deadly force means force that is likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. In deciding whether Chase Morris was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Chase Morris must have actually believed the danger was real. However, the defendant had no duty to retreat if he was not otherwise engaged in criminal activity and was in a place where he had a right to be. However, the use of deadly force is not justified if you find that Chase Morris used force to initially provoke the threatened use of force against himself, unless the threat of force asserted towards the defendant was so great that he reasonably believed he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on Tola Thompson. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Chase Morris and Tola Thompson. In your consideration of the issue of self-defense or defense of another, you have a reasonable doubt on the question of whether Chase Morris was justified in the use of deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Chase Morris was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. Justifiable use of non-deadly force. It is a defense to the crime of felony battery with great bodily harm, including battery, if the actions of Chase Morris constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Chase Morris was justified in using non-deadly force against Tola Thompson and had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself or another against Tola Thompson's imminent use of unlawful force. In deciding whether Chase Morris was justified in the use of non-deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of danger must have been so real that the reasonably cautious and prudent person under the same circumstances would have believed the danger could be avoided only through the use of that force. Although, as I have previously explained, the defendant had no duty to retreat. Based upon appearances, Chase Morris must have actually believed that the danger was real. However, the use of non-deadly force is not justified if you find that Chase Morris used force to initially provoke the threatened use of force against himself, unless the threatened use of force asserted towards Chase Morris was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on Tola Thompson. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capabilities of Chase Morris and Tola Thompson. If in your consideration of the issue of self-defense or defense of another, you have a reasonable doubt on the question of whether Chase Morris was justified in the use of non-deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Chase Morris was not justified in the use of non-deadly force, then you should find him guilty if all the elements of the charge have been proved. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some of the things you should consider are the following. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony deserves more consideration than that of any other witness. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside the court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, number one, whether when the defendant made the statement, he had been threatened in order to get him to make it. And two, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of not guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Actually, you don't have a copy of the verdict form, but I will read it to you. State of Florida versus Chase Morris, case number 2019 CF 3767. Verdict. We, the jury, find as follows on the information of felony battery with great bodily harm. Check only one. The defendant is guilty as charged of felony battery with great bodily harm. The defendant is guilty of the lesser included offense of battery. The defendant is not guilty as charged of felony battery, great bodily harm. So say we all, and it will be dated and signed by the foreperson. And lastly, closing argument. This is the last page of your packet. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments to you before deliberations. Please remember that what the attorneys say is not evidence or the instruction on the law that you have just received from me. However, do listen closely to their arguments. They are intended to aid you in your understanding of the case. Each side will have an equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, Ms. James, are you ready to proceed with the state's opening closing?
Yes, sir.
You may proceed.
All right, good evening. Thank y'all so much for bearing with us. I know that it has been a very long 2 days. I know y'all are probably tired, so thank you so much. If I could just get a little bit more of your time to wrap everything up for you, like I told you I was going to do an opening. Hopefully that'll make it a little bit easier for y'all. I know y'all are paying very close attention, so thank you. I'm going to do my best to just kind of wrap it up for y'all. What I like to do in my closings, because we have these really helpful jury instructions, if we could go to that page that's got the elements on there, and y'all can just kind of follow along with me. All right, so if y'all remember in jury selection, I did that like BLT example with the elements, and this is kind of what I was going to. So these are the elements that I have to prove. These are the things that I'm focused on in my case when I'm bringing forward evidence to you. So this defendant is charged with felony battery, great bodily harm. So I'm just going to read it off and go through it. So to prove the crime of felony battery, the state must prove the following two elements beyond a reasonable doubt. The first one is that Chase Morris actually and intentionally touched or struck Tola Thompson against his will. So I'm just going to start with that one, and what I'm going to do is we're just going to go through how we know that that happened. So it's not really in dispute. If y'all remember, a lot of what we were talking about, this is a self-defense case, so the fact that he punched him is not really in dispute. But real quick, I'll just run through the people that have talked about that to us. All right, so you heard from Tola Thompson. And if you remember, he is the victim in this case. He was, I believe, the first witness that you heard from yesterday. He tells you that on October 4th, 2019, he's at the Circle K gas station. He is pumping gas. He hears what we now know was Miss Roylance making a statement of, you know, hurry up, come on, let's go. And she testified that she did say that very loudly, so that corroborates what Mr. Thompson heard and what Miss Wiggins heard, that loud noise. He told you that upon hearing that, and I think Miss Wiggins probably did it best in her reenactment for us. Oh, shut it up, something like that. So you hear that Mr. Thompson says that, and in response to that, the defendant, and you see on the video, him running from the front of the store, and what I would characterize as rushing the victim from the front of the store over to the gas pump. Upon being at that gas pump, obviously we do not see the punch because it's behind the gas pump, but we know the punch happens because the defendant tells us it happens. Again, this is a self-defense case, so he tells us that he punched him. And Miss Roylance, although she did not see it, she now knows that a punch occurred. So I would argue to you that it's not really anything to go on about. We know the punch happened. We know that he did it intentionally. You have photos, you have the injury, you have the video, so we know that that happened. All right, so I just do a little check mark. Okay, that's done. All right, and element number 2. Chase Morris caused Tola Thompson great bodily harm, permanent disability, or permanent disfigurement. So that's really the catch here with this charge. That's really the thing I'm going to focus on right now. So how do we know that that happened? How did I prove that to you? Well, mainly through Mr. Thompson, and then you have the medical records and evidence as well. Those will stay out here, but if y'all need to see them, you just write a note and let us know, and you can review them if you need to. Mr. Thompson testified to you, and you heard in his the interview with Detective Abel, him kind of describing what happened as a result of being punched by the defendant. I also, if I could point your memory or point your thoughts to the video where you see Mr. Thompson fly backwards and land on his wrist or on his hands. So we, fortunately, because of body cam, we really get to see that wrist injury from start all the way to the end. So we see it right after it first happens. It's kind of swollen up. He's holding on to it. It's like the size of a golf ball. At times he's like, I don't really know, like it hurt. And I think at some points he's like wincing in pain, but he's like, I don't really want to like make a big deal of it. Maybe it's just sprained. And the officer's like, okay, well, if you need to go to the hospital tomorrow or whatever, you need to do that. So then we kind of get to the point where he does do that. So he does go to patients first. He testified to that. They do x-rays. They tell him like, yeah, this is broken and you're going to need surgery. And if you remember, I asked him, did you see the x-ray? Did you observe it? And he said, like, it looked like it probably was not supposed to look like that. So I think that probably gives way. It was pretty bad. And the only reason that injury happened is because he was punched in the face. And you kind of see that in the video, the amount of force that he flies backwards with. That's not like a trip. That's not a fall. That's an amount of force that is pushing you backwards. So anyways, you see the x-ray. He describes it to you. He then testified to you that he had to go have surgery. He's put to sleep for the surgery. He has 2 pins in his wrist from the surgery. And then he showed you, and you have a picture of it, the scar that is on his hand. And if you remember, this happened about a year ago, so he still has that scar on his wrist, and I imagine that you could even see it from the jury box. I would argue too that that's a permanent scar. I don't think that that's going to go away. But also, more importantly, he testified that it's affected his ability to do certain things that he could do before he was punched by this defendant. So the ability for him to move his wrist, and I think he sort of demonstrated that he doesn't have as much mobility in that wrist anymore. And I asked him, well, what are some things that you could do before that you can't do now? Just to give an example of what he was talking about. He mentioned push-ups, that before he could do push-ups, and now he can't do them. It hurts, he can't do them. And I think he also mentioned lifting heavy objects. And if you think about it, that makes sense because of where the injury is on his wrist and where he has the pins and where he had surgery. So I would argue to you that is great bodily harm. That's not a mere or just a bruise. That's not a moderate harm. That's not minor. That's not trivial or slight. That's life-changing. I mean, for the rest of his life, that's how it'll be. He'll have that scar, can't do the push-ups, has the pins in his wrist. So, the fact that he can't do push-ups, maybe one of you might think, okay, well, I'd see that as like a disability. You can't do something you used to do before because of this injury that you have. So there's that too, but it's an or. So great bodily harm, permanent disability, or permanent disfigurement. All right. So on that point, I would argue to you that great bodily harm was proven by the medical records, by his testimony, by the scar that you saw, what he could do before, what he can't do now. So I would argue to you that was proven to you. All right. 1 second here. You heard from Officer Bartholomew, as well as Detective Brittany Abel in this case, or Investigator Brittany Abel. The reason why I bring them up is because if you'll remember, you got to see their body camera in the interview. And I just want to point out to you, which hopefully y'all noticed, the victim's demeanor, Mr. Thompson's demeanor, was the same back then as it was on the stand. So he is generally he's just a calm person. I think at times he can be like a little bit odd maybe, or a little bit socially awkward, but I think that's just who he is. And you could see that in the interview where he did the photo lineup and on the scene. So I would if anybody was kind of watching him and thinking that, I think that's just his personality, and that sort of shows through looking at the stuff from a year ago. But what I wanted to point out is that he is calm. And I would submit to you that even when this incident happened, he was calm. And I believe he testified to that he was really just trying to de-escalate the situation. He says that several times. He's very consistent about that I was just trying to de-escalate. Please leave me alone. Please go away. Not tonight. And I think I would argue to you that what was meant by that is this is not what I expected when I said, oh, shut up. And I think that that's clear from the evidence that his intent was not to end up with a broken wrist and not to be able to do push-ups and a scar and pins in his arm. So anyways, I would ask that you just pay attention to his demeanor and how it's consistent throughout, even then all the way up until now. I'm not going to put a lot of weight onto the testimony of Sierra Roylance and the defendant. I would argue to you that, do they tell some of the truth? Well, they don't have a choice, right? Because we have surveillance. But do they add in some lies in there and some exaggerations? Absolutely, they do. The statement that, and I believe Ms. Roylance and the defendant both said this, that the victim yelled out, "Shut the fuck up," and then she yells back at him, "Who are you talking to? You shut the fuck up." And then he says, "Dumb bitch, you shut up or I'm gonna make you." I would submit to you that is a complete exaggeration. They are the only two people that say that, which is not a coincidence. As you can imagine, they are dating, they have a child in common, they are here to support each other. There was a statement that was made, she backs me up like I back her up. What affects him affects me. So they are in this together. But I would submit to you that added stuff is an exaggeration to make it seem as if this defendant needed to do something. Now, I still do not think that him running over there because of words is justified when he could have gotten in the car and driven off. But regardless, I just wanted to point out, I do think that that is an exaggeration based on the fact that none of the evidence supports any of that. The victim's testimony, Ms. Wiggins' testimony, does not support hearing really any type of arguing or going back and forth. She hears "shut up," defendant runs over, and then she sees the punch happen. So I'd submit to you that there was no like back and forth argument. It was really quite simple, and you can see that on the surveillance video. When you're thinking about the intent of Mr. Morris, and I'm not going to put too much weight on this either, but I did want to point it out. The defense, for whatever reason, during his direct examination, during the defendant's direct examination, brought up the fact that he employs Black people. I mean, yes, I know the victim is Black, but there's a reason they felt the need to qualify that or bring that up. If you notice, I mean, I've never mentioned that throughout the trial. We can see that he is Black, but I never made that an issue. The defense, again, felt the need to qualify that for a reason. And y'all are smart people, and I imagine that y'all can get back there and figure out why that might have been. I asked the defendant on the stand, had he ever, like, what does he refer to the victim as? And he said, Mr. Thompson. And then I was like, no. Have you ever referred to him by his race? And he said, well, I've called him that black man. Okay. And then I asked him, have you ever referred to him with a racial slur? And he says, I don't know. I'm not sure. I don't know how much weight to give that, but I did want to point that out to you, that the defense brings that up, that he employs Black people. It's something I explored. Just putting it out there. Maybe think about that when we're looking at why even run over there, turn around, walk away, and then come back and punch him. So I think it was put out there by the defense. I think it's something to think about when we're looking at the intent, and kind of just like, why would he do something that makes no sense like this? Why run up to him? Why? Maybe that's why. All right. I think that's about all I have for this first closing. I will get an opportunity to get up again because it's my burden to prove the case. So after the defense attorney does his closing, I will get an opportunity to rebut what he says. Ultimately, looking at the two elements that I have to prove in this case, I would submit to you that it really is quite simple. And sometimes the simple explanation is the best explanation. And those two elements, I think, have been met in this case beyond a reasonable doubt. And I would ask that you return a verdict of guilty as charged for felony battery, great bodily harm in this case. Thank you.
Thank you, Mr. James. Mr. Pumphrey, you can proceed.
Okay, please report, counsel. Members of the jury. It's been a long 2 days. So Chase Morris, from the very start, y'all remember jury selection? How long did that take me? Not very long, did it? This is a straightforward case. The state has put on a case for the last 2 days, and we put on a case for maybe 2 hours. Y'all be the judges of that. But why is that? Members of the jury, I submit to you that the state, upon hearing that opening statement, because they never had the opportunity to interview Chase Morris, and they're listening to his telephone calls with his girlfriend and everything else, and they're looking for everything they can to try to convince you that he has done something wrong. Now, members of the jury, you are the triers of the facts. Y'all are the ones who heard the testimony. I watched y'all. They're paying attention. You're taking notes. You've got the facts down. Now all you got to do is apply them to the law. And so let's go a little bit through the facts and how everything came out, and about how Chase Morris did what he needed to do, and no more, but no less. Members of the jury, things strike you as to Mr. Tola, and we're going to talk about that. But who says, shut the F up, just like I said in opening, in a calm, collected manner? Members of the jury, so much so that you can't deny what's on the video is you see a young man walking in, and he he obviously, you can tell now after he's testified, he talks a lot, he's nervous, and it's just a natural thing, and he feels like he's got to fill dead air. I was about to have a heart attack over here if he asked another question of the state attorney, because the judge kept telling him no, but he kept apologizing. That is his nature. He's just a talker. And I don't think there's any doubt about that. And so that's what he did that night. He was himself. So his pregnant girlfriend, who's 7 months pregnant, she wants ice cream. Well, it kind of, if y'all hadn't figured this out, she kind of tells him what to do. Now, he doesn't listen very well, as you can hear it and see what happened here today, but there's no denying that. I mean, she literally, but she's like a mama bear. When you see her on that video get out of that truck, she threw caution to the wind. He did the same. But he went a full-on stride, near about a full sprint. And what caused it? All the way across from the front of the store. It had to be like 60 feet. And there's cars going up and down Monroe Street. Y'all see the traffic? Y'all paid attention? I don't care if I ever see that video again. Mr. Morris and Miss Rolance, they go to get ice cream at Circle K. It's open, but it's 12:30 at night. She wants him to go with her. Okay, fine. The explanation for her driving was explained by Mr. Morris. She likes to drive. She likes to drive the truck, and they share the truck. He's usually gone on business with his company. There was no evidence that Mr. Morris was drinking. Tola Thompson had his bracelet on from the cigar bar. He said he had a drink. Y'all make the determinations of that. You were able to see the video, how he interacted with the officers, so you can make your own determination. But the concern and the focus has to be, what was it that was so great to scare a young lady like that? Whether you dispute what was said or what wasn't, and we'll get to that in a minute. But what caused a young man to go full on sprint like that? And he didn't run and just nail somebody. He ran like he was, like he was a linebacker in the NFL trying to figure out where's the next one coming from? Where's the next one coming from? And he kept pivoting, looking at his area. He has a hyper sense of awareness. And quite frankly, when he was testifying today, I didn't know how that was going to go, because I knew my colleague was going to just tear him apart as best she could. And I think she tried to do that. But the interesting thing is, that's the gauntlet of truth. If you can survive that, y'all heard in real time the reactions to this question. Did you not? And you saw how they reacted. You saw how they were I'm going to tell you, my head was hurting over here. I mean, it was like ask, argue, repeat. Same thing over and over again. Folks, you hear the same thing enough, you start wondering, well, maybe you can't get past the truth. That cross-examination is the gauntlet of truth, just as when we went through and cross-examined the state's case, they gave everything they could against those two. They listed the same witnesses available to them that we had to call. They didn't want you to see that. They should have called it in their case in chief. They want to give you the full picture, but they didn't. They want to win at all costs. And that's not the way we do things in the United States of America. Very famous justice once said, in our system of justice, we would much rather let a guilty man go free than even take the chance of convicting an innocent person. I respectfully submit to all of you. That's what Chase Moore said. Now, we didn't dip, dodge, dive, and evade the fact that he punched a fellow. And folks, you've seen Chase Morris. He played football at Childs High School. If he wanted to hurt somebody, they wouldn't have a little split lip. Now, the humanizing aspect is he feels remorse for it. He just didn't know that night. He was scared. That's what caused him to sprint across the parking lot. He was scared. Miss Roy Lance, they tried to attack her here today. That's why you were able to see that statement that occurred back in October of 2019. On 10/25, we had to call Detective Copeland. Why is that? That was recorded. The state attacked her like she was making something up. She's going to do this, and they pulled the tape call. Listen, I didn't like hearing killing. I didn't really know, but after she explained it, I was like, well, that makes sense. And everything she said, it made sense. No matter how many times she was berated, she'd come right back to the point she She was confused and shaking and everything else, but every time she came back, she was passing that gauntlet of truth. But let's look at the state's witnesses. Tola Thompson had the cigar bar, but did you notice when he was there and the cops were there and they're talking to him? Now, we don't even know who that first officer was who just happened to be there. And so he's trying to gather information. But did he say, you know, I said something I shouldn't say? I said this, I said that. He didn't write anything. He didn't say anything about what he did to cause that young man to go running across a parking lot 60 some odd feet because he's in fear of what could be going on. Now, a reasonable person at certain places, at certain times, in certain locations, would have a right to believe, based on their experience as a reasonable person, what goes on in their hometown. That's just human nature. I mean, for those of us who've grown up in this town, we've seen a lot of change, a lot of positive change, but there have been some bad things too. I hate hearing in the news that Tallahassee, Florida has one of the highest murder rates. You know, I hate hearing that people are getting robbed and carjacked, things that when I grew up on Centerville Road, we never locked the door. Now, if you're anywhere in the municipality, you got to lock it up. People are kicking open doors. There are crazy things going on. So a reasonable person would think at 12:30 at night, there's not a lot of good comes out after that period of time. But you're pregnant, 7-month pregnant girlfriend wants some ice cream. And believe me, you're going to get that ice cream. Any doubt about that? Anybody? So, and no offense to Mr. Morris, but Ms. Royland, she wears pants many times. That night she did. Did you see her? She wouldn't get in between anybody. She's trying to shove him outdoors. She's ready to go home. She's feeling crampy, whatever, tired. She wanted to get that ice cream. Did you know she didn't eat any of that ice cream? That's right. So Tola Thompson comes in. Now, interesting fellow. Now he's a chief of staff for Al Lawson in Washington, D.C. Last time I was in Washington, D.C., I was in 7th grade. It's the last time I was there. Not too sure I need to go back. But he's a big guy up there, and I talked to him about his lobbying efforts. And you remember all when I said, now, if it was to show up in the front pages that you were saying, shut the F up, and creating a fight and coming at somebody at a gas pump at 12:30 at night, that wouldn't be too good for you, would it? He said, no. See what you mean? You're daggone right. That's why when he wrote that statement, he didn't say, listen, I was out of line, said this, you know, they came over, you know, I was going towards the guy, whatever happened. But what you need to focus on is what that young man right there, a reasonable young man, was experiencing at that time. And the state attorney, they're the ones that are to bring you the proof, not us. We could have sat over here and twiddled our thumbs. Not done a thing. Not hurried through the jury selection. We didn't hurry. We paid attention. We didn't drag out the case and put on witness after witness after witness, put the same witness on. And then on direct examination, repeat that testimony so many times. How many objections do you have to make? Folks, I was getting annoyed at myself, but I have a duty to my client. I have to preserve the record. I don't like objecting. In fact, I'd rather sit there and go through the case without any objection. I'm sure the court would appreciate that. And I'll tell you who else, court reporter, clerk, bailiffs, they appreciate it too. Didn't take 2 days to try this case. It just didn't. Unless your case is falling apart, it's built on sand and not bedrock, like this young man in his defense of immunity. He has a right to stand his ground. He has a right to confront that threat. He has no duty to retreat. Did you hear how the state was going after him again and again and again? That's called a conflict avoidance. That doesn't apply in Florida law. He had every right to run out to the threat, and he was putting himself at risk. He didn't know if it was a gun, a knife, just somebody being loud and mouthy, but he was on point. And when he got on point, we can't see, but we do know from what he testified, and he broke it down pretty straight. And I think with cross-examination, if there was any question, it was eliminated on cross-examination that he was doing the exact same thing that he needed to do in that moment for him and his girlfriend and his unborn child. There can be no doubt about that. We see that burden shift to the state. The state's got to prove beyond its exclusion of each and every reasonable doubt. There's reasonable doubt all over the place here. Mr. Tola didn't hold up as well on the cross-examination. And folks, I want to tell you something. Listen, this isn't some game, these people's lives. It's Chase Morris's life. He's the only one sitting over there. He's the only one on the other end of that jail call. It's not the state attorney. It's not any of the witnesses or anybody else. And the state had Miss Royland sitting out there since Monday when y'all got here, shortly thereafter.
Judge, I would
all the way
object.
through
This
to
is not
today.
appropriate.
For one moment. What's the objection?
Just saying it's not appropriate that I had her sitting out there. She's a witness at the trial.
Oh, overruled. You may continue.
Let me say that again. The only reason is, y'all notice I go through out that door, or I don't know if you do, and I try to avoid everybody. It's not because I don't like y'all. It's because I don't want the appearance of impropriety. Every time I go out that door, that young lady's sitting right there. Okay? She's got a baby at home. She's got to have somebody take care of that baby. She's worried about whether or not the owner of the business that they're trying to build a family is going to be coming back home. And the state makes her sit out there on that bench, doesn't talk to her. They didn't give her a subpoena until the last minute, didn't let her see the video or anything. Now, we prepped this case before COVID hit, and Ms. Royland received a copy of her statement because I received it from the state. I thought it was right. Anybody who makes a statement like that, they should get it. They should have it. But she never saw the surveillance video. The state attorney who listed her as a witness, their category witness, never brought her in to show her the surveillance. Ask her, hey, tell me your side. Tell me what's going on. Did you see who had to call Detective Copeland? Sorry, I keep calling him detective. Whatever rank he's got, he's earned it. He's been around a long time. Why did we have to do that? As a state attorney, you should be a minister of justice. You should be seeking the truth, not trying to win at all costs. That wasn't done in this case. You know, you folks have paid attention. I don't have to beat that horse to death. You're not going to hear it 20 times. So Mr. Tola came from the cigar bar, said he'd been drinking. Y'all make that determination. Y'all been around folks that have been drinking and everything else. What's the strangest thing is how loud did he have to be from that distance, from the front of that door, to hype that young man up to the level he was to a fever pitch, scared to death, come over there, and you see him on point, pacing, looking around, and he explained it. He explained what he was doing. I'm looking for my peripherals. I'm looking for somebody come around here. Who's over there? Now, Mr. Tola admitted he has 2 milligrams RX for Xanax, which is in those same medical records. Y'all want to check it out, you look at it. And I'm just trying to look for explanations for why that behavior would occur to that degree to cause someone from that distance to react that way. And then when in that situation, to still remain scared. So much so that when he advances on him, he doesn't go after him. He doesn't lay into him. He pops him in the mouth and then backs off. You see him going back. That's the girlfriend comes rolling out. And the timing of when she came out is very critical because she could have said, I saw him hit him. I saw the other guy hit him. She didn't. She said, when I saw him advance to him. In other words, that's her senses that something bad's about to happen. Okay. And she's already scared. And, whatever else is going on in her mind that time of night on FAMU homecoming weekend. Listen, I don't like it when the Gators come to town for FSU. I don't like FSU homecoming. And the older I get, the less I want to go into town. But you got to remember, he's a reasonable young man who has a lot of experience in that area. They live right around the corner. They know the traffic of that area. They also know the people that frequent that area. Y'all have the records of his treatment. Y'all take it back there. You look for the Xanax, whatever you need. Said he heard loud screeching noises coming out of the store. However, you saw the video the state played. She was outside for at least 2 minutes. Mr. Morris was inside the store. Chad, you see him give the homeless guy a hug? He's just a talker. I can't shut the kid up. But that's what it is, isn't it? And that's what I told the show man. I said, if you go in there and you tell the truth, same way Ms. Rollins, just tell the truth. It will set you free. And that's what he did. Mr. Thompson, though, did he ever admit to anything he did at any time whatsoever with any law enforcement? Did you notice that? Did you catch that? He was asked to give a written statement. He's got an opportunity to say everything. Very short. Maybe he's tired. You can give him credit for all that. But he didn't tell the officers anything. In fact, the second officer on scene, the first one was just there, Officer Bartholomew. And I felt kind of bad for Officer Bartholomew because I kind of do this for a living. I see a lot of officers. My background involves law enforcement, prosecution, now criminal defense. And so I can relate to what he's going through on a busy night. And I'll tell you, he's a fast talker, isn't he? Whew. I'm glad they recorded it because I could play it back, catch every word. That's okay. He's doing his job. He's trying. But you know what offended me? Offended me in my background and appreciating what these people are doing. And it's a tough time to be in law enforcement. There's a lot of change in this country, and it's needed change. But that officer's up there, and I just called it. I said, listen, you're human. It wasn't a thorough investigation. He said, yeah, I agree. It wasn't a thorough investigation. Only to have the state attorney call him back to the stand today, and at the very end ask him, well, that was a thorough investigation. Did you notice I retained Officer Bartholomew? I didn't call him. I wanted to talk to him because I don't think he realized what he said, because there was no doubt when I walked him through every step that was missed or person's name that wasn't taken. The first officer's name wasn't disclosed. They didn't capture it. Well, it's a busy night. Give him some credit. But don't say it's a thorough investigation when it's not. Why would you do that? Why would you put an officer at risk like that? He could lose his career over an inconsistent statement. I just pulled him aside and told him. I said, I don't think you realize. Because as an officer, he's trusting the state to lead him in the right direction on things. They led him right into an avalanche. You should have seen his face. It was beet red. He didn't realize it. I'm not going to beat you up on it. I'm not going to call you, but I want you to know about it. Because you said this on one day, then you came in, maybe you're not paying attention, and the state got you to say something different. Well, that's that officer's career, potentially. He didn't mean to do it. I knew he didn't. That's why I didn't have to call him. I didn't have to go through all that stuff. That's a waste of time. Let's just get to the point. Either Chase Morris was scared and was reacting to what was in front of him at that time, or it was. And y'all are going to decide that. But Mr. Thompson, I keep coming back to him because he kind of waffled on the shut up. In fact, when he first testified, he denied it. He said, shut up. Then he denied it with the state and then agreed. He said, shut up. And if he said the F word, it was inconsequential. It's been a long time since I've heard that word before. Inconsequential, it means it doesn't matter. He basically was conceding to, shut the F up. Or that's the way, y'all take it any way you want. That's why you're in trial or fact. Then he changes to, hey, you all shut up. His sworn written statement, time wasn't limited. Why not include some of the details? Shed yourself in her light. Give everybody the big picture. You remember, Mr. Thompson, they exchanged words. Did you notice in the video that's in evidence? Y'all can look at it. With Brittany Abel, she presses him on that. Exchange of words. What does that mean? He dipped, dodged, dived, evades. She keeps pressing him. He downplays. Why not just accept responsibility for it? But it keeps changing. Do you know whose statement didn't change? Jared Lawrence, Roy. we'll mess that name up to catch me off guard, was. That's why we were able to show you that video, because the state attacked her like she had some motive to lie. Probably played the killing and stuff. Brought this thing out like she had some reason to lie or something else. Did y'all see that thing? That was from a year and however many months ago. It was a mirror of what she said on that stand. And a mirror after drawing through the gauntlet of truth. The gauntlet of truth. Mr. Tola Thompson, not so much. Why is he dodging all over the place? Nobody says, shut the F up in a calm and cool manner. Unless they're a sociopath. I don't know. I don't know the guy. But I know this. It was enough that night to scare that young lady. And it was enough that night to cause that young man to go sprinting across that parking lot and protect his family. Unborn and present. Well, why even say anything? I've been getting gas for years. Y'all won't get gas. If you drive cars, you do. Price is going up. You ever sit at the pump, start yelling at somebody on the other side? Yell so loud they can hear you all the way inside the place? So much so, the young man starts almost a full, not a full sprint, but he was striding over there. That ain't how he walked in. Something. What is it? What is it? Mr. Tola Thompson isn't telling you, isn't telling the state, isn't willing to concede and say, listen, someone, you heard this young man say, hey, I wish that had never happened. I wouldn't be sitting here. I wouldn't be. It's not worth it. But I felt like I had to, I was scared. Hindsight's 2020, Monday morning quarterbacking, whatever you want to call it. That's the state's case. Monday morning quarterbacking. Remember Mr. Thompson's demeanor yesterday? He was calm, soft-spoken. I lowered my tone. But how was he that night? Ask yourself, calm, soft-spoken, de-escalating. Nobody would ever heard it. Nobody. Now, I'll tell you, the state put on a witness that was over there, and she thought it was funny. I don't see anything funny about the last 2 days. Y'all? No, not a thing. Why not just get your gas? Go home. Why say anything? You don't have to. I know I sure haven't. 57 years. In fact, I'd be afraid to. There had to be something pretty magnanimous to make me even say anything other than good morning or good afternoon. And I usually don't even say that. I just want to get my gas and go. Because you never know what's out there. And gas stations are just a hive of activity. All types, good and bad. Ms. Rollins was 7 months pregnant. He was yelling at a pregnant woman to shut the F up. Who does that? I mean, he says it's inconsequential. It ain't inconsequential to me. If you say it to me, I'm a pretty big fellow. All right? It doesn't add up. Doesn't make sense. That's because it's not true. When Mr. Morris was still inside the store, you recall Mr. Thompson was outside all the way across. And Mr. Thompson sat on the stand. Now, I'm going to give some deference here, okay? I'm going to tell y'all, that Zulu time, I think I messed that up. Because state didn't know either. But it says that 3.5 hours I was hammering him with, because I couldn't figure out why in the world would you leave your car hooked to a gas pump for 3.5 hours? Well, folks, I don't even know to this day if we can figure out the exact times, but I know for one thing, I'm going to be straight up with y'all. That Zulu time thing I crossed him on, that's on me. That's on me. And that's the truth. But I didn't realize it until officer, I'm like, wait, did I have an aneurysm or something? Did I read it wrong? I had my assistant pull it up on the computer. I'm looking at it. I'm like, it's right. So first officer gets up there. It's his tape. I take the computer up there. I can't show y'all because it's not in evidence. But I'm wanting to know, why does it say almost 5 a.m.? And we know it happened between 12:30 and 1, depending on which clock you're looking at and what you're dependent on. Hey, but that's the truth, isn't it? Hey, do you think I'm perfect? If y'all know anybody's perfect, point them out to me when you're done. I'd like to meet them. But I'm also have an emotional intelligence. Say, hey, listen, folks. Credibility is key here. Professionalism is key. Let's get it right. Let's don't even take the chance of convicting an innocent person. Just like a famous justice said. Mr. Thompson was weird. Y'all are going to have to figure this one out. Why was the judge having to tell him to respond to questions? Now, some of them may have been in that category with the Zulu time hours. That's on me. Don't hold that again. But all that other stuff, that was the weirdest thing I've ever seen. I've tried a lot of cases on both sides. I don't think I've had a judge have to tell somebody that many times to be responsive. The simple things. But it was the one key thing that dealt with what the exchange of words were, the same as Brittany Abel. Don't remember that? Chief of Staff, member of the House Financial Services Committee, lobbyist. I can't help business if you get caught up in some mess like that. Thompson never purchased gas. Well, it makes more sense after we figure out the Zulu thing. The streamline, I just couldn't figure out why somebody leave their car there for 3.5 hours. Got to be something wrong there. I brought that out. We put that to bed. What happened behind that pump? Minutes passed. Now, Mr. Morris was able to elucidate. There's about 4, 5, 6 feet. You can take 4 feet if you want. 6 feet if you want. You're the trier of the fact. You determine what is factual and what you find. But it made a lot more sense then. And when he actually took the stand and she was cross-examining him, it made more sense because you remember how many times I had to object to leading on the state's own witnesses? There's a reason for that. Now, you grab it. Put it on, please. You've got photographs and you saw the video, and you can see it again. You'll have to come out here. The photographs you can take back there, but you can look at them and you can make your own determinations as to Mr. Thompson. He said he had a drink. He sounds pretty fine when we listen to the video. But did you see the officer's response to this injury? Now, listen, I feel bad. I fell backwards and everything, but it wasn't the force that sent him reeling backwards. It was being off balance, and it was a pop in the front of the mouth. So I don't know how the balancing was. Unfortunately, we don't have that side. Otherwise, we probably wouldn't be sitting here. We had a video from the street show it in, because then we could see everything. But the other thing that struck me when I first looked at this case, well, if he's trying to do something, trying to hurt somebody, first thing he would have done when he ran over there, when he had all that force and momentum, he would have just clocked the guy. He didn't. He stopped. He didn't clock him right away. He's looking around, looking around. They're exchanging words. That's for Mr. Thompson. But when he advanced on Mr. Morris wasn't trying to size him up. The sucker punch thing, I got that out through the officer. That was just him trying to speed things along. There was no sucker punch. That was a straight on, and not even a follow through punch. Not something that would twist his jaw and make his lights go out. He got up. Now he did go backwards. And I was a little concerned about the gas hose and the proxemics and all that. We all figured that out. Long and the short, we don't have anything. He popped him in the mouth. He didn't go and get on top of it. Didn't start pummeling. That'd be a different story, and we wouldn't be here for that one either. Andrew Bartholomew. Didn't obtain written or recorded reports. Didn't get the name of the officer who was initially on scene. He was busy. I'm not beating up on him. Y'all understand that. And Mr. Carpenter, I imagine nobody can find Mr. Carpenter anyway, but you know, he was in and out of everything. And if y'all didn't figure it out, they were trying to help him by not arresting him for trespass because they had trespass on that place. That's why it seemed a little funny. And that may be why the officer didn't really follow up on that, but that's not it. You don't have to go there because we already told you he popped him. What we're saying is he had a reason. Same reason that he ran across the parking lot. Same reason that when he's in there and he's looking around and he's scared, he doesn't know the fellow. Now, Kiana Wiggins, did y'all catch the fact that she's a medical assistant? And she thought it was funny. But okay, I'll give you that. Whatever you want to spend on it or whatever. Weird's going on there. Well, wasn't weird? If you're a medical assistant, you got all that medical experience, why didn't you go over there to that man? If you thought he was so injured and this was so wrong, why not? And she told you, she said, oh, I never went in the store. Well, that would raise issues. Well, you folks take it. Did she forget? Was that something that was a memory issue or was that intended? But when the state played that tape, we know who was all up in the store. Y'all decide that. It really doesn't matter. What matters is what caused that young man to go across that parking lot? What caused him to react that way? I just had a feeling Ms. Wiggins had a bias when she said it was funny. There's nothing funny about this. She said she never went in the store. She went in the store. Well, that's inconsistency in statements. You can take it for what it's worth and weigh it. But when Thompson went in with Brittany Abel, let me go through the different things he said to her that he never said before. He's played, we exchanged words. This is what Detective Abel was trying to get to. Not tonight. Can you just turn it down? Bring it down. Be quiet. You got something to say. Really? Away from here. Not tonight. Had you heard any of those before? Officer Bartholomew, did you see any of that at all? What would be wrong with saying that? That sounds more like somebody that's just shifting like sand all over the place. Why do they do that? I'll tell you two people that didn't shift. Not one lick. That was Chase Morris. And that was Sierra Royal. And none of those things were reported by Kiana Wiggins. None of those statements, the list I just went through. Why? Sierra Royland's consistent, scared, felt threatened, pregnant, late at night, hurry up. Seemed a little frustrated with Chase over here. Chase was talking it up. She explained that every time they go someplace, it's a problem. It's always talking to people you hadn't met. Never met a stranger. Man started screaming, threatening her. Shut the F up, or he was going to make her shut the F. That second one is the kicker. You know what? That's about the time he heard it. That's the part he heard. That's a threat. That's a legitimate threat. People today have come jack your car or pull out a gun or baseball bat, all kinds of crazy. You don't know. And I'm not trying to beat up Mr. Thompson or say he's any of those things. This young man didn't know, but he heard some fighting words. He heard a threat to his pregnant girlfriend. Chase heard him threatening, went over to the man. When Chase was walking back, they talked. The man advanced on him, and that's when she got out of the truck because she was in fear of something happening to him, and she's got his back. And she goes over there, and by that time, she didn't even see the punch. It doesn't matter, we told you about it. Didn't know if he had a gun. They left and drove that night and drove around and went to friends. Yeah, they admitted, yeah, we probably should have called 911. We could have done things different. Hindsight's 20/20. On 10/25, she gave Detective Copeland the truthful testimony. Didn't know it was being recorded. Just sitting there talking with him. He's doing some good law enforcement. In fact, I told him, I said, man, I'm glad you were on it that day because we got something to show the jury that eliminates any question of what her story was back then and what it is now. Consistent. Chase testified. He heard a threat. Members of the jury, Chase has a nervous laugh and everything else, but that was a hard thing on that. It's hard. He held up the gauntlet of truth. He ran to put himself in between the truck and the threat. He had every right to stay there and not flee, to stand his ground. Why is the state cross-examining on a conflict avoidance? Conflict avoidance, like you want to stay away from everything. In Florida, you have a right to stand your ground. He wasn't going over there, except that he had a threat, a well-reasoned, reasonable threat that he responded to. That's why he ran across there. And it had to be one heck of a one for him to react like that from that distance. State's cross of Mr. Morris may have been affected if Florida law was different. Why would a prosecutor cross-examine somebody not on the law, but on a conflict avoidance that's not part of the law in the state of Florida. I respectfully submit to you, it's a little bit of a red herring. Members of the jury, the judge has read you some instructions. The one that I'm gonna focus on, justifiable use of deadly force. You got it in your packet, 3.6G. It is a defense to the crime of felony battery, great bodily harm, including battery, misdemeanor battery, if the actions of Chase Morris constitute the justifiable use of non-deadly force. We're not talking about deadly force, non-deadly. Non-deadly force means force not likely to cause death or great bodily harm. And great bodily harm means great as in distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises. Chase Morris was justified, I'm reading from the instruction, was justified in using non-deadly force against Tola Thompson and had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself, catch this, or another. You got a twofer. Tola Thompson's imminent use of unlawful force, when he advanced on him, he interpreted that as I'm about to get punched. I need to pop this guy and get some distance. And that's what he did. Didn't jump on him. Deciding whether or not Chase Morris was justified in the use of non-deadly force, you must consider the circumstances in which he was surrounded. He, that's Chase Morris. At the time the force was used, the danger need not to have been actual. This is the instruction the court has charged you with. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, like Chase Morris, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. He reacted. He wasn't setting the guy up. He was reacting to his advancement. The defendant had no duty to retreat. I'll let y'all read the rest of that instruction, but it explains it. The judge has charged you with it, and that is your duty. Members of the jury, I'm sorry I've talked this long. I'm so sorry we've been here for 2 days. And I'm not taking away from the state. They got every right to do their job. But folks, y'all make the determination in this case at the end of the day. In that verdict form, Mr. Morris and I, we're asking you to check that box, not guilty. Not guilty. Not guilty of a misdemeanor battery, not guilty of felony battery, great bodily harm, not guilty of anything. Because of this instruction I just read you in Florida, you have no duty to retreat. And something caused him to go over there. And something caused him to react to this man. And the state has not disproved any of them. Members of the jury, weighing the evidence, did the witness seem to have an accurate memory? Mr. Thompson, well, you make that determination. Was the witness honest and straightforward in answering the attorney's questions? Did the judge have to, sitting in the instruction, but did the judge have to prompt him to answer the question? I'm adding that in. It's number 3. Did the witness have some interest in how the case should be decided? Do you think Mr. Thompson wanted to be on the front page of the Democrat? Acting the way he did? Members of the jury, I'm not going to belabor this anymore. Just go back there. Appreciate your duty. Go do your duty. Deliberate, follow the instructions of the judge, and in this case, follow the law in the state of Florida and find Chase Morris not guilty and let him go home to his family.
James, are you prepared to give your rebuttal closing?
Yes, sir.
You may proceed.
Thank you. The reason I put your screen up is just, y'all look at that. Where's the danger? Where's the threat? Where's the danger? You see Mr. Morris, you see his truck, Ms. Roylance is in the truck, Mr. Thompson is on the other side of that gas pump. Where's the threat? Nowhere. You do not get to create the danger and then say, oh, well, I had to protect myself from it. That's not how this works. That's not how self-defense works. We can turn the lights back on. Thank you. I don't know if y'all notice how the defense spent a lot of time talking about stuff that's not evidence in this case. What happens when there's not a lot to go to your defense, self-defense. There's not a lot to say about that because that's not what we're dealing with here. A whole bunch of talk about stuff that doesn't matter. Look at the evidence. The evidence doesn't lie in this case. The video doesn't lie. What we say as the lawyers is not evidence. We're just arguing to you, but what the testimony was, what the physical evidences that you have, that is the evidence that you are to consider. So if your memory tells you something different than what you hear, rely on that. Rely on the video, rely on the testimony, rely on your notes, rely on each other. And I submit to you that if you do that, you will see that there was no danger here. There was no threat here. Mr. Morris was the threat. He created that. Why would you approach somebody, right? So if y'all remember, he mentioned something about like Tallahassee's dangerous and FAMU's kind of FAMU homecoming is dangerous. Okay, well, let's say that that's true, right? Let's say he really feels like that. So FAMU homecoming weekend, the scary weekend, right? It's so dangerous. So you go run up on a stranger to confront him? That doesn't make any sense. Right? But you're so scared, right? There's this big threat. So you go run up to him instead of just getting in your car? Miss Roylance was in the car the whole time. It's a 4-door truck. Get in the car. Leave. Not once do you see Mr. Thompson move from outside that gas pump. He never runs towards Miss Roylance. He never runs towards Mr. Morris. Never. All right, so going to the self-defense instruction, the justifiable use of non-deadly force. All right. In deciding whether Chase Morris was justified in the use of non-deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. Okay, so what were the circumstances? He ran up to him. He created the circumstances. He created that. I pulled up the video so that you could see kind of, again, what that scene looked like. Mr. Thompson is nowhere to be. He's not running around anywhere. He's not wielding a knife or a gun. Those are the circumstances that we're dealing with. We're dealing with Mr. Morris running up to him, confronting him. If anything, Mr. Thompson should have done something. I asked him, did you even defend yourself? Did you do anything at all? No. I asked Miss Wiggins, did Mr. Thompson do anything? No, I mean, he picked up his glasses, but no. And if you remember her testimony, she was yelling at him, pour the gas on him. He didn't, but you know, a reasonable person in that situation, do something. You've got somebody who's running up to you, but he doesn't because it caught him off guard. He told you that when the defendant walked away and he came back, he was like, okay, it's over. I'd submit to you that the defendant did that to catch Mr. Thompson off guard, which is shown by how he got punched. He flies backwards and then he does nothing. He's completely caught off guard by this defendant running up to him. So consider the circumstances by which he was surrounded. Mr. Thompson standing there talking, please leave me alone, shut up, whatever he was saying. We know he didn't have his fist balled up because they told us that. We know he didn't have a knife because they told us that. We know he didn't raise his fist because they told us that. They meaning Mr. Roylance and the defendant. He told you to shut, or told your girlfriend to shut up, or told you to shut up, so you run over and punch him? Since when did that become okay? All right. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of danger must have been so real, that a reasonably cautious and prudent person under the same circumstances would have believed that that danger could have been avoided only through the use of force. Again, we're talking about Mr. Thompson, who according to the defendant and Ms. Roylance, never raised a fist, never balled up his fist, didn't have a knife, didn't have a gun. He said, shut up. And he yelled it out. He didn't say it to their face, right? Remember, she's in the car, he's in the store. What danger? Where's the danger? Where's the threat? Where's the danger that must be so real? It's not there. Because this is not a self-defense case. That's not what we're dealing with. We're dealing with a hot-headed defendant who didn't like Mr. Thompson yelling, shut up. That's what we're dealing with. So he confronts him about it. There's some language in there that says it's not, the use of non-deadly force is not justified if you find that Chase Morris used force to initially provoke the threatened use of force against himself. I want to highlight that because that's exactly what I'm arguing to you. He created this. He provoked this. He walks up to Mr. Thompson, runs up to Mr. Thompson, turns around, comes back, turns around, comes back. What in the world? Just go get in your car and leave. Mr. Thompson never chases after. I mean, what are we doing? Why is he doing this? Mr. Morris provoked this situation. He created this situation, and you saw that on the video. All right, a couple more things that I wanted to highlight. You can determine for yourself Mr. Thompson's, I don't know, demeanor. I'd submit to you that he was calm. He was not under the influence of anything. The Xanax situation, I don't really even know where that came from, aside from that he's prescribed it. And he said, like, I don't take that normally. His medical records just show like what he's prescribed. So that's in there. I don't know what relevance that has to this night. But you can watch the video for yourself. I mean, you did watch it. Submit to you that there was nothing wrong or odd about him that night. The defense brought up his demeanor on the stand when they were crossing him. And I want to highlight this because the defense said that like he wasn't answering the questions. He was just sitting there staring. And he was. But think about what had just happened. The defense had just crossed him on this whole thing. You left your car there for 3.5 hours, Mr. Thompson, and you don't remember that, do you? And he's sitting there like, no. I mean, I think genuinely he was confused, which is why he just stopped responding. Yes, he's supposed to answer the questions, but if you're confused and you're trying to figure out what the heck, I didn't leave my car there for 3 hours. The defense was trying to make this point that he couldn't remember because he was drunk or because he was high. And then it was like, oh, oops, it wasn't 3.5 hours. And he wasn't drunk or high, and he does remember what happened. And he told everybody what happened. On that night when he talked to Officer Bartholomew, number one, he had just been punched in the face for no reason, caught him off guard. His wrist was broken. He still provides a statement. He didn't have to. He could have said, no, I'm in pain, but he does. He tells a story. He's coherent. He makes sense. And then the next officer to talk to him is Officer Abel. And yeah, she's like, okay, tell me what they said. If you remember, that's the first person to ever ask him, what did he say to you? What was the conversation? Officer Bartholomew never asked him that. He said, write your statement. Let me take some pictures. Let me see your wrist. You want a victim's right pamphlet? You want to go to the hospital? He never asked him, hey, give me specifics. Let's really go through this. But Investigator Abel does. She's a lead. It makes sense for her to do that. So when she does, he says to her exactly what he said on the stand. I asked him to leave me alone. I said, hey, not tonight. And I'd submit to you it's because when he yelled out, oh, shut up, it was not because he was trying to like fight anybody. Tyrona Wiggins, she was really the best. You know, if you think that the victim was drunk and you don't want to listen to what he's saying, well, listen to her. She's an independent witness. She has nothing to do with anything in this case, aside from that she saw it. And everything that she says supports what the victim told you. That he's standing there, the defendant rushes over to them. Remember, she's even like, he's looking at me and Mr. Thompson, and she's looking back at him like, don't come over here. So just think about that when you're weighing all the evidence in this case. Think about what's consistent, right? An independent witness, someone who has nothing to do with anything. Her story is consistent. What she tells is consistent with what Mr. Thompson says. It's consistent with the video. It's consistent with the interviews. The defense says Miss Roy Lance wears the pants in this relationship, and I just thought that was interesting because if you remember when she's interviewed by Investigator Copeland, she's like, I don't want to say too much until I talk to him. I don't want to write a statement until I talk to him. Why do you need to talk to him for? Because they need to get their story straight. Otherwise, why do you need to talk to him? I don't want to say too much. I don't want to say too much until he tells me what to do. I don't want to say anything wrong. Well, there wouldn't be nothing wrong about the truth. You don't need to go talk to him unless you need to make sure that y'all's stories match. Y'all, they have exaggerated what happened so that it fits this whole self-defense thing. That's not what we're dealing with here. Like I said before, this is really quite simple. This defendant, for whatever reason, decided to play big bad wolf that night and make a choice to rush over to this person that he does not know, confront him, have this back and forth with him, and then punch him in the face. Totally unnecessary. But when you're a hothead, that's what happens. You do stuff like that. He caused this victim to fly backwards. He hit him so hard that he flew backwards onto his wrist. His wrist broke. He has pins in his wrist. He can't do push-ups anymore. He's got a huge scar on his wrist. That is great bodily harm. That's not some slight little thing that healed, the next day. So look at the evidence in this case. Look at what's consistent. Look at what's supported by the actual evidence that you have. I imagine that if you do that, I would submit to you that if you do that, you will have no problem finding this defendant guilty of felony battery, great bodily harm. Thank you.
Thank you, Ms. James. Members of the jury, now that the attorney's work is done, it's your turn to begin deliberating. Before those deliberations begin, we are going to excuse the alternate jurors. If the clerk could please excuse the alternates at this time. Mr. Russell and Mr. Ochoa, excuse me, Ms. Ochoa and Mr. Russell, you are excused at this time. And if you would like to remain to watch the outcome of the case, you're certainly welcome to do so, but you're free to leave. We thank you for your service during this trial. For the other members of the jury, you can take your notepads with you, but please leave your copies of the instructions in your seats. You will be given one copy of the instructions along with a verdict form to consider while you retire to your deliberations. Also, I believe, is the dinner here as well. Very good. Your dinner is awaiting you. You may rise and prepare for deliberations. If the attorneys can please leave a phone number with the clerk in case we have a question or need to reconvene. We are otherwise in recess unless someone has something to bring up at this point.
You want to use this paper? Take the video.
So medical stays out here, the discs stay out here, the photo and written statement can go back. A few of the pronoun errors that I caught in the instructions, I'm just going to clean those up, and that will be the copy that goes back.
So today, we don't have a this on the record?
No.
Oh, okay.
All right, we are in recess.
Okay. Include all the chargers.
Thank you.
Yes, sir.
Yeah, I believe so, but if she doesn't, I'll just give it to you now. Okay. How you doing, young man? Good, man. It's a pizza for you. Okay.
Right. You tell you this, you lose state.
No problem.
39292.
No, I did it to her too.
Right.
So she just paid me back.
Mm-hmm.
For not getting married.
That's me calling, but this,
Okay.
Yes, sir.
Let me get you the copy of the instructions that you're gonna take back. Unless it's gonna be a safety issue for you all, just leave them the way it is.
And were they given the,
Yeah.
were they given the verdict form?
Now, I'm gonna give you a copy of
I'm so tired.
Need something in there.
I'm hanging.
Man. You got it? Yeah. Yeah. Without that, over.
Yeah, Tom.
Thank you.
Feel bad for anything.
Well, I'm just gonna get some of these, anything, you gonna see me like, I was at the gym.
Like, do you mind if I go there and pull them? Yeah, I was like, you have plenty of time.
I got you. So, second, sir, that is?
Do you wanna leave?
I'm staying here. I'm staying here. Oh, this is mine. Oh, here's mine.
Yours is covered.
Eyes twitching.
I'm hoping to read as many times down. Wish I drank soda because I have my.
Oh, it's good that you don't.
I haven't for like 2 years. I quit. I thought it would make me lose. I thought it would make me lose weight.
Did it?
No.
Of course not. You just gave up on something really good.
Yeah. So part of me is like, I should just, but I used to be like really bad about it.
Okay, that's fine. It'll start running together.
Yeah, what's if, did Mark go down? Yeah, we're good.
Yeah, that's wonderful. I had my husband say, because there's you and Steve. One reporter that worked in.
Right, it used to be Steve, but not Steven. He retired.
Steve did a good job.
He was great. I loved him because he was like slouch back in his chair.
I really don't. I was so, what was that movie? What was that movie? I really needed my.
You've done it, a few of my cases, I don't remember.
I did your first one.
You did my
Yes.
first. Oh, we shared that experience. Every Williams. Did you do the whole thing?
I did the whole thing. Yeah.
I was that, remember the fight outside the courtroom? Remember that?
Yes,
Because the brother on rebuttal, it was a murder where all my witnesses were the defendant's family members, their cousins. And so this man was just against him. He did. And it was a really, I put in some work to get this against him, but they came and they did a wonderful job and, you know, they had other family members in the courtroom. It was all family, right? The defendant had shot someone who was not family. It was his brother's best friend. And during the trial, the defense basically threw under the bus the defendant's brother. He was had refused to come to court. He basically called me and said, I'm not my best friend with my brother, like I just lost my best friend, I don't want to touch against my brother. And I was like, oh, cool, let me just say this. Everybody knew about that party that Wednesday. So if you don't, I can replay what's gonna happen. And after that was home, the mom threw him under the bus, like, oh yeah, we got it done. You remember when she said they had to eat? So he, oh, I know. I know. They were all like, my program was like, I love it. I forgot we shared that.
Your mom.
My mom came and my husband came and my dad came. Everybody came. It was my first murder. That was like,
That's why we're going to change the indictment.
yeah, I had to go to the grand jury in the morning. Please leave the case defendant. He said, "Have a long day." You remember that? And I was like, yeah.
I remember there was a lot. It was
It was a lot.
He literally
shot
like no reason. Totally out of the blue.
came up to him and was like,
So I think he was tried, but we don't know if he's doing his letter and things, but basically not. We did an argument on a front doorstep. And not an argument, but the Democrat reported it. Creative discussion. They thought that it was an argument. The defendant asked if he wanted to steal. And the defendant was like, no, it's like I want my life. And then the defendant shot the gun up in the air. He was like scared now and he didn't want to know. And he shot him in the mouth. And then the guy started to get the gun. And then he walked away from the gun. And then came back and walked inside and shot him across the head. And then put him up on the gun. Crazy person. I know.
And nothing.
And I never found out.
This was all over the offer of the people. Sure said yeah.
Yeah, I know. I can say that's really a good one. Yeah. It was really, I mean, that's wild.
and then like you're thinking like, oh, that's like my best friend's brother. Like you're not, you probably think I'm gonna know it.
And there was a lot of people, I mean, it was a bunch of cousins, and they used to like, they were older guys, in their late 30s, early 40s.
Wasn't a family party.
It was like, they had a family property out in Buffalo, and they would go to football, they would just all meet up, all the cousins, and watch football. So that's how all the cousins were there. So it was just like,
And naturally, when you go to a family gathering, you're hacking, like you're.
yeah,
Right. Like, okay, we're going to see this family.
Why are you doing that?
Family football.
But
No, there was some testimony that he didn't really come around the office. He came around them once or twice, but he didn't really, he was like the kind of. Yeah, he was like oddball, he didn't really do anything like that. So he reached up and we got his brother on the bottle, so they threw brother left, and then, everything was okay. Speaking to the bottle, case of stress, they called this like, and I feel like because of the kids out in that court, it was just like, the family. He's coming? Yeah, coming? Because I didn't know he was, he was cute. And so I think the family was supposed to be like, but but I got it. I really glad you told someone that their own family hears that. It was really upset. He's crying. I'm a fan. He was very yeah, on the front. Yeah, it was very, like a brother. But he felt like he lost. Right, that's what he said. He was like, I lost my brother and I lost another brother. But I told him this have to come because they are saying now that you are the person that did this. So he came after he testified. I remember he was like all these people in the court going like behind his sisters, cousins, aunt. After the brother walked out, you see like two sisters walk out behind him and then like screeching. And the jury was in there and they're like, and then remember the name was in the door. Yeah, and then when the judge is like, yes. They would call the door while the fight was happening. Instead of bringing it up. Oh my God. Well, they keep them yeah. It was a little scary. Yeah, I was a little bit scared. I think I touched him and drive back to my car. Yeah, it's like, somebody could literally like, well, because like anytime anything, she left and came back, and they like gave the parking lot and she left. So like then it's like you can get back on the list. But I don't know parking lot. Like no matter what kind of case you find. But there's so many. Yeah. Yeah. Right. Well, everybody would be like, that's what I heard. So, yeah. When I first got hired, I was over 5, the person that never went down the hill and walked up the hill. Terrible. 3 weeks after, luckily afterwards, there were people that were like nice, that were like, let me drive your car, and I'm like, you can actually pick me up from my car, as long as it's up the hill of the car, and I go down. Yeah, and it's like, no one ever around at that time. It's just like, me early. Luckily, I have day off, her and Evelyn, and but I probably. Definitely. This is, yeah, our next one is in the second week of June. This will be I have like, okay, well, this is never, I don't know. I mean, I was scared when we had a problem. And then a year, I was like, yeah, over a year. Yeah, never. And then, that is what's gonna be. I don't know, that's not gonna be real fun. You know what we should do this, well, there's somebody that nobody can get. Let us go over. I know. See, everybody, what the problem is when they have, they have certified, there you go, that's like, you stand up and be like, oh, that's not right. They got really bad, huh? My ears are from your ears. Oh, yeah, are you still wearing them? Am I still wearing my ears? Are you still wearing them? I mean, right, of course, everyone says that. Oh, boy. Yes, okay, Michael. It's not, maybe in, Dade County, definitely. Not here. I think it was like a week there in Gadsden County, it was longer and colder. So much here wasn't as much as Dade County. I think it's partially. But yeah, right. It's very hard. It's very hard to hear. You know, you have my point, and then you're like, you can't walk, and you walk, you can't breathe. You start to feel hot, like, I feel like so much more, it's not so fun. Which one? Right. Like, that's majority. I'm a what? I know. I'm not. I wasn't a bitch now. What the? What the? Don't you go in and like? No. Oh, no. Yeah. Yeah. It was a few years that I went out, because I was in Gadsden for a year. I worked with him for a whole while. I learned how to my daughter. She hated on her. I see that came back. What year? Oh, you're great, man. I was old. I don't know. I don't think so. It's our election. Yeah, I was out there. I didn't out there in summer of 21. That's where I was still out there. And so he was still out there. He was with Fort Reporter out there at that
time. Like, the one time he was there, when he was like, off that day, right? It was like 95. He cried me out. He was so really and really smart. Right. And he was great, obviously, and stuff. And then, yeah. I finished school, graduated in December. And then I also January 19. And then I did my whole first year in Gallup. December, I was out there. I was on the farmer side, we didn't have court order in third quarter. Yeah, I did. I was going over there.
God.
I want to say
I know
we
you
hired
did.
in that year, like, maybe like some manufacturer. I remember looking at it in the phone enforcement. I don't know. Like, every time we would go, we'd be like, and days and 47 minutes. I mean, you have a blizzard, so it's, come back with yourself. All the people are watching. It looks like it's funny, though. It's just too big. Not that you're not hot. No, I feel like you're a little aggravated. I feel like they're asthma. I've had you.
I had a lot of them, John.
Right. We get along very well, and I think that helps. I think it's just like we don't. I mean, like obviously we like fight, but I feel like it's like. Like I'm working on this. Right, we're gonna fight. It's not. That's like I feel like you don't get that.
Good job. I would just be like, oh, let me get in my car and go.
Say the least. I was like. No, I watched because it was live stream. I watched because it was live stream. I don't know. It was. I don't know if it's it. They might have paused it because we're on break, but it was. But I don't know if they. It's so good. They're so great. Shit, look right here. I don't know what I'm talking about.
Oh, yeah.
Big Tom. Hey.
Oh, and I think I'm okay.
Oh, I'm the jury one now. They're what, 7:30.
They have dinner, but I'm sitting right here.
Also, we're still.
Tracy?
We're still being live.
Yeah.
I was on her. I do my but it will be my.
We were like. Probably, like, probably our friends. Yeah, yeah. Sorry. Pretty cool. You might have, yeah. It might have been, it might have been. It was like really big. All right, and just you're gonna get it. So it's like,
Yes.
They did it on purpose. The problem. Yes. I feel so bad for you. So sorry. I don't think so. About there, I got you there. Do you remember? Oh, God, you're very close to me. Savannah, close Savannah. I'm sorry. I don't know, some days I have a case with Aaron, and I don't think I have a case with you guys. And I just sent him an email. He responded. No, not you, Aaron. He sent me an email. And I responded, he has not since responded. I think he was running a new house. Yeah, I pretty much just put my hand now. I haven't been trying to get one. Yeah. I don't know anything about it.
Yeah, he was asking about it. He was, apparently he was trying to get hold of me and I wasn't responding, but he had my wrong email address, so like he forwarded me all these. And I was like, sorry if I didn't reply, right? Like, it was literally like months. And I was like, I respond to my email usually within 24 to 48 hours, even if it's just to say like, even if it's just to say like I'm in busy, I will respond. Like I have all my emails categorized as like follow up for offers, discovery, contact. Like I have everything organized so that I don't prioritize. And so like he forwarded me all these emails. He sent me like, whether you're welcome to see it, and I was like, never got those. But then, yeah, I didn't want to be I don't think I have any cases with you guys. I just had my work called the Rachel. I mean, it's fine. I've been called worse. So, we're still fun friends. Is that not normal? Yes. Well, also, we do have a Rachel in our office, so like that's not. I mean, I don't really look like her, but I mean, we're both very pale, but we're all pale right now.
One of the ones since, like last March, so, but luckily.
Yeah, just had, my birthday was last week, and I don't think I had any. I don't really remember that.
Yeah,
Or you would, Aaron was. Well, yeah.
And I pretty much only
I'm glad we don't have to do that. They honestly, like, when we got there in law school, and then obviously, like, MPRE or whatever, I'm like,
Close to that one.
I want to do that, or I don't. Yeah. I'm used to it. I mean, I like it. It's like, it has everything in one place. So it's nice. So we can put notes in there and
you gotta be like, okay, don't write anything else on an email, even like really be careful, I think.
right. Well, we put like for mine, like I put like work product, do not disclose. Like in the notes are like Leo Intel, do not disclose. Like
I'm just saying, like, you know, like Harvard, like, it'll be like something about one thing, next thing you're like, you don't want.
right.
So I think that really needs that.
Oh, but we can't send messages.
So you can't do that.
No, we can send requests, like, but that's usually just so like, I can report to my assistant, like, please send us a email, so it's probably, like, please run this test. My investigation, please go find that.
It's sometimes like, I don't know, like, messaging thing. Yeah, there you go, just have to find something. Wait, add that in there?
Yeah, I know, ours, they don't, yeah. Yeah, but it's nice, like, having everything in one place, and like, we're paperless. Love paper model. Right, like, but that's why I say paperless.
That's not what we do. I can put it all,
Right.
And it's so long.
Right.
Okay.
I think like pre-COVID, I still would bring copies to the judge, but like now, it's like we're not really supposed to like hand stuff to each other. Like that's why we're not allowed to, that's why we have that. We're not allowed to hand stuff to the jury. So,
Yeah, we do the insurance credit. And, do it. Then I make sure it's you. Like, I'm already making it. Right. Well, I don't that.
I feel like that's I mean, as long as I'm like looking it up himself or like emailing it to him, like I either email like when counsel, like I either email them the site or like in a written motion or memo, like or like a case law attached, just to like. I feel like looking at the book, but rather than a code book, but most of the time it looks public. He's great. I don't know. I can buy problems.
Yesterday when we were on the hallway, and, you know, I almost said I'm just, I'm like, I don't you. I was like, well, you didn't know, I didn't know. Because you're that Lorena, the prosecutor, and I was the only one in the mine who were like, our, and, Mr. Pumphrey, you do something. It's not all that, you know, direct, Lorena, especially that she don't want to, right. Right. And then, you know, I was that, and yeah, it's her.
I never, he like, he retired, I came over to Leon in January 2019. But then we all went home for COVID in March, so I was only here for 3 months. And I was in March, so. And then October I got home, so February, working for COVID. No. No. I'm young, like, wow. I don't. Well, they have to eat dinner, so it's. When? No, they brought them dinner. The judge, when he comes back, he goes, oh, we have your dinner ready. I don't know if they like brought it and then they didn't do it, and I don't know, and hopefully it was. I mean, but yeah, so you gotta do the horror person. Do that. Go to the bathroom, eat.
We're real at it, okay? That's why we. I'm gonna go upstairs.
I guess.
I want to get my other off my camera.
Okay. Ugh, grab your cart.
You're doing like a whole bunch of things.
Yeah, I know. I have not.
One problem, I'm exhausted, I can't imagine.
7:30.
Are you guys leaving?
Yeah.
There's always some secret lounge.
Sign or, we'll be around. Tom, you think, yeah, you feel good?
Yeah, I got something.
Don, be cool.
We'll see you, Don.
He was on video.
Just, that's. Just like old cars, a lot of. That's what I can do. Like that minute. And shout out to you. Appreciate it. Look at that, sleep up here. So fun. Notice.
Here's your mic for that.
No, you did. Research this. If I work, you can go right down the street. I wish we had worked with it.
It's been a long day.
You know, it's good,
Three, 4, 2, 8, 5, 6, 2, 4. My hands
you
are
should
like
have,
that.
you should have on.
Yeah, I've had yours for years. I mean, I had to really go through my phone numbers because it's been so long. I had to work. Calling and hurry. Is it covered?
Oh, it's kind of a nice.
No, we didn't have any trials for so long. I mean,
Well, that's right, because you're the prophet.
I've been doing class for about a month and a half now, but, not many, so it's not like, back in spring, everything.
Yeah, and then that's what we said, knocking the dust off and the cobwebs and just getting our bags together and food. Directly.
Oh, well, I'm happy about it, I'm happy with that too.
Yeah. Everybody's
A
ready.
little bit of normal.
A little bit.
And I tell you what, there's a lot of stress with vaccine.
Although I will say right now, we're having felony jury selections on Monday, and Tuesday, with one judge picks on Monday. So we don't have like over.
I'm going to do the last one.
One a week, each one.
Are people showing?
Yeah, they are, surprisingly they are. It was slow at first. I think they called it 150 the first time, got something like that. So,
This morning, all the
Spirit.
years I have never.
I was called to jury selection. When I lived down south, I had never been called to jury selection, and I got picked for a statewide grand jury here. Wow. And I had to come to once a month, 3 days, for 18 months.
Oh, it's terrible when I don't have to do that. Work, awful. You can get off of it.
Well, it's probably with errors.
It was interesting.
I like that. Not be good.
Yeah. No, I drove, they would push on a plane with the little planes that they had coming from here, and up here, I couldn't just on them, so, yeah.
Well, anyway. Well, I'm
Go with it.
you want to take part? I'll try to do that. Yeah, I got it.
I'm still gonna go though. I need a lot of things that
Yeah.
We're gonna go drop our stuff off.
When I first was posted, you know, back up.
Okay.
Are we gonna be able to get in and out of the building?
Oh.
we're not.
Well, before you guys
Go
leave.
back. Okay.
Tracy.
They got in and out of the back.
In the back. Calvin. Now, let me just check real quick, they're just out in the hallway by the jury door.
Okay.
I'm literally going there. Yeah. Are you related to the?
Who? The Pumphrey? Well, if they're Pumphrey, they're related to me, but I don't.
You don't.
That's it's not unusual, man.
Yeah.
Everybody's Pumphrey.
Yes, there will be someone at Kaufman Street.
Okay, good.
Thank
Great,
you.
thank you.
Hey. What's up? I'm okay. You're fine.
Thank you for. Oh. Oh, there you go. That's what get me. A bowl of ice cream before bed. I think it's like a bowl of cereal. Or cereal. If there's nothing much usually, that's what you go to. Yeah, the milk. The milk's ice cream.
Somebody, oh yeah, there's that. Yeah. She has to be kind of near her side. No. Yeah. Oh. Really like now. I'm just giving them my life. I just put my son on. You got that too. You know, like, I can spell right now. You know that. Oh. That. Just disappeared. He fell into the ocean. I'm telling you, Mom, she's gone. And they wanted her home. So, your daughter's like my age. Oh, well, I'm okay. She's a little younger. Right. Okay, yeah, mine. I didn't do it. So my daughter, she told me, you know what, you got school, and it's my school route. There's just like cars everywhere for driving, like five, about. Right. I don't really, you know, just let them tell us. We might have to know that. The one door, one that. Yeah, that's what my kids are doing. Really? And we're right here, so. And my dad, do that. So we kind of are, you know, yeah. Oh. Yeah, we went there in 1995. Heavy in emergency. Even if it is, it doesn't matter. Still going. I'm really good at ignoring things, like figure it out. But I'm really good at just, you know, learn. So we probably have to take medicine or something. That's what it is. Oh my God. I thought, oh my God, this could be an emergency. I'm really good. Why did that out? Yeah. Best thing ever. I need one of that. I got it at Walgreens. It really helped out under my vest. Oh. I can't get anything under a vest. No. I'm sure it gets scratchy like the thing. Yeah. And it would cheap. And then it's. I can't think of it. There's only one. She's like that. What?
know what, after, you know, now she's gonna end up in a food, kidney problems. Can't even see a word. So that's what she does. She will, you know, doesn't make sense. She will. Right, right. I mean, the. I don't know. She would go, and when she'd go, I'm working on the hospitals in Arizona. And it was springtime, and early summer, she'd go to the Northeast, and the rest of the time she'd go to. And she went, it and she wanted to they can go, they decided to go. We just wanted to see Wyoming. see what they got available, and if they hire you, you can go and see it, X number of months. And as I said, they keep your housing, they do, fee, they do pay too. So, really, right. And that's what they choose to do. And I don't want to do that, and I can go, you know, you can try to see that. They all have people who have dedications.
I
They have to pay. You're not necessarily.
I see. They're moving you all.
They're short on the access. Because they just, people are on vacation. Or usually every week, next week, you get a whole into.
I told Elizabeth about that. Yeah, people are ready for it.
Oh, yes, it is. So it's just one of those things where I think she wants to do. And some people don't like to do it. And once they go, they can do what they're saying.
Because her kids are on this track.
She's got, the older son now, I'm not sure what she's gonna have to do with him.
What about her husband? He's still having.
He's gonna
It's going down.
And then she
Get through her some good first.
one day she'll, you never know. None of us know. Nurse. She wanted to be, nurse. She didn't want to.
That's what Elizabeth wants to do.
Well, she wanted to be in the hospital, she was studying and everything. She wanted to do everything together. So you can't.
You never know what
When you walk in there, which one is my sister. First time they came her, and she they delivered it to the lady, she had to move it from to the incubator. But she was in the military. She was surgical. She didn't do it. With this mother and to do it with the baby. She had to do it with the she was under the bed. Under the bed, she delivered the baby. And as soon as they can run, the baby, she's good. She took the baby away. Yeah, I will never see that. So much. She's.
Yes. There was one thing that I knew that I knew. Right. And that's not emergency. She mentioned this. Oh, good. I'm checking in. Sitting there. The lady is walking now, really was really fast. She turned around, she said, that's my wallet, let's go. Go. So it's this thing. Yeah, she's really. Yes. I mean, we all like that. This one was running for her normal. She doesn't help with it. I'm sure there's always more to the art. Yeah. You're not losing your art. There's nothing in that hard. And he was really, and we jumped up and says, come on. You need me to call one? Does that scare you? Okay, bye. Oops.
on for a while. Thank you. I understand. No, it's not. I'm there to vote when isn't that stupid? I've been keeping up why. I know that, yes. Pretty nice. You want water?
What?
Are you gonna go for some water?
No.
Is it my whispering?
I was like, hello.
Yeah, but telling you what my number is.
No. I actually have your number in my phone. I think from Greg Williams.
Very good.
Yeah.
Very good.
I'm gonna die. Shaking. Less than 2 hours. Cool. Hi, Mike. I love you. Just bring this up. Yeah. What?
It would be looked up for her, but no one's gonna do it. Don't stand there. No one's gonna stand there. Okay. So, put my tie back on or anything, I guess it doesn't really matter at this point. Don't let me forget it. Okay.
A typo. Party.
I know.
Yeah. Yeah, you still got that.
Where's Pumphrey?
Mm-hmm. I miss him.
Three problems in there.
Mm-hmm.
Who's judge for?
All right, quick back in session.
Pumphrey and his wife on their way back.
Should he go to the standard jury instruction? No, I'm going on. I think it might be in the. Nope, not that one. It's. And then. Sorry.
Right, we're back on the record. I've been informed we have a verdict from the jury. Is there anything the parties wish to go over before the verdict is published?
No, Your Honor.
No, sir.
Bring in the jury.
Judge, do you mind if we remain seated with our client?
Yes, that's fine.
Our client can't, so let's see, we stay with. So let's see. Repeat.
Jury entering the courtroom.
You may be seated. If the foreperson of the jury could please rise. Has the jury reached a unanimous verdict? If you please could hand the verdict form to the bailiff. I have reviewed the verdict form and it is in its proper order. If the clerk could please publish the verdict.
We, the jury, find as follows on the information of felony battery, grave bodily harm. The defendant is guilty of the lesser included offense of battery. They say we on the 18th day of May 2021 is signed by the foreperson.
Would either party like the jury to be polled?
No, sir.
There you are.
Members of the jury, I thank you for your service over these past 2 days. The right to have a jury trial is protected by our Constitution, and ultimately, we cannot do our jobs even during this trying time of COVID without you. Thank you for your service. You are discharged. If you please could hand the bailiff the exhibits and also the instructions. With the jury's finding of guilty, Mr. Pumphrey, are you wishing to proceed through the bifurcated proceeding this evening or to set it for a separate day?
Judge, I think Mr. Balbone's here. I think that we could go ahead and do the proceeding now. If the court could explain to Mr. Morris what we're doing, and I'll let him make the ultimate choice. If he wants to come back, I will. I haven't discussed sentencing or anything else. I typically don't do that until we get a verdict.
Right. Mr. Morris, so you understand, the jury has found you guilty of the lesser included offense of battery. With the change to the state's charging document, they are seeking to essentially seeking to turn that into a felony battery based on your prior. Would you like for the proceeding to continue, or would you like to have additional time to speak with your lawyer before moving forward? You wish to proceed this evening? Right, then we will proceed forward. If the clerk could please hand me the amended information. Does the state have a certified copy of the prior?
Yes, sir, I do.
Right, if you please show a copy of that to Mr. Pumphrey. Mr. Balboni, you also can come up as well.
Your copy, and then this is the certified.
Balboni, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do, sir.
You can be seated. Mr. James, you may proceed when you are ready.
Thank you, Judge. Just let me know when you're ready, Mr. Balboni, when you've got your stuff. Okay. Good evening. Can you please introduce yourself to the judge and the court reporter?
My name is Thomas Balboni, spelled B-A-L-B-O-N-I.
Right, and where do you work?
I'm employed in the Criminal Investigations Unit for the Office of the State Attorney in and for the Second Judicial Circuit.
And how long have you been in that position?
22 years.
Okay. And what are some of your duties or responsibilities?
I provide investigative support to the assistant state attorneys in a variety of ways and help them in preparation for their trials. However, in this particular case, it was as a fingerprints examiner.
Right, and what education or training do you have that qualifies you to examine fingerprints?
I've actually been involved in the science of fingerprints prior to my tenure with the state attorney's office. I previously served with the Tallahassee Police Department's Crime Scene Identification Unit, where our primary responsibility was the detection, collection, preservation, analyzation of fingerprint evidence, both at the crime scenes and the laboratory setting. I attended the training courses presented by the FBI in the science of fingerprints, numerous other basic and advanced training courses by the Florida Department of Law Enforcement, the Crime Scene Institute of Florida, the International Association for Identification, of which I'm an associate member under the discipline of forensic fingerprints examiners.
Do you conduct fingerprint comparisons on a routine basis?
Excuse me?
Do you conduct fingerprint comparisons on a routine basis?
Just about daily.
Okay. Have you ever been qualified as an expert in Florida for fingerprint identification?
Yes.
And how many times?
Prior to today, I think it was 336 times.
At this time, Judge of State would tender the witness.
Judge, for the record, as long as Mr. Morris doesn't have any objection, I've known Mr. Balboni. I think most of the time I've been back in Tallahassee, which is 21 years. I've interacted with him. I have no concern about his qualifications in fingerprint identification, and so I have no voir dire at this time.
Then I will find the witness is qualified to render an opinion as to fingerprint identification. You may proceed.
Thank you, Judge. Mr. Balboni, are you familiar with the defendant, Chase Morris, in this case?
Briefly, yes.
How are you familiar with him?
Last week, I met him for the first time in a different part of this courthouse for the purpose of obtaining the ink fingerprint impressions of him.
And how do you get fingerprints from somebody? What do you have to do?
Well, I had previously obtained the certified documents of prior offenses and did it's a rudimentary, but a side-by-side examination, a comparison under magnification, inappropriate lighting, for the purpose of determining whether the fingerprint impressions on more than one document were made by the same individual. The fingerprints I obtained from him were to be used as the standard for comparison.
Okay. And you said you looked at a prior document. I think you said, what prior document did you look at?
Well, it was a judgment and sentence in a 2015 court case here in Leon County.
Okay. Is the person that you took fingerprints from when you just described it to us? Is he in the courtroom today?
Gentleman, bald gentleman, with a blue mask, sitting to the left of Mr. Pumphrey and his wife.
Okay. Is he wearing a pink shirt?
I can see it now, yes.
Okay. Let the record reflect that the witness has identified the defendant.
The record will reflect.
May I approach the witness, Judge?
You may.
Let the record reflect, I've just handed the witness what has been pre-marked as states. I guess it'd be 1 and 2 now. Mr. Balboni, do you recognize what I just handed you?
I do.
Okay, and what are those?
This is a standard applicant fingerprint card. It's a pre-printed card stock document. It's used specifically for recording the ink fingerprint impressions of an individual whose identity is known. It bears my personal notation all over the card, the date that we took these, my signature, my printed name, my identification number, the location of this, the time of day, the demographic information of the defendant, as well as notation indicating that this is the specific document I used for an examination in comparison to another document, which is documented on this document.
Okay, and for the record, he is referring to State's Exhibit 1. Does that document appear to be in the same or substantially same condition that it was in when you got fingerprints on it?
Yes, and I wrote on this in blue ink for the purpose of being able to identify it as the original as opposed to a Xerox copy of the document.
Does it appear that I've altered it or changed it in any way before handing that to you?
No.
Okay. At this time, State would enter into evidence State's Exhibit 1.
Any objection as to State's 1?
Just gonna see, State's 1 or that.
Oh, I'm sorry, it's the fingerprint. I was gonna see that. That's the too.
Right, I just want to make sure I'm looking at the same thing in the course of the proceeding. See that.
I don't know, just the other day, last week about this one.
Yep, that's right. I think I saw you, yeah. Yep. Judge, I've reviewed the fingerprints and I'd actually forgotten, I was talking to Mr. Balboni when he fingerprinted him, I believe, but it's late, but I found no issues with the fingerprint identification, and I've also got a copy of the original plea, judgment, and sentence. So for the judgment and sentence with the fingerprints.
State's 1 is admitted at this time.
Okay, Mr. Albany, if I could direct your attention to what's been pre-marked as State's Exhibit 2, what is that?
This is a certified copy that I obtained from the Leon County Clerk of the Court bearing the name Chase A. Morris. It depicts actually an adjudication withheld of the charge of felony battery with great bodily harm. This court proceeding this adjudication was handed down in 14 July of 2016.
And what is the case number for that prior?
2015 CF 2057.
Okay. Does that document appear to be in the same or substantially same condition that it was in when you obtained it?
Yes, and again, on the lower left-hand portion of the page 2, the fingerprint page bears my personal notation in blue ink indicating this was the actual document I examined.
And also, is that the original certified or the certified copy of the judgment and sentence for that case?
It is a certified copy of it, yes.
And has that been altered or changed in any way since you last saw it?
It doesn't appear to be now.
This time, State would enter into evidence State's Exhibit 2.
Any objection to State's Exhibit 2, Mr. Pumphrey? Mr. Pumphrey, State's Exhibit 2, the judgment and sentence, any objection to its admission?
No, Judge.
State's 2 will be admitted at this time.
Mr. Balboni, what did you do once you had the prior judgment and sentence and then the fingerprints that you collected from this defendant?
Like I say, I conducted a side-by-side comparison in my office under magnification with appropriate lighting. I then had as per protocol, had an independent fingerprint examiner conduct a similar comparison for the purpose of verifying my original finding that the fingerprints on both of these documents were made by the same individual.
And who is that same individual?
It was Pat Lyons from the Leon County Sheriff's Office.
Were you able to confirm that the fingerprints on the judgment and sentence match the fingerprints that you collected from Mr. Chase Morris?
That was my determination. Yes, they were in fact made by the same individual.
I don't have any further questions.
Cross-examine.
No cross-examination, Judge.
All right, Mr. Balboni, you may step down.
Judge, let the record reflect that Mr. Morris is seated at council table, and I've been talking to him proceedings and what's going on.
Say that one more.
Being heard. I've been talking to him to explain what's going on because he's asking me what's the process and everything else. I explained to him this is a bifurcated process, so the jury never knows that he had a prior record as that would influence their verdict. And so that process is taking place. I asked the state to run a preliminary score sheet. My recommendation was for him to go back and we set off sentencing, give him a chance for he and I to speak further. And we talk to his family and see what they want to do. And then I can talk to the state and verify the score sheet.
That's fine. Does the state have any other witnesses or evidence to present?
No, sir.
Based on the testimony and findings of Mr. Balboni, I am going to find that the prior conviction under case number 2015 CF 2057 has been demonstrated for the purposes of meeting the enhancement of the battery conviction that the jury has found by the result of the jury trial. And on that basis, I am going to find that a felony battery did occur pursuant to Florida Statute 784.03 subsection 2. We will set sentencing in 2 weeks. Jeannie, do you have dates up for me?
I do. The first,
Well, Mr. Pumphrey, are you looking for more than 2 weeks or would you be asking for 3?
Judge, if we could set it in 2 weeks and give me an opportunity to speak to him, and if we need to, we can file a motion and get with the state.
That's fine.
I have a trial next week and just want to make sure our logistics and everything, but we should go ahead and get it on the calendar.
Is there any legal entitlement to a PSI?
Judge, I want to go back and just do some research. It's late in the evening. I want to talk to him about a PSI, but I haven't researched that issue yet. As far as
Judge, I don't believe there is a legal entitlement to it because of the prior felony, so.
right, I think the state's correct, but I haven't researched that in a long time.
I'll allow Mr. Pumphrey to look into it just in case there's something he can find. What would be? That's fine. We'll give it June 8th as a control date, and you can check with my JA to get a sooner date for the sentencing. The defendant will be remanded pending sentencing. Mr. Morris, you certainly can remain in contact with your attorney concerning what your options are moving forward.
Judge,
the date would be 2:30 in the afternoon as the control, but again, that's just a control date, not the actual sentencing.
Judge, if the state has no objection, if I could get another order so I can go out and sit down with him and go over everything and make sure he understands it. And if the state has no objection, I'll have that submitted tomorrow.
Mr. James?
I have no objection to that, Judge.
All right, please submit that. We are in recess. Have a good evening, everyone.
Thank you, Judge. Yeah, that's for you.
Did Judge already? Judge Jennifer?
Yes, sir.
Yes.